Okay, everyone, we're going to get started if you can take your seats. For those of you who don't know me, my name is Alexandra Givens. I'm the Executive Director of Georgetown's Institute for Technology, Law, and Policy. We're thrilled to have you all here today for a great program. This is our 11th year co-hosting this conference with Berkeley. And it is such a pleasure to put it together every year to reflect on the major happenings of the past year, to think who are the best people to come and share their insights about what's happening and how can we talk about the year ahead. And this year and this moment is certainly not failing to deliver. There's a lot to talk about today, and we're excited to have that conversation with all of you. I want to pause for a moment just to say what a pleasure it is to work with the team from Berkeley Law. Peter, you, Jim Dempsey, and others on your team are so wonderful as we do this coordination. And also pause just to thank our sponsors who make this event possible. It is something to be said when sponsors give you financial support to make an event happen, but then give you full editorial control over the content. That is something that we really value, and it allows us to have a full and wholesome debate, which you'll see on this stage today. Our sponsors this year are Intel, Google, Verizon, and Samsung, and we're very grateful to them for their support. I'm going to pass the microphone over to Professor Jay Thomas, who is on our faculty here teaching patent law. He'll give a couple more words of welcome, and then we'll start with our first panel. Thank you.
Thank you, Alex, and good morning, everyone. Now, you know that today we have come to Capitol Hill at a moment of extraordinary importance for the nation. We have in front of us an impassioned debate on matters of exceptional significance. Who can say where the proceedings will take us? And of course, I'm talking about this patent conference. As compared to other events, we don't have Marie Jovanovic, it's true, but we have an extraordinary array of exceptional guests and speakers here. You know, I tried that joke last night, but I got cut off. So I'm sorry for those of you who had to hear it twice. Anyway, we have so many extraordinary guests, I don't want to go through the long list. I do find myself in a moment of reflection, because you reach a point in life where your physician is younger than you are. You reach a point in life where you have a child that's the same age as the law students you're teaching, right? You used to be sort of akin to them, right? And now something has happened. And you reach the point where you have former students you have to start calling judge. And we have Judge Clark Cheney here in the front row. Again, I just want to call him out as a 2002 graduate. Who has achieved an aspiration you told me about a long time ago to become a judge of the ITC. I know it's been a winding road at times, and we're just so grateful to have you here as a speaker. Welcome home. We've enjoyed following your career as it's progressed, and I hope you'll be a part of this conference in years to come. So I have to say, though, it gives me a little pause that I'm old enough to have 3 students who I have to call judge now, including the PTAB. But at any event, thank you so much to each of you for making time to come and join our 11th conference. We couldn't do it without our dear friends at Berkeley, who just really bring so much life. And we certainly couldn't do it without our sponsors. We're very grateful for your contributions to the life of the school and for contributing to the patent community. I'm grateful to see sort of new people coming up. I have a slightly more somber task in front of me, which is to acknowledge the passing of Don Dunner. Don Dunner, of course, was a doyen of the patent bar. He was a 1958 graduate of this law school, and he passed away recently at the age of 88. I remember when I went to law school, clerked at the Federal Circuit, got off the court, and I'd been working at the firm for about 3 weeks, and someone fell ill. And so Don said, hey, do you want to write I got an appellate brief to write, and it's due on Tuesday. So we went to Don's house on the Eastern Shore, just bunkered down, and spent today it seems like very quaint technology, just banging out a brief. And I really got to know Don and learn a lot about appellate lawyering from him and that intense experience. And I had the pleasure of working him for about a year. I remember with the Johnson, remember the Johnson & Johnson case? That's the public dedication disclosure disclaimer doctrine. I see a few of my students out there. There's an exam coming in about a month. You better remember that one. You better know that case, I'm telling you. Yeah, there you go. And as you'll recall, there was a circuit split between YBM Magnex and Maxwell v. J. Baker, and the court was trying to resolve that split. I was like, well, wait, didn't Don argue one of those cases? Then I looked up the other case. He argued that one too. I was like, this is crazy. How did you pull that off? Anyway, Don lived a full life in the law, and he was a good friend of Georgetown. He came about 3 years in a row to our alumni reunion weekend, but he didn't come for the 4th. And I was like, Don, where were you? It's like, don't schedule the reunion weekend before Federal Circuit Court Week, because I'm probably not going to be able to make it. So he was a good friend to Georgetown. He was a good friend to our friends in Foggy Bottom down the street at GW, teaching a class there for many years. And I'm glad to say that his legacy will live on in the lives of many people he's touched. Thinking about Clark, thinking about Don, Judge Cheney. Used to be, reminds us that law schools are really only as strong as the community around them. And, we're very grateful to have our sponsors and our graduates and so many friends of the school. We're really grateful to see you here today, and we look forward to having you interact with us today. Thank you again for coming. And with that, I'd like to turn it over to our opening panel, moderated by Professor Manel. Thank you.
Well, good morning, everyone. It's a pleasure to be back here at Georgetown. We lost our screen, though. Oh, there it is. This is our traditional opening panel. The goal in doing a panel like this is to bring judges from around the country, and we have leading judges from the leading districts addressing patent cases, for them to share their views inside the Beltway about how the patent system is functioning. And the patent system, as we all know, has been somewhat tumultuous. We've lived through true revolutions in the creation of new institutions like the PTAB, with a lot of controversy over important doctrines relating to eligibility, relating to damages. And this is an opportunity to see from the standpoint of that trench, that very important trench in which lawyers are battling this out. It's not focused so much on the legislative angle, but on how the system is functioning for the people who have to administer it. In many ways, the judges are the front line. They are seeing the issues, and unlike legislators, they have to resolve the issues. They don't have the option of pushing things off deep into the future. And we have the most experienced judges who handle these cases with us today. Our system is a general system. We don't have, like many countries, specialized trial courts. But in the patent field, District of Delaware and the Eastern District of Texas are among the courts that handle a very high percentage of these cases. And we have with us today Chief Judge Rodney Gilstrap, who has had the heaviest docket for most of the last decade. We're going to hear from Steve Chang from RPX, and he'll give us some statistics on that. He's no longer at the very top, but he's still very close. And I'm sure the residue of being at the top is still in his court. We have also Judge Mary Ellen Noriega. She was a patent litigator prior to joining the District of Delaware. And so she's seen these issues from multiple dimensions, and now she is handling cases. She's had quite a few, even in this relatively short time that she's been on the district court, and she spends a lot of time with her colleagues who are dealing with another of the real barrages of patent cases, especially since TC Heartland. We also have our good friend, Judge Kathy Ann Benchavengo from the Southern District of California. Judge Benchavengo was herself a patent and intellectual property lawyer before joining as a magistrate judge and later a district judge. And so she's really seen so much, and I always invite her to events that I do because she has a great judicial approach. She will break down the issues at a very practical level and usually add a little humor in explaining what's going on. And so I think we're really fortunate to have this group. And what we're really going to try to do is just have a discussion. We're not going to try to teach the law so much as to say, here are the issues that are most prominent, and here are the areas where the law is less clear. And to help me in bringing those issues to the surface is John Damaris. John is truly one of the giants of the patent bar. He has had a storied career. Many of the leading cases are ones that he was involved with directly. I don't know why he keeps doing it, just because he's obviously had tremendous success, but he loves it. And he's even opening offices out on the West Coast. So I know it's a very active practice for him. And it's a real honor to have him with us today because he is able to cross so many different lines in the patent area. He's worked on cases for plaintiffs, for defendants. He's had quite an amazing array. And whenever I see him, he's always so persuasive. So apparently you can do any side of these cases and have success. What I want to do to really open this morning is to give you a statistical picture. Well, I shouldn't say, to ask Steve Chang from RPS to give you a statistical picture of what's going on. And we've added this to the program over the last several years. And I think it really does help to see how the system is evolving. And RPX is in a unique place for being able to follow these issues. So we're going to be focusing our discussion on venue, parallel proceedings, and stays, patentable subject matter, damages, and hopefully enhanced damages if we have time. And I'm just going to ask Steve to kind of set us up for that. He'll do a quick overview of all of those questions.
Sure.
Do you need the clicker?
Yeah, sure. Thank you.
And do you have the same slides? Oh, am I going to sort of
Yeah, I think I could.
Okay, we can do it that way.
Right. Okay. So thank you everybody for being here, and thanks Peter for the introduction. And so we'll just go ahead and walk through some highlights, looking at trends from a macro level and in district court filings, remedies, and patent eligibility, and then we'll move on to some high-level statistics regarding parallel proceedings, both at the ITC and PTAB, in particular how they track district court filings. And then we'll show some interesting findings on Federal Circuit appeals as well. So with that, so one of the ways that we like to track district court volume is by looking at the number of unique defendants that are added to cases rather than tracking unique cases themselves. And did I press something wrong?
Might have put this center.
Okay. And one of the interesting things, as most people in the audience probably know, outcomes of TC Heartland was a shift from the most popular venue of Eastern District of Texas down to over to the District of Delaware. This trend, if we look at cases just in 2018 by number of defendants, this trend largely continued through the end of 2018. So TC Heartland was May of 2017. And the Eastern District of Texas did remain the second most popular district for litigation overall. But when we further break down the look at which districts are the top 5 when we divide by cases brought by NPEs and cases brought by operating companies, we see that Eastern District of Texas does remain a fairly popular venue for NPEs, but for operating companies, it drops to 5th place. And in operating company litigation, Northern District of Illinois and District of New Jersey enter the top 5. This data does include biotech and pharmaceutical cases. Including those would bump up District of New Jersey fairly significantly. So TC Heartland also caused a spike in the percentage of new litigation seen in other districts that historically have not been favored venues for patent cases. Districts that saw such an increase included certain other districts in Texas with Western and Northern districts, each seeing a pretty significant jump in the defendants added, 138% in Western District and 93% in Northern District. District of Colorado, interestingly, also sees a fairly significant jump in the number of MPE cases, though a fairly significant drop in the number of overall litigations, but that is a smaller data set, of course. But here you can see a draw out of all patent litigation cases and how these individual districts fared, comparing the year and a half before TC Heartland to the year and a half after TC Heartland. And that percentage change, as reflected in MPE cases, is you see some of the dominant districts, including District of Delaware, District of New Jersey, getting pretty significant gains as well. So TC Heartland also created a fair amount of uncertainty as to venue for foreign corporations in U.S. district courts. So we took a look at the nationality of defendants added specifically into Eastern District of Texas before and after TC Heartland. The alien venue rule is a pretty long-standing principle under which foreign defendants fall outside of all of the federal venue laws under Section 1400B. This effectively allows any foreign defendants to be sued in any district. It's last affirmed in Brunette, so it's going on 47 years. And despite various parties challenging that, most notably, I think back in May, the Supreme Court denied cert of a Federal Circuit's issue of mandamus in re HTC. Basically, Brunette stands. And so when we look at how the pre and post Heartland effect took place in Eastern District of Texas, just with respect to non-U.S. parent companies versus U.S. parent companies, you can see a certain growth in the number of cases brought against non-U.S. parent companies. And this is affected, again, likely affected by TC Heartland. So moving on to district court remedies, if we look at the top 3 district courts by number of defendants and look at specifically, let's start with injunctions and then we'll move to jury verdicts and damages. But here we see that the injunction grant rate nationally is roughly around 60%. In Eastern District of Texas, the injunction grant rate is fairly high, significantly higher than the national average, and almost effectively an invert of at the District of Delaware. And these are for all orders that were filed between 2013 and 2018. When we just as a point of comparison, because I know a lot of people, have been finding that patent litigation in China is a hot topic. We looked at more specifically patent cases in China that have reached final judgment. And what we see is that not only are injunctions requested at a much higher rate, they're granted at a fairly significant clip as well. Much higher than the U.S. national average. There is some selection bias into China data, and part of that is because we can only access information on final judgments in China. So the selection bias goes toward those cases that have not settled. Now, with respect to injunction timing, we see that when we break down U.S. injunctions by preliminary and permanent injunctions, of course, preliminary injunctions are granted much more quickly than permanent injunctions. But interestingly, when you look at the timing of grants of preliminary injunctions versus denials of preliminary injunctions, grants are much faster, whereas you don't see that kind of dichotomy in timing when it comes to permanent injunction grant and denial rates. One of the ways we broke down injunctions was also by looking at various market sectors to see if there's any kind of distinction between cases brought against different market sectors. RPX has a team that basically goes through every case and defines, kind of labels the case as belonging to a particular market sector based on the accused instrumentalities, based on who's in suit. So based on that labeling, we see the market sectors, in particular consumer electronics and PCs, which includes smartphones and tablets, has one of the highest injunction grant rates, but is also generally a smaller data set. Notably in the networking sector, the injunction grant rate is much lower than any of the other sectors. So let's move from injunctions to jury damages. And when we look at jury damage awards, the first thing to note is that as many of you probably expect, there have been relatively few. So 316 cases in the period from 2013 to 2018 had jury damage awards. And when we look at the percentiles of those, there's not too much of a variation between cases brought by MPEs when compared to cases brought by operating companies, either in the lower quartile or the upper quartile or the median of comparing 1.5 million to 1.8 million. When we look at jury verdicts by district, again, looking at the top 3 districts where cases are brought, interestingly, the Eastern District of Texas actually has a lower rate of jury verdicts in favor of the plaintiff than the national average, as well as in the District of Delaware and Northern District of California. Moving on to summary judgments. Summary judgment motions, when we look at Eastern District of Texas, again, it's actually much higher than the national average. District of Delaware and Northern District of California roughly track the rate of grant of summary judgment motions as the national average. And then taking a quick look at just the timing of summary judgment motions together with their outcomes, you can see that Eastern District of Texas and District of Delaware grant at roughly an approximate pace. The Northern District of California does take a bit longer to get to a summary judgment motion outcome from the case start, and that's a bit longer than the national average as well. So let's move on to patent eligibility. Everybody, I assume, is aware of Berkheimer and Atrix, and what we did was to look at all of the cases filed from Alice, from the issuance of Alice to Berkheimer, to look at the patent invalidation rate in district courts. And this is all district courts combined. And interestingly, when you look at pre-Berkheimer, this is from Alice to Berkheimer, patents were upheld under Alice less than a third of the time. After Berkheimer, and this trend is continuing to increase, the rate of finding patents not invalid under Alice is actually increasing. So generally speaking, plaintiffs will have a better than 50% chance of getting their patents upheld post-Berkheimer. When we break it down by the procedural route or the stage, we actually see that summary judgments, interestingly, post-Berkheimer have the highest rate of upholding, of course, the smallest data set. Whereas the Rule 12 largely tracks the percentages from overall. Further breaking down the all of the post-Alice, including pre and post-Berkheimer, upholding rates for MPEs and operating companies, we see that MPEs do get their patents upheld at a lower rate in general than operating companies. And then if we break down further by different districts, we can see that upholding rates near 50% in the Eastern District of Texas and in the Central District of California, whereas the District of Delaware and Northern District of California more closely track the national average. And if we further break down the upholdance rate under Section 101 by the district and the procedural route, we see that the District of Delaware and the Northern District of California invalidate at a fairly high clip under Rule 12 with not much variation on summary judgment. And the Eastern District of Texas largely tracks the national average as well there. So moving on to the ITC and PTAB. A lot of folks should be fairly familiar with recent statistics regarding the filing rates at the PTAB. The PTAB filings have been down in 2019. When we break that down by quarter, and I don't have it here, but by month, basically we're averaging about anywhere between 100 to 110 filings per month at the PTAB, whereas pre-2019 filing rates were generally between 130 to 140. A lot of folks have a lot of theories as to why that is, but certainly a lot of the new discretion awarded to PTAB panel, given to PTAB panels for discretionary denials may be affecting that, as well as a lot of the new rules under the trial practice guide. And when we overlay district ITC investigation, number of newly filed ITC investigations over the number of district court filings, we do see that there was a spike back in 2017 or a local spike back in 2017 for ITC filings when a lot of parties were going to the ITC from district courts. But overall, filing rates at both the ITC and the district courts have dropped. So finally, the Federal Circuit. Federal Circuit appeals largely originate from the PTAB. The PTAB dominates the source of all Federal Circuit appeals and has been doing so since 2018. The trend seems to have largely steadied out. I don't include it here, but the quarter by quarter look also appears to have a roughly steady state around 53%. When we scale up all of those bars, just to give you a better visual look at how big the bars are in comparison to each other, you see that there's a lot more of the PTAB that constitutes the dominating origin of Federal Circuit appeals. And when we look at irrespective of, or I'm sorry, from district court, the appeals to the Federal Circuit are primarily MPE originating as well. So more than 50% ever since around 2015. And when we look at appeals broken down, again, by market sector, we see that bio and pharma appeals, together with consumer products and e-commerce and software cases, dominate the Federal Circuit appeals, whereas there's a lot less variation among basically all other market sectors. And when we look at which events in district court are being appealed, we see not unexpectedly that summary judgment is the dominating event. Dismissals under Rule 12b-6 and 12c, or judgment on the pleadings on 12c, a lot of these are dominated by Alice, and you can see that they're comprise a fairly significant amount of the number of procedural appeals. And looking at how the Federal Circuit rules in the various appeals, the Federal Circuit affirms on over half of all appeals, and they reverse and remand, and on about a quarter, and then another quarter settles out. Federal Circuit appeals do tend to settle fairly quickly, with the median at about 138 days, and most cases, by far most cases, settling within about less than a year. The districts, the various districts are fairly consistent in their appeal outcomes. When we look at the affirmance rates, there's actually not there's not a significant variation here. And when we look at the top issues that are appealed, the infringement and claim construction, of course, are dominate, but interestingly, invalidity under Section 101 on its own nearly matches invalidity under 102, 103, and 112. And as we can see in the next slide, invalidity on Section 101 is affirmed more often than appeals under 102, 103, and 112. All right, that's it.
Thank you, Steve. That's a great snapshot, and it gives you a sense of the important trends. We're going to jump right in with the venue question. This was the hottest topic a few years ago. It appears to have settled down in terms of where the cases are going. And John, I'd like to start with you just to hear your perspective on how the judges, or I'm sorry, how the litigants are perceiving venue. Is this now something that you've got pretty much sorted out, or is there still, selection questions at the beginning of your cases?
I think there's more difficult selection questions now than there were before TC Heartland. I think, at least it's been in my practice when I'm on the plaintiff side trying to pick a place to file. The drivers of that decision really, the largest, most important one from a plaintiff's point of view is, are you going to get a firm trial date relatively soon, and is it not going to move? The second criteria is, are you likely to get to trial, or is the philosophy in the court, going to try to get rid of it either on claim construction or summary judgment or some other dispositive motion that will prevent you from getting to trial? What are the chances the case is going to get stayed? And what are the chances it's going to get transferred? So you do that analysis, and I think that's one of the reasons why the Eastern District of Texas was so popular pre-TC Heartland because it was a court where you knew you were going to get a trial date, you knew it wasn't going to move. I think there was a judicial philosophy that you were going to get your day in court. There wasn't going to be a lot of dismissals ahead of the trial. And so plaintiffs wanted to file there. You know, I've been practicing for 30 years. When I started, that was the way Delaware was. And almost all my cases were in Delaware. And Delaware sort of changed a little bit over time and started dismissing things and granting summary judgments, and trials got further out. And so folks started going to Texas. I was heartened to see the statistics there because I think there's a misconception about Texas, about whether it's really pro-plaintiff in the sense of the outcome. And if you see, the trials are 50-50. So it's not really a pro-plaintiff outcome place, but it is a place where you're going to get your trial. And I think that's why people file there. In the post-TC Heartland time period now, Eastern Texas has become less attractive because you don't want to start your case with transfer practice because all that does is delay the result. But now the plaintiffs are stuck with a quandary because the other jurisdictional options are not as attractive. You know, in Delaware, more cases get resolved early through motion practice than you'd like to see. And in Northern District of California, where a lot of the other cases are getting filed, I think the statistics there are probably even worse on cases not actually getting to trial and speed both. So plaintiffs are sort of, have got their back up against the wall about what's a better place to file. And the problem is if you go outside those three jurisdictions, you never know what you're going to get because the judges often don't want the cases. They have heavy criminal dockets and they won't schedule them for trial. You know, sometimes you'll have a Markman hearing, you won't get an order for 2 years, or the case won't get settled for trial. So I think in the aftermath of TC Heartland, it's been very difficult for plaintiffs to figure out where they want to file, and I think TC Heartland was, a great result for when I do defense cases.
Well, Chief Judge Gilstrap, is that warming your heart, or is it making you feel relieved?
Well, if you ask the litigants who appear in front of me, they would wonder if I had a heart at all. I love coming to these conferences because every day I live in a micro world where I get to the courthouse and which fires are the biggest and which ones do I have to put out first. And then I get to come here and transition to the macro world where I can see the view from 10,000 feet. And I think the view is fairly accurate. I think there are probably some things you don't see from the macro level that you see at the micro level. For example, I know in my court we had a major U.S. manufacturer, appliance manufacturer, set out on a intentional course of litigation to try and shut down largely offshore knockoff refrigerator water filter companies. And we had many, many lawsuits filed, and every one of them resulted in an injunction. And every injunction was agreed to. None of them were contested. So all of a sudden, our injunction numbers look skewed on a slide like that when really, it's something that doesn't result from actual litigation and trying of issues. It's an agreed result from a course of intentional conduct like that. I do agree that the 50-50 result on verdicts is reflective of the fact that our district, and this is over many, many decades, it's nothing new at all. We have a cultural history toward going to trial as opposed to disposing of the case on summary judgment if it's at all a close question. And that's just our cultural background. There are other districts. I've always kind of viewed the Northern District of California as one that had the opposite cultural view, that if it was a close question, they were more likely to grant summary judgment than go to trial. One's not right, one's not wrong. One thing I learned when I came on the court, there are real differences from district to district around the country as to their culture and history and tradition and the way they approach litigation. The fact that we grant less summary judgments is indicative of the fact that those cases go to trial. And some of those cases are good defense cases and they get defense verdicts. But you're more likely to get a trial before the jury in our district than you are in some others. That I think the statistic on the summary judgments and the verdicts go hand in hand there. As far as T.C. Heartland goes, I will be real honest with everybody. From a day-to-day work standpoint, I have seen absolutely no difference at all. I often told people a year or two ago, and I think it's true up and through the present, when you're 10 feet underwater and you're drowning and somebody brings you up 5 feet, you're still drowning. And so we certainly don't have as many cases as we did. Many of the cases that have gone to Delaware and other districts are NPE cases where, quite honestly, in my view, the economics of the lawsuit won't generate the additional costs of fighting the venue question. And in many of our cases now, because of T.C. Heartland and In re Cray, we start off with targeted venue discovery. And and that adds a layer of cost to the process. It really hasn't delayed the time to trial and to verdict, but it has increased the cost. And if you're a questionable economic case, and you can choose our district, or you can go to Delaware, where if that's the state of incorporation, it's a lead pipe cinch. I think that's why a lot of those NPE cases have left our district. The result, though, is that I think we've kept the majority of the competitor cases. And those are the cases that there's enough at issue and there are strong enough feelings from competitor to competitor. If there's an extra layer of targeted venue discovery added, so be it. They want to fight, and they're going to spend what it takes to fight to a result. On the practical side, when we had literally 1,000 NPE cases a year, they took probably 1% of my time, because you got a complaint filed and weeks or a few months later, you got a agreed motion to dismiss. It took no time. We spent no effort. And so when those left our plate, it really made no difference. So the numbers have changed significantly. The workload has not changed. And, I'm set to try 2 patent cases to a verdict in December. And that'll probably give me 12 or 13 patent trials in the last 12 months. So we are trying patent cases as fast as we can, and that hasn't changed. We do get pretty much a venue fight in every case, just because of the lay of the land post T.C. Heartland and In re Cray. That's just the world in which we live. But many of those cases, it's such now that you can argue about the rationale for In re Cray and whether a brick and mortar 19th century philosophy should apply in a 21st century digital world, but the rules are pretty straightforward. And those rules make it really pretty clear whether you're going to be able to keep a case or not keep a case. So we still have a lot of venue fights, but whether you like the result or don't like the result, there is greater clarity to the situation now than there used to be. What else, Peter?
Well, let's go to Judge Noriega. You're now in the popular district, the cool district.
Let's not forget that John called me less attractive than Judge Gilstrap. I'm still smarting from that. Thank you.
Well, just remember from the old Hertz and Avis advertisements, number 2 tries harder.
So do you deal with venue, or is it just it's clearly established in the lion's share of cases?
I have not had a lot of venue motions. I think right after T.C. Heartland came out, there was, I was still practicing, so I haven't actually been a judge. I wasn't a judge pre-T.C. Heartland, but we did, as a litigator, I filed some venue motions after T.C. Heartland, and maybe I'll now have 1 or 2, but it's not a big issue. A lot of times people just come to Delaware because it's a safe for venue, and they don't have to deal with the issues that Judge Gilstrap was just
well,
mentioning.
it's interesting. You're getting more of, your district's getting more of the NPE cases. perhaps for this economic reason
Right.
that they're marginal, and that's probably
Right, it's just a safer place. You don't have to worry about expending resources at the beginning on venue because there's not a venue challenge. And that's consistent with what we've seen, which is when people come, there's just not a large number of venue challenges.
so. Judge Benjamin, you're in a place that
Clearly,
has some,
I'm here because my venue has the best weather of all of the 94 venues in the country. Unfortunately, we don't have as many people who have a regular and established place of business. So if you're not Qualcomm, you're probably not going to be in the Southern District of California. But we have it. When I look at my docket, and another aspect that I reflect that's a little different than my colleagues to my left, is as a generalist judge. We all are generalist judges, but our district also is one of the 5 busiest criminal districts in the country. And so my balance of caseload is very different. While my civil caseload is probably less than 40% of my docket, my patent cases then become more concentrated and more important because within my civil docket, they may only be 10 or 15% of my civil docket, but they take the most time, and for me, they're the most interesting. But my criminal caseload is huge. And right now, we're down 5 district judges, so it's really huge. And I'm sentencing, a dozen people a week for border-related crimes. So balancing that when you choose to come to a district and pick venue and looking at, as John pointed out, what's going on in that district in terms of your ability to get judge time and trial time. Those of us who are in districts that are swamped with criminal matters, there is a reticence to say, if I go there, am I going to fall behind the Speedy Trial Act and never get a trial date? You will get a trial date. I will give you a trial date. I've never had an attorney come to me and go, "Oh, Your Honor, can't we get an earlier trial date?" And it's like, yeah, you can go to trial whenever you want. Usually they're asking for extensions. But, it's an interesting question about picking where you're going to go. And we try to be venue friendly by having local rules. Another aspect of this that doesn't really get caught up in your statistics, but would be interesting, maybe difficult to tease out, is how many judges are there in these districts? Because not only are you picking a district, but you're also looking at the number of active judges. The Central District of California has like 28 sitting judges, and although they're a patent pilot, they all still pretty much take whatever they get assigned. The Northern District is a patent pilot district, but they also have their magistrate judges on the wheel. So they have a really big selection of judges. The Southern District of California is a patent pilot. There are 4 of us who do 80+% of the patent cases. So if you filed in our district, you would pretty much know you were going to get 1 of 4 judges. In the other districts where they have such a huge number, they have less active judges too. So, who you get, not just what district you're in and what are their roles, but what judge are you likely to get could be part of your factors in deciding where to file.
Absolutely.
And, then there's the other, 80 districts in the country that aren't in this top 15 that, you're going to get a judge who hasn't seen a patent case in a decade, if ever, and has no rules and doesn't want it and doesn't know what to do with it. But that's where your defendant is incorporated or has their regular and established place of business. And good luck with that. When they say one-on-one motion and the judge goes,
well, let's move on to the PTAB interaction. This is obviously an issue that has emerged over the last 6-7 years since the American Invents Act. This has been a somewhat exciting year for PTAB. They are getting some pushback on their constitutional status. I think things have settled down in a lot of ways, but it's now, I think, raising issues about how well the district judges can rely on the PTAB process. So, John, has that filtered into your thinking on how to approach these cases now?
Yeah, definitely. I think, first of all, just a commentary on the United States government and its ability to do something well. I think this whole area is really strange. You know, you pay the patent office to get a patent, you spend a lot of time getting it out, and that same group then in the in the IPR process takes it away and charges you. They get charged, the patent owners get charged on both ends.
Coming and going.
It seems so unfair. They should just, we should try to figure out how the patent office can just issue good patents in the first instance, and we could solve this whole problem. So I agree, there's a patent quality problem, but going back to the patent office to fix it seems like a mistake. But Congress, what they were trying to do with this was a laudable goal of getting efficient and saving people money. And I don't think that has happened as in the way that Congress intended, because what I see happening in my cases, whether I'm plaintiff or defendant, is everybody's hiring two sets of lawyers. You're now hiring litigators and you're hiring PTAB folks. Sometimes it's the same group, but you've got more lawyers on it. And those proceedings largely are going in parallel. So I think this notion that we are going to be efficient and have the PTAB resolve this stuff and not the district court, I think isn't really being realized the way Congress intended. So I think litigation's got more expensive because of the PTAB, because of the IPR process. And they're, now with no limits on how many IPRs you can file. I mean, it seems like sometimes you're fighting 4 or 5 on the same set of patents. And largely, the cases are not getting stayed in the district courts, so that process is running in parallel. I think it's been my experience that it's rare to actually stay an entire case because of what's going on in the PTAB. But that is one of the criteria we look at if I'm trying to file a case. We look at, is this a district? It's one of the other criteria. Is this a district that's going to grant a stay if there's some action in the IPRs? So we factor that in on the venue question. But, the whole thing, I think Congress should maybe look at this again and try to figure out how to achieve their efficiency and cost-saving goals that they intended, because I don't think they've achieved that right now.
Judge Benchvenko, you raised this question for me right before we got started. How are you thinking about stays now that the whole PTAB process is under another cloud?
We all held our breath while they tried to decide whether you could do an IPR and it was constitutionally a violation of your 7th Amendment rights. And that came out saying, oh, good, they're not going to send all that stuff back and tell us to do it again. And now they said, well, but the judges aren't constitutional. So I don't, unintended consequences of what I thought had a good goal of taking primarily the invalidity issue and putting it back with people who understood the art, the field, the scope of the patent, and could say, yes, now that all of the art that we didn't look at before is in front of us, we can reevaluate this patent. Whether they should do that in the first instance better or not is a different question, but maybe not having juries decide that more complicated question than simply getting a patent that's been construed and say, okay, now match it element by element to the accused device, which I think a jury may be better situated to do than grabbing a handful of prior art, having to interpret that and determine whether it renders this patent obvious. That's a much more complicated question. But I tended to want to stay if it was an IPR because I don't want to spend the time and money putting parties through parallel litigation, particularly since even if the patent comes back, there's usually comments, disclaimers, the positions taken in IPR that are relevant to my claim construction and how I'm going to apply the patent. But now it's like, okay, but when are they going to have judges who can actually hear this now? And oh, by the way, are all those old ones going to come back to me? This is like when we get a sentencing reform thing and they say everyone you sentenced for the last 10 years has to be reevaluated because we changed the guidelines. And like, oh, good, because it was fun the first time. So, it just, these sort of flipping back and forth things are very complicated. And I think it really was going to put a real damper on the idea of staying a case while we don't know if it can even be heard.
Mm-hmm. So how's Delaware handling this question? Is stay less available? I know that, from talking with judges in the past, I mean, there's a negotiation over the stay, and the judge is pretty active in that. Is that?
Yeah, to some extent. I mean, I think I take each case on its, based on its own merits, and I look at the stay factors. I don't typically stay a case before the PTAB is instituted, trial in a matter. And then if the PTAB has instituted trial, I look to see, is it really going to simplify the case? Is it, if there are 10 patents and the PTAB's instituted on one patent, then it doesn't really make much sense. If there are 10 patents and the PTAB is instituted on 10 patents, then it does. I have not yet had to consider the latest challenge to those to the PTAB procedures, the PTAB judges. I'm not sure that that's going to change my approach on things at this point, but it might. And as for the negotiation aspect of it, when I'm looking at the factors, I typically get the folks on the phone if I'm thinking about granting a stay, or I get them to come in person. And I do want to make sure that I understand what the scope of the estoppel is going to be, what the defendant is agreeing is not going to come back to me, and to get some understanding of how the case would be simplified. So there is, if I get something and there hasn't been an institution yet, I'm probably going to deny that and I won't have any negotiation. But if the PTAB is instituted on some terms, then I would probably have that.
Judge Gilstrap, I know you've had some concerns over the years about the parties not being fully upfront about how the PTAB process is going, and
Well, I think to John's comment about perhaps the process is not working like Congress intended, I think the factor that maybe Congress didn't take into account was the creativity of trial lawyers. And, now we have two parallel tracks that one can be played off against the other, and it creates opportunities that didn't exist before. I think a big part of the problem is the 12-month window that you have. If you had a 3-month window, then you knew early up front, and it would make a whole lot more sense. In my district, we're one of the ones where you're going to get a trial date early, and it's going to be written in stone, and your case is going to move along. And so by 11 and a half months, when they decide to go file at the PTAB, we're way down the road. I've spent a lot of time, a lot of resources. We're in all likelihood past Markman. And I'm not very likely to stay a case where I have a lot of time and effort invested in it. Had that been filed early, well before that expenditure on my part, I might feel considerably different about it. I think that 12-month window is a problem, because I don't remember any that were filed in the first 3 months. They're all filed in the last month or two.
To be fair, though, and I think it's important, especially if you're in a district where the judge has very little experience with any of this, that you make sure the judge understands what it means to file a petition for review. It's not like filing a notice of appeal where you just send in a one-sheet piece of paper saying we want to appeal this order, and then you attach all the stuff later. And yeah, the 12-month window may be too big. But certainly within the first 3 months, if this is the first time you've seen the patent when the complaint got filed, and you have to figure out what claims you really are at issue and you want to challenge, and the amount of work and time that has to go into that to do a proper petition for a review, it's not unreasonable for someone to maybe need more than 3 months. And I just think it's important for a judge, when that first factor comes out, is, well, why did they wait so long? Well, because you threw a patent at us with 150 claims and wouldn't tell us which ones you really wanted to pursue until we got your infringement contentions or whatever. And so it's a complicated process. And so it's not, and it's your one shot, it's your petition. So there again, there's a balance.
Well, there is, and I'm not saying it should be 3 instead of 12.
Yeah.
I'm saying it might not should be 12. And, in our district, we have local rules that front load all those disclosures of infringement contentions and invalidity contentions. And so you're going to find out where the real deal is a whole lot quicker here than you might somewhere else. And maybe if you're in that district that's not one of these top 15, and you don't have any idea until 6, 9, 11 months down the road, that's a different deal. But that's not the state of the real world, and at least in my district.
Steve, you wanted to?
Yeah, I just like to respond to a comment about, you know, what the PTAB route and IPRs have done. I mean, I don't think it's necessarily a failing of the federal government to have created this mechanism. Even before IPRs, you know, there was inter partes re-exam. It's really it can be viewed as a more efficient mechanism to get the truth on actual validity. And you know, and moreover, it's an inter partes process. It's recognition by Congress that, yes, the patent examination process is inherently limited because you cannot give examiners an infinite amount of time to look through all the prior art in the world. And the rate at which prior art is being generated nowadays is just phenomenal. You just can't search it all. And so, you know, what we've seen, I think, since the inception of the AIA and the creation of the PTAB for these trials is that oftentimes it's not a parallel proceeding, and oftentimes it becomes an either or. It shifts the economic goalpost for plaintiffs bringing patents of questionable validity out of the district courts. And what we've seen in interacting in many of these transactions is that often when plaintiffs do have patents of questionable validity, they're not even going to bring a case, or they might settle a case very early. And that's actually, I think, to a certain extent, the creation of the PTAB has, to a certain extent, contributed to the downturn in patent litigation from that standpoint, and made Judge Gilstrap drowning from 10 feet to maybe 7 feet. So,
so we're going to move on to another controversial area, which is patent eligibility. And what I'd like to focus on are really the timing question, which we saw has shifted, but also how you're reconciling the case law, because the Federal Circuit is now generating a ton of cases on top of the Supreme Court cases, which were already difficult to reconcile. So, John, again, can you tee this up for us and we'll jump in?
Yeah, I think that, you know, as probably everyone in the room thinks, I think the Supreme Court's guidance on 101 has been not nearly clear enough to help the courts figure out what it is they're supposed to do. And I think the district courts in the first instance have an impossible task. You know, they're asking district court judges to decide if something is abstract or not. And, you know, persuasive lawyers can argue both sides of that issue. And then if you get to step two, they're asking judges often on a motion to dismiss whether something's conventional or not. I think that's an impossible task for a judge to do. And you know, you see the Federal Circuit as well. Depending on what panel you get, you're going to get an opposite result on the same patent. So we're struggling, everyone's struggling, the district court, the Federal Circuit, and the lawyers to figure out what the Supreme Court had in mind. I think finally we're going in the right direction, because in the early aftermath, patents were dying under 101 with some regularity, and you know, many courts were feeling comfortable just cleaning up their patent docket by deciding these issues. But then, you know, with Berkheimer and other cases like it, where folks are beefing up their complaints, what plaintiffs' lawyers are doing in response to this is putting in their complaints factual allegations that talk about what was conventional and what wasn't conventional, what's inventive and what wasn't inventive, because that all has to be presumed true at the motion to dismiss stage. So it puts the court in a situation where if they assume what's in the complaint is true, they can't grant the motion, and it has to go on for factual determination. But then, you know, Berkheimer brought it to the far extreme of, okay, so now we're going to have trials on 101. And I don't see how that trial doesn't collapse into 101 being the same as 102 and 103. So I think the rubric here that the Supreme Court set up is intractable and needs to be fixed. And probably the only fix at this point is legislation. But, you know, I don't know that our Congress is going to get to that anytime soon. They seem to have other things that they're working on right now. So, you know, it seems strange to me. I think the law is confused and needs to be fixed.
Mm-hmm. Well, I think you opened up quite a range of issues there. Judge Noriega, do you have a view on resolution stage on whether you would hold trials on these questions that have a factual component?
Okay, so I'm going to start by saying I agree with everything John said, that it's very difficult. It's a difficult issue. I have many motions to dismiss that are filed on 101 challenging the eligibility. And I typically will address them at the motion to dismiss or judgment on the pleadings, or, either as 12B6 or 12C. And that works, though it is difficult to do. I have to tell you, I think Atrix has made my life a little bit more confused than even Berkheimer, because now I have a hearing on 101, and if I dismiss, I'm now asked, well, heck, can these claims actually be eligible if I go back and amend my complaint? And that, to me, I don't really understand how it can be that claims that I find are not eligible actually will be eligible if you beef up your complaint, but that's kind of where we are in the weird Berkheimer-Atrix world that we're in. So I think Berkheimer does make it more difficult to finally address the issues if there is anything in the patent specification, or perhaps if you can make enough of a factual record in the complaint, rather than just conclusory allegations saying this is not conventional, routine, well-known, whatever. So I address them at the motion to dismiss. I have not yet had, it's probably just because I've only been on the bench for a year, I haven't yet had any at the summary judgment stage or that have gone to trial. But, and I'm kind of hoping to see if there's any clarification on the factual issue, whether it is an issue of fact. And I do agree that it does, the whole two-step process leads me, so often I feel like I am really addressing in the second step novelty, essentially, at the motion to dismiss stage. And that's really hard. And I don't usually have a record where I feel comfortable doing that.
Chief Judge Gilstrap.
Well, I recently wrote an opinion denying 101 at a summary judgment stage, and I said the only thing clear about this area of the law is that it's unclear. And on the one hand, that's frustrating. On the other hand, it gives you a little bit of freedom because nobody knows what you're supposed to do.
But they know you're wrong.
And that's usually the
Everybody's wrong.
we get from
Yeah.
the Supreme Court was you didn't do the right thing. We're not going to tell you what the right thing was, but it wasn't that. So try again.
We're not going to tell you because we don't know.
Yeah.
Well, I had an interesting experience a few months back, earlier this year, where we had a early 101 challenge, and I don't know about other judges here, but it's rare I get a case filed that there's not a 101 challenge that goes with it. It's just part and parcel of patent litigation now. And it was denied at the Rule 12 stage, and it was argued at summary judgment. And at summary judgment, I found clearly as a matter of law under Step 1 of Alice, it was directed toward an abstract idea. But there were real unanswered questions of fact as whether this was routine or well understood. And so I carried the Step 2 part and made it a part of the jury trial. And I submitted a question to the jury on the verdict. In addition to the infringement and invalidity, I submitted a question of whether the functionality embodied in the asserted claims was well-known, routine, or understood. And I can tell you that we got an answer and everything all fit together, but you cannot try the 101 issue in a case with 102 and 103 where it does not all collapse down into one narrative that the jury is told. It's just unavoidable. In my case, the jury came back and found no infringement, invalid under 102 and 103, and it was well understood, routine, and conventional. So everything lined up, but it was one set of evidence. It was one set of testimony from various witnesses. It wasn't like there was an invalidity witness and there was an ineligibility witness and there were clear lines. There were no clear lines. It collapsed into a single inquiry that was addressed in multiple questions on the verdict form.
Can I ask a question of the judge? So,
But I don't know how else you do it. And if there are questions of fact that are real and live,
And when the verdict form comes back, there's no 103, but there is 101.
and I was praying that I wouldn't get that. And thankfully I didn't. And I've just done it the one time. But that's going to happen.
Yeah.
what do you do if you have an IPR art preclusion? So they went to the patent office and they're precluded from raising invalidity, and then they bring it back as a 101 and they start using the same art to show that it was conventional at the time.
That didn't take you long to come up with that.
Yeah.
Short answer, is I don't know.
I don't know.
I do a lot of defense cases.
But I mean, I think under at least the discernible part of the current law, if there are underlying questions of fact on the step 2 analysis, they're entitled to be resolved. And the fact finder in a jury trial is the jury. And I didn't think I had any other way to address that and get some resolution on those questions, except to make it a part of the jury trial. And it dovetailed in nicely, or I guess said another way, it was more or less subsumed by the invalidity evidence.
And did the parties agree to the instruction that you gave, or did you have to fashion it?
No, I don't think there was a big fight over the instruction. I mean, the issue of under step 2, whether that functionality is well understood, routine, or conventional, I think everybody agreed on the language. Nobody said, no, you have to say it a different way. But I think everybody in the room knew it was collapsing into the invalidity evidence. And on the one hand, I know no other way to do it where it's a question of fact and you have a jury. And on the other hand, at least Berkheimer, is it clear enough to me that you cannot resolve the question in its entirety if there are live disputes of fact regarding that step 2 analysis. Now, can you do that in a way that doesn't collapse into the 102, 103? I don't think so.
Yeah.
But
And 112.
and 112. But that's what we have.
Mm-hmm. Yes, Judge.
Yeah, I think that when this whole kind of trend started, there was certainly a lot of patents out there that on the face of the patent, judges felt comfortable to go, yeah, this is garbage. And those patents weeded themselves out either quickly, and I think when you look at the affirmances on 101 from Rule 12 motions from district judges, those were, use a computer. And, it'll make it go faster. And it's like, and you're just using a computer and it's regular course to do what it does. There's no innovation there. And and those cases aren't getting filed anymore. They're weeding themselves out. So we've seen less of those.
The low-hanging fruit's all been picked.
Exactly. So the ones we do have now raise all these questions. And as a Rule 12 motion, you'd be a pretty poor plaintiff in your pleading if you don't address this conventional routine issue with some assertion, and it can't just be, it's not, the ultimate legal conclusion, it's not conventional, routine, or well understood, but some factual basis. Because once you've put that in your complaint, the other side's going to want to introduce declarations or whatever to counter that, but I can't do that on a Rule 12 motion. I can't go outside the scope of the pleading. So unless what you're saying is directly contradicted by the specification, where in the specification it says this is all just the normal customary use of off-the-shelf products, there's nothing, you could substitute anything here, and then you say, oh no, this is unique architecture, and then you're going to get past a Rule 12 motion, and you're going to get into these questions of fact, and then whether or not that can be addressed on summary judgment because there is actually no material fact being raised by the plaintiff in light of what the defendant's putting on is maybe going to be judge and jurisdictionally sort of balance how far out on a limb a judge is willing to go in ruling on that, or do you put it to a jury and then, boy, you want to be careful with how you draft that verdict form, because when it comes back with it's okay under 101 but not 103, or the vice versa, and you've got inconsistencies, That's everybody's nightmare.
I think we have time for one more issue. So John,
Let's do willfulness. Let's do that one.
Okay.
It's great.
okay? You want to tee it up?
Yes, I will. I had such great personal experience with this issue in the last year. Let me just relay what happened. So I had 2 trials last summer, one in Texas and one in Delaware. In the first trial, which was in July, the willfulness charge that went to the jury, the court adopted, was modeled after the Federal Circuit Bar Association pattern jury instructions, which said to find willfulness, and then it used the HALO language. It has to be willful, wanton, malicious, characteristic of a pirate. And that went to the jury, and the jury made its decision. Literally 3 weeks later, I was in Delaware having a second trial, and the jury instruction there was just subjective intent. We're not going to make it malicious, wanton, not the HALO language. So in the course of these 2 trials, we were grappling with this issue. So I had one of our associates collect all of the cases post-HALO and get all the jury instructions. And what we found was in all of the district courts, there were jury instructions on both sides. In the same court, in Delaware, Texas, California, judges in the same courts were sometimes charging the juries with the HALO language of it. To find willful infringement, it has to be egregious, wanton, willful conduct. And sometimes that same court was charging subjective intent. So really strange. So we got all the Federal Circuit cases, and it turns out the Federal Circuit was pretty clear that it was going to be just subjective intent, not the HALO standard. So that winter, right after those trials, I gave a CLE in the New Jersey IP Law Association on the willfulness. And I showed all the district court cases. I showed the conflicting jury instructions, and I predicted the Federal Circuit's going to clean this up. As these cases percolate up, they're going to fix it. It's going to be the subjective standard. And then literally 2 weeks after my CLE, the SRI appeal gets decided, where the Federal Circuit reverses a jury verdict against Cisco on willfulness, and they say, even accepting this evidence is true and weighing all the inferences in SRI's favor, we conclude that the record is insufficient to establish that Cisco's conduct rose to the level of wanton, malicious, and bad faith behavior required for willful infringement. That's just clearly wrong. HALO was very clear. HALO said, once you have a willfulness, when do you enhance the damages? So all that language in HALO about willful, wanton, characteristics of a pirate is when should you enhance the damages and how severely. It's not about willfulness or not. Willfulness or not is a subjective standard. So I don't know what the Federal Circuit is going to do with this now with SRI, but this, like every other topic we've talked about today, it's a mess.
Yeah, and that's actually not the only case. I mean, Judge Bryson, and I love Judge Bryson, I think he's brilliant, but he has a case when he was sitting by designation in Texas. I think Eli Lilly was in there, and he didn't send the issue of willfulness to the jury, and then he explained why. And even in that, he was going back and forth using the
You're right.
wanton language, saying, I didn't send it to the jury because I didn't find that they met that issue, but I still wasn't going to grant it. It's harmless because I wouldn't have enhanced damages anyway, and I have the discretion. But those kinds of things, even before SRI, when I was looking at the issues and what to do with the jury instructions, I was like, I couldn't go either way, and I probably have ones going both ways because sometimes I think I could do it either way based on the law, and if the parties don't object, I go with it.
Yeah,
And that's a real explanation for why judges in the same district and the same judges in the same district are doing it different ways. You're in the middle of a hard-fought jury trial, and it's time to do the charge, and they want to spend hours arguing over the infringement instruction, and here's the willfulness instruction, and nobody objects from either side. you don't have time to say, well, I want to raise another fight that you all have. You're just trying to get to the end of the trial.
And if you
so
agree
you
to the
take it and
instruction,
run with it.
Yeah.
Yeah.
And that's why you sometimes get a different instruction from the same judges.
I'm not sure what guidance you're giving a jury to say it's a subjective standard of willfulness. It's a strict liability statute. And if you know there's a patent or not, and you infringe, you infringe. And if you, just because you know doesn't make you willful either. So what is the subjective standard? What adjective am I going to give you to say this act of infringement that you've now found based on a patent that they knew about is not just straight infringement, but it constitutes willful infringement? There has to be some behavior there that they're going to measure it by, and to say, did they subjectively do it in knowledge of the patent? It's got to be more than that. Did they do it with reckless disregard for the rights? Well, then you're starting down that road, and you need to define it somehow. So again, they've left us in a box that's, if the parties propose an instruction, and I may not like it, but if they agree with it, I'm kind of in a better place to go, fine. If that's what you want, that's what you get.
You know what's really funny about this topic, though? If you go back to sort of first principles, why are we sending that question to the jury anyway? The statute says the court has the right to enhance in exceptional cases. And we're not asking the jury to find the case exceptional. Willfulness doesn't actually mean anything. Why are we sending it to the jury?
That's where I was coming out with.
Yeah.
It may be that willfulness, if it doesn't have any adjectives with it, it just means that you knew of the patent and you knew you were infringing it, and that's it. And then, there could be lots of willfulness, and then it goes to the judge to determine if you meet the standard for that meaning anything at all.
Right.
Well, certainly, we never tell the jury this, but you're talking about the possibility of trebling whatever the award is. And personally, I want the comfort of knowing the jury, hearing the evidence, looked at it and told me, yes, it was wanton and willful and egregious. Now, I may not enhance it all. I may enhance somewhere between those two. But from a baseline, I'm much more comfortable later dealing with whether I should or shouldn't, and if I should, how much, if I know that there's a common sense determination by the fact finder that it was really wanton and willful and egregious.
Well, and while you're sending
I
this,
agree with Kathy. I mean, you have to have some understandable basis for the jury to react to.
but if the jury is going to make this willfulness finding, and you're going to tell them that the behavior, the act of infringement had to be more than just knowing, it had to be, then there's always that, and did they build some punitive damage on their own into their decision
Well,
on
you
the
tell them not-
compensatory damages? I mean, you may tell them not to, but
do.
when you're looking for a unanimous verdict and someone, is compromising or saying, well, we think it was willful, and the other saying, well, we don't, but okay, well, we'll bump the number a little to justify. So there's a lot of things rolled into that.
If anybody thinks juries don't negotiate and bargain, they've never tried a lawsuit.
Especially when you need to get a unanimous verdict and you got to rope everybody in.
But let's see if we can maybe resolve this issue by this Federal Circuit panel sitting by designation. Because it sounds to me, Judge Gilstrap, that you actually want the more detailed standard. You in some ways want to see not just is it willful or not, but where along the spectrum of behavior you really want the jury in some ways to evaluate the conduct.
I do.
But John's saying that's not really how the HALO decision intends the willfulness part.
Right.
So it sounds like you want an advisory opinion that will help you to assess enhancement, not just whether to enhance, or, is that?
Well, I'm going to make the decision if there's a verdict on willfulness that's returned. I'm going to make the decision. But I want to know that the jury has decided that this is more than somebody who just stumbled onto somebody's patent and didn't know about it, and that they really are a bad actor. And taking the words of that bad intent, that bad action, egregious, willful, wanton, taking that out of the jury's determination, to me, doesn't help at all. It it gives me less information to work off of. So whether you call it an advisory opinion, or whether you call it a prerequisite to enhancement, it really kind of plays out in the real world much the same.
If you look at the Reed factors, though, and you say, well, there are a number of them that the jury would have no knowledge of, in terms of the way the case was litigated and all those background issues that the court has knowledge of and can consider and whether to enhance. This is just one factor. And presumptively, the evidence at trial, if there's infringement, is going to show there was copying, there was knowledge, there was, disregard. I mean, when you go back when I was practicing and the issue was, did you get an opinion of counsel? I mean, that was like the threshold gateway. Were you a willful infringer because you learned of this patent and you didn't get an opinion of counsel? And that's gone way by, no, that doesn't matter anymore. But that was like the issue. And so, that was the thing the plaintiff put on and said, oh, well, they knew and they didn't get outside counsel to look at this. And now that's not even on the table anymore. So I don't know what they're looking at.
Okay. Well, listen, I wish we could go on, but we're going to have a great panel for the second half of this morning on the PTAB. I want to thank our judges and John and Steve for illuminating these issues for us. Thank you.
Thank you very much, my friends. A timely conference is a happy conference, isn't it? We can keep moving it forward. And I've been asked to remind you that if you seek CLE credit for New York or New Jersey, the hinterlands. No, if you seek CLE credit for New York or New Jersey, you have to sign in. Okay, we can't take your word for it. All right, so thank you very much. With that, I will turn it over to Naveen Modi, who's going to lead the panel on the PTAB. Thank you very much, and the ITC.
Great. Thank you, everyone, for joining us, and good morning. For those, again, I'm Naveen Modi. I serve as the president of the PTAB Bar Association. I'll put a quick plug in. Please join if you are not a member of the PTAB Bar Association. I also serve as the global vice chair of the IP group at Paul Hastings. We have selected some topics for our panel discussion this morning, which we hope you'll find interesting. And really, we're trying to get at the latest and greatest at not only at the PTAB, but also the ITC and the overlap between the two forums. So hopefully you'll find our panel discussion interesting this morning. So, and we'll also try to leave some time for questions at the end. So we'll aim for that, but we'll see where the discussion goes. With that, let me introduce our panel members. So I'll start with Judge Clark Cheney. Judge Cheney was appointed as an administrative law judge at the US ITC in March of 2018. He began his career as a patent examiner at the USPTO, and after law school, clerked for Judge Bryson at the Federal Circuit, while I clerked for Judge Shaw. So it's really great to have Judge Cheney on our panel. He also worked in private practice representing domestic and international clients in litigation. He also worked at the US ITC's Office of General Counsel, where he represented the ITC in appeals to the Federal Circuit. And he also served as an ALJ at the Social Security Administration and the Federal Energy Regulatory Commission. And he has, so he brings really a very diverse background for our panel today. Then to his left, we have Eldora Ellison. She is a director at Stern Kessler. She also co-chairs the firm's patent office litigation practice and is a member of the executive committee. Eldora has extensive experience in inter partes patent matters. Her experience includes representing clients in inter partes review, post-grant review, interferences, reexaminations, and district court litigations. She brings the life sciences perspective this morning. And then we have Steve Smith to her left. Steve is a partner at Cooley and is currently the chair of Cooley's intellectual property litigation practice. Steve has over 2 decades of first chair trial experience. Steve also served as a senior investigative attorney at the ITC for 3 years. And Steve also serves, in his free time, he serves as an adjunct professor at George Mason, where he teaches patent law. To my immediate left, last but not the least, we have Jonathan Stroud. Jonathan is the Chief Patent Counsel at Unified Patents, where he manages an in-house team responsible for a number of things, including inter partes reviews, district court litigation, federal circuit appeals, and licensing. Jonathan also serves an adjunct professor at American University, where he teaches and publishes on post-grant procedures. Prior to his role at Unified, Jonathan was a litigator in private practice. I had the pleasure to work with Jonathan, and he was an examiner at the USPTO before then. So let's go right into our discussion. We have a lot to cover today, probably more topics than we'll have time for, but let's start with the elephant in the room from a PTAB perspective, and that's the Arthrex decision. So perhaps, Judge Cheney, you could kick us off. And that decision, if those who didn't notice, was issued on Halloween. Judge Cheney, if you wouldn't mind giving us some background on that decision and kick us off, that would be great.
Sure. I am so happy to be here at my alma mater. And I'll just take a little point of privilege. I used to live in this very building. Right after it opened, I lived on the 6th floor. And when you looked out this direction, you had a really great view of the liquor store and a very desolate parking lot, some abandoned buildings. It is just a really different place now, and the law school has grown since I was here, and the neighborhood is changing rapidly, and it's just such a pleasure to be back here. Speaking of history, I'm going to take you back to a couple of areas of law that when you were in law school and you were planning to become a patent practitioner, you probably didn't pay much attention to, and now you probably wish you did. And those two areas of law are constitutional law and admin law. So Article 2 of the Constitution describes two kinds of officers of the United States. We have principal officers that are nominated by the president and confirmed by the Senate. And we also have inferior officers. The Constitution says that inferior officers can be appointed by the president, by heads of departments, think like Secretary of Commerce, or by courts of law. And over the years, Congress has created many different positions, and there have been many fights in the courts about whether the positions created by Congress fall under one of these two categories of officers established by the Constitution. There's been a long and interesting history about officers at the PTO. I'll just give you a really fast sketch. In the 1970s, we had something called, I want to get this name right, Examiners-in-Chief, and they were kind of the predecessors to today's administrative patent judges. Those examiners-in-chief were nominated by the president and confirmed by the Senate. And then in 1975, the statute was changed so that those officers were nominated by the what was then called the Commissioner of the Patent and Trademark Office, and his nomination was ratified by the Secretary of Commerce. Fast forward into the 90s, we get into some more modern patent reform, and in 1999, Congress tinkers with the title of the commissioner, changes it to the director, and also tinkers with the way that these patent judges are appointed and makes them nominated or appointed by the director, straight up, just the director. Now, the director at that time in the 90s is nominated by the president, confirmed by the Senate, but reports to the Secretary of Commerce, is not a head of department. And so a smart fellow named John Duffy in 2007 wrote a law review article when he was at the University of Virginia and said, it looks like these patent judges are probably not appointed in accordance with the Constitution because they're not appointed by a head of department and they have substantial power. Cases started percolating this way along these lines, and Congress remarkably stepped in rather rapidly and fixed this and said, oh, patent judges are now going to be appointed by the Secretary of Commerce. Fast forward to 2011, the passage of the America Invents Act. Now we're going to tinker with what was then the Board of Patent Appeals and Interferences and make it the Patent Trial and Appeal, Patent Trademark and Appeals Board, the PTAB. And there's another little tinkering done with the way that judges are appointed, and they continue. Remember that the Duffy article is still in everyone's mind, and so they say, well, let's make sure that these judges are appointed by the Secretary of Commerce. And so everyone thinks that now we've got a new IPR system, we've got these constitutional judges, and everything seemed to be pretty good until Arthrex got a patent on a device for doing surgical sutures, and that patent was challenged by their competitor, Smith & Nephew, in an IPR proceeding. And Arthrex lost, and on appeal, Arthrex argued that the patent judges that decided against Arthrex were actually not just inferior officers, as everyone thought they were for the previous many decades, but they actually have so much power that they are principal officers. And Arthrex argues that their decisions can't be reviewed by someone who was confirmed by the Senate, and they cannot be easily fired. So that makes them principal officers. A unanimous panel of the Federal Circuit held that APJs were, in fact, principal officers. The panel looked at the Supreme Court case in Edmonds and focused on 3 areas and did kind of a balancing test. The first area that the Federal Circuit looked at was who is able to review APJ decisions. And the court concluded that no one can until there's judicial review. So that factor weighed against inferior officer status. Then they looked at who supervises APJs, and they said, well, the director of the Patent Office actually has a fair amount of administrative supervision over APJs, so that weighs in favor of them being inferior officers. And then they looked at how APJs can be removed. They said that they can't be easily removed. They can only be removed for cause, and they're entitled to hearing at the MSPB. And so that factor also weighs against them being inferior officers. And they ultimately conclude that those judges are principal officers. So what to do about this? Principal officers have to be, remember, back to your law school days, nominated by the president, confirmed by the Senate. And these APJs are not either of those things. So how to solve the problem? The Federal Circuit says, well, we should try to do something as narrow as possible to preserve the constitutionality of the statute and of the whole IPR scheme and the PTAB. And they decide that the best and most conservative thing to do is to eliminate removal protections to make it so that the director of the Patent Office can easily fire administrative patent judges. And so that is what they did. They reformed the statute in that way. And now to discuss the very controversial fallout of all of that will be my colleagues on the panel, and I will say no more.
So real quick to follow on that. So in the interim, right, well, to back up 1 second, a lot of this was provoked by the Supreme Court ruling in Lucia last year, 7-2, which was a opinion by Kagan that the SEC judges were not constitutionally appointed in a similar manner. Not exactly the same, because the SEC was arguing that they were employees because they were hired by other employees. So they needed them to be employees and not officers, and they were found to be inferior officers. But the remedy was similar. What's interesting about that is people think about it as like part of this inexorable march against the administrative state, but it's a Kagan decision that there's a concurrence from Justices Gorsuch and Thomas that it is the textualist opinion that it should be going further and there should be sort of more rigorous analysis. And the Kagan opinion just says, we did this in Freitag, it's almost exactly the same as what we did with the tax commissioners, so we don't need to go that far. So it didn't actually mean an extension of any new law, but it did provoke tons of challenges in the DC circuit and now in the federal circuit for these types of issues. So all of that is the backdrop of Arthrex and a number of other challenges that have happened at the federal circuit. People know about Polaris. Polaris was argued around the same time. It was argued Monday after this decision came down, and the panel there felt like they were bound. But to give you a timeline, Thursday, right, which is 2 weeks ago now, Halloween, this comes down, and then 3 orders issued the next day per curiam, 2 denying people who've asked for remands because they didn't raise this issue, and 1 granting a remand because Unilock had raised the issue like they do in all of their briefs and all of their appeals below. That day, my understanding is that the government wrote a letter, because it's been cited as an exhibit in some IPRs, none of mine, but I've seen it, asking the court to stop remanding cases while they consider whether they're going to ask for en banc. And then the opinion happens a few days later, or the argument happens in Polaris a few days later. Then there's a concurrence that issues in the Bedrock or Bedford case. Bedgear case, where the court finds that they're bound, but there's a concurrence by Judge Newman and Judge Dyke that says, this went way too far. You didn't need to do any of this. So even the limited remedy of possibly remanding these 150 cases for a new panel wasn't necessary, which freaks everybody out, because then they're like, oh man, en banc is a real possibility now, which is where we are. The government waits a few days, and then I have the date, but they sent letters to all of the cases that they thought might be affected, even cases where they had not yet intervened. I'm sorry, backing up. A day after that concurrence, the Polaris panel authorizes additional briefing in Polaris on 4 points, all related to what seems like an en banc review of the earlier panel that they feel bound to. And then, yes, Wednesday and Thursday, November 14th, so 13th and 14th, the government filed motions to stay in all of the pending cases that they thought might be affected by this, saying in their briefs they will seek en banc as of the deadline, which is December 15th. So as of right now, the government has indicated they will seek en banc review in Arthrex. That leaves everything a little bit up in the air, because if the Federal Circuit grants the motions to stay these remands, those cases are sort of held in abeyance, it feels like, until there's a decision on whether there should be an en banc review. And if there is an en banc review, that would result in a whole additional briefing schedule where it's unclear what happens to all of the cases in the interim. So if Arthrex were standing alone and there were no possibility of en banc, it solved the constitutional issue, according to the Arthrex panel, and it would only affect the 150 or so cases that were either post-final written decision or pre-initial brief that had raised it or could raise it, and then the handful of cases, many of which were by Unilock, that had actually briefed it at the appellate stage. Really only 150 to 200 cases looking at remand. But if that is pending for en banc review for 6 months or so, no one's really sure how that's going to affect the underlying cases. So that's just as a ongoing backdrop. There's probably a case being decided right now that is affecting this. So I don't have that up on my phone, but I'm sure that we will learn more in the coming days.
I have a question.
Sure.
Having represented a government agency in an en banc case, it's probably about a year from now before we get an en banc decision.
Right.
And usually if the court takes it en banc, and if the court takes it en banc, usually the first step of that process is to vacate the panel opinion.
Usually.
Usually.
Right.
And then where would that leave us
Right, so we've
with
looked into this.
everything in the interim.
We've looked into this too. So I don't believe there is technically a rule that they have to vacate the cases. They just do by custom. I could be wrong about that, but I couldn't find a rule in the Federal Circuit's appellate procedures that say they have to vacate.
Yeah.
But they do, right? So if after briefing was done and the responsive briefs would be due December 29th, which just seems cruel. But if they were to grant it sometime in January, the traditional thing would be sorry, I can't think of the word right now, because the baby brain, revoke or vacate the underlying decision. And then we'd be in a position where it was as if it never happened for a year, and the Federal Circuit and the PTAB, I assume, would have to keep issuing opinions in line with their constitutional duties while they waited to hear the case.
And I think,
Go ahead.
so, no, I was just going to interject. I think
If they vacated.
But the PTAB has been issuing decisions, right? So we had actually, we had a conference yesterday, and the director spoke at the conference. Of course, he started with the elephant in the room, and he said, look, all of my unconstitutional judges, and of course he was joking, but he and someone said, when are you going to issue guidance? Because the PTO has yet to issue guidance in the Arthrex case, right? So everyone, the bar's waiting, and he basically point blank asked the audience, well, what guidance do you want? Tell me. From a practitioner's perspective, this has definitely been a sort of interesting 2 weeks because all of our clients have been reaching out to us, and the IPRs are in various stages. You probably came here saying, wow, we're going to talk about the PTAB, but the PTAB baby is in a state of array right now. But maybe, Eldora, I can ask you a question in terms of the pending IPRs. Do you see this decision impacting the institution decisions or cases that are pre-institution? Maybe we can start there.
I think they won't impact cases that are pre-institution or impact the institution decisions. I think the Arthrex decision itself viewed institution decisions as being acceptable and constitutional, given their nature. But and then as far as pending cases go,
you read my mind.
Yeah, when I look at what's happening with cases that our firm's involved in, the PTO's done nothing thus far, and it's just marching forward like it's the good old days.
Right.
We'll see how long that lasts, and I think we all know all of our clever colleagues are going to challenge this issue in every way possible for years to come.
Right. So, it was interesting. Again, the decision came down on October 31st. We had final decisions due in 3 of my cases the following week. So you're on pins and needles as to whether you should actually raise this Arthrex issue before the final decision issues, right? So any thoughts on that? It seems to me that the PTAB is issuing final decisions. It really hasn't changed its practice as to, in light of Arthrex. But Steve, any thoughts?
We have some good guidance, I think, from the TC Heartland case that was decided a few years back and how the Federal Circuit dealt with those issues. So I would say make sure not to waive that issue and act as fast as possible. I think there's some counter points to that, but what we saw from the various different panels and the petitions that were filed post TC Heartland, if you don't immediately raise it and preserve it, you're waived. And here, I think in the decision itself, there was some inclination that it was a jurisdictional issue that could be waived, so you need to be very careful about that.
Yeah, and subsequent decisions from the Fed Circuit, the ones that came out right afterwards seemed to, there was at least one that denied a remand request on the ground that it was waived for not having been raised in the opening brief.
So what are you recommending to your clients, to make sure to preserve that issue, or?
Yeah, and I would say, even if it's not in your opening brief, still preserve it, because, you can challenge everything. That's what
Right, and
lawyers do.
I guess we'll probably have Supreme Court review potentially here too. So these days could be there for a while in some of these cases to the extent the Federal Circuit grants those.
I have a saying at Unified, or I have a saying, I should say, because, it's ABM, anything but the merits. It's like the PTAB, you're supposed to be talking about 102 and 103, and if the other side has great arguments, that is what they'll talk about. If they don't, they'll talk about anything but the merits. And this is just another example of a case that's going to disrupt all these proceedings moving forward. If the court doesn't grant en banc, the outfall or the fallout will be limited, right? There's a couple of people that have done studies, RPX, where Steve did a study that I thought was helpful that said it'd be 207 potential cases. Smith and Nephew said in their opening brief upwards of 160, but that's not, those are all cases where all we're talking about is a potential remand for a new panel, and that could be resolved relatively quickly in 3 to 6 months, and it would be a blip on the radar. That's if it's not granted. If it is granted, then yeah, it's going to be a huge distraction for 2 years. And it's like every year when you wake up in PTAB practice, you're like, what non-merits based argument will I be talking about on the panels like this year, right? Like 1 year it was claim construction, then it was oral arguments, then it was panel stacking, then it was, Seventh Amendment. And I'm sure down the road, I mean, retroactivity is still out there, takings clause stuff is still out there. There are a lot of very creative people in this bar that seem to want to do anything but talk about the merits. So I think that's where we are.
So one takeaway from this panel for the law students in the room: pay attention in your con law class and admin law class.
Admin law in particular.
But no, in all seriousness, there have been a lot of issues. It's been an eye-opening for me as someone who practices before the PTAB all the time. The number of administrative law issues that we are seeing in these cases, whether it's this issue or a different issue. I guess just one last question on Arthrex, because I do want to try to move on to some of the other issues that we want to try and cover this morning, is how is the PTAB, in your view, deal with cases that are being remanded by the Federal Circuit? So, for example, the Arthrex case is clear, right? Obviously, it's going to go in bank, so the PTAB doesn't need to really do anything. But right there, the court said, PTAB, you need to assign this to a new panel and have a new hearing, right?
Right.
But there are obviously other cases that are sitting right now at the PTAB that are on remand. Any thoughts on that as to what should happen or what the PTO might do with those cases?
I know some folks have wondered whether, like, if you have a case that's post-final written decision, but you haven't yet appealed, can you just go ahead and ask the PTAB to remand the case right then and there for a new panel?
People have against us.
Mm-hmm.
There's one party that in all of their matters, one firm in all of their matters has asked for an out-of-time rehearing request, which has been denied, as my understanding, across the board, and has sent a letter to the solicitor's office. And everyone's response has been just file your notice of appeal, which I think is the most practical thing, right? Like if they just have to file their notice of appeal, the Federal Circuit deals with the whole issue all at once, as opposed to the board somehow trying to fashion some sort of relief in the interim that could change next week or could be wrong next week. So my understanding is that that's happening for those cases, but in terms of remand, there's no clock on the board for remand cases or for requests for rehearing cases. There's no statutory clock.
But their SOP is 6 months
They say
from
6
mandate.
months.
Yeah.
Right, but there's nothing preventing them from delaying cases that are in those gray areas. There's nothing statutorily preventing them from delaying.
Agreed.
And they have in rare cases already delayed them 9 to 10 months for SAS issues or other issues as well. So I could see cases that get stuck in the twilight zone to sort of stay stuck in the filter until the Federal Circuit deals with some of these issues, but we'll see.
But I assume the PTAB's going to wait to see if the en banc rehearing is granted.
Sure, yeah.
Before they do anything.
Yeah.
And typically, not getting into the nitty gritty of how the Federal Circuit goes about the numbers needed to grant a rehearing en banc, usually in a 3-0 panel decision, that's a very hard case to get to be heard en banc. So just from prior rehearing petitions, you would say, given it's 3-0, the decision's 3-0, it'd be very unlikely that it would be granted en banc, but who knows?
Yeah, and I guess here we have, if you look at, it's 12 active judges, 3 are already that issued the decision, and 2 have indicated they have an issue with Arthrex, so it's 7 out of 9 they need to get rehearing. So we'll see what happens, right? We'll find out. But before I leave Arthrex, I do have to ask this question, is how does Arthrex, do you feel, impact any of the other agencies? Or how could it impact any
or
of the
other parts of the PTO, like
Sure,
examiners
TTAB.
or
Right.
or re-examiners?
Any thoughts?
I will say this, as an adjudicator, these issues are not issues that patent folks are often well prepared to present. And that puts us at a disadvantage. So I would encourage you to be up to speed on these issues, because they really are, patent law is administered by an administrative agency, the PTO. The ITC is an administrative agency. And I need the very best briefing I can get on these issues. So I really look to all of you to be studying and keeping up to speed on these things and helping prepare the best record possible. The other thing I would just, as a counterpoint to Jonathan's very tactical maneuvers and things about anything but the merits. The people in this room are the people that are thinking about the future of patent law and policy in the United States. That's the title of this program. And we should be thinking about how this system works from an administrative perspective. And if you're happy or not happy, or if you think patent judges should be able to be terminated rather summarily or not, you have a role in shaping this system. But you need to be an informed part of it. So I think we all have a part to play in it.
Well said.
Okay, with that, let's move off of Arthrex. I have a feeling we're going to come back to it at some point during this panel, but let's go to another topic that's been pretty near dear to my heart, that I've seen the PTAB use quite a bit over the last 12 to 18 months, and that has to deal with the PTAB's use of its discretion to deny petitions under sections 314 and 325. So maybe, Eldora, if you could kick us off, perhaps we could start off with 314 and the General Plastics case. Just maybe give us your thoughts on how that law has been developing over the last, let's say, 12 to 18 months.
Sure. I have to first say, I'm really thrilled to be back here at Georgetown, because I'm a Georgetown law alumnus, so it's great to be here again, like Judge Cheney. But secondly, I think the developments that we've seen at the PTAB, particularly when it comes to the use of the PTAB's discretionary authority, have generally been welcome changes to help bring more predictability and more clarity and, frankly, more balance to the system. At least that's how I think many stakeholders see it. And I credit Director Iancu a lot for the efforts that he's brought to bring more clarity and predictability to the system. With respect to the PTAB's discretionary authority, it's something that they've had quite really all along, but have been more direct and open about using it, as reflected by the General Plastic case, where the PTAB identified various factors it would consider when deciding whether to grant multiple IPR petitions, including things like whether the petitioner knew about the art that was asserted in the later petitions when they filed the first petition, or whether there was a good reason for them filing multiple petitions. Perhaps the good reason is based on some action that the patent owner took, perhaps late assertion or assertion of a large number of claims in litigation. Or perhaps the multiple petitions are needed because the petitioner is making an argument based on alleged priority dates and needs to make multiple arguments based on multiple pieces of art. And of course, the timing of the filings of the petitions are important to maintain fairness. Are the follow-on petitions filed after the patent owner's preliminary response or after a decision on institution, such that the petitioner can use the earlier briefings or decisions as a roadmap to fixing sort of defects in the petitioner's original petitions. And so we've seen in a number of cases where these general plastic factors have been applied and used to deny follow-on petitions. In a set of cases, the use of this discretionary authority under 314A is quite interesting. And these are what we call the Valve Corp cases, Valve Corp versus electric scripting products cases, where Valve Corp's petitions were denied because they were really follow-ons to earlier petitions that a similarly situated co-defendant, HTC, had filed against the same patents. And so even though Valve Corp hadn't filed the earlier petitions, they, as co-defendants in a litigation with similar interests to the original petitioner, those original petitions were essentially counted against Valve Corp's later petitions. So it shows that the Patent Office was looking at this fairness issue from really a broader perspective. And some of these issues regarding fairness are reflected in, fairness and predictability are reflected in recent updates to the trial practice guide. So the recent updates from the summer in the trial practice guide actually go to a number of issues. And on this issue of multiple petitions, now petitioners who file multiple petitions now need to rank their petitions for the Patent Office and include a short summary explaining the differences between their petitions, a 5-page summary explaining the differences between the different petitions and ranking them, which I think I can understand why the PTO would want that in terms of helping the office decide which petition or petitions, if they're going to institute multiple ones, which ones should they institute trial on. And it seems to have had an impact on the willingness of the Patent Office to grant multiple petitions. We seem to see a decrease in the number of petitions multiple petitions that they're granting these days. Just quickly, a couple of other key features of the updated trial practice guide are, of course, putting into the trial practice guide the new claim construction standard that the office switched to, going from the broadest reasonable construction to Phillips, which they implemented last year in November for new petitions, but now it's part of the actual trial practice guide. And then I think another important development would be relating to motions to amend. So the Patent Office has developed an optional pilot program under which if a patent owner wants to file a motion to amend, they can seek preliminary guidance from the office as to whether their motion to amend meets the regulatory requirements for a motion to amend, as in not broadening and only a one-to-one substitution of claims, but also get guidance on the merits of their motion to amend. And we've seen some of those guidance documents come out from the office. And this new practice also allows the patent owner to submit a revised motion to amend if they want after receiving the preliminary guidance. So we'll see if it actually leads to an increase in the number of granted motions to amend. I think it's a little too early to tell just yet, but it's at least a step in the right direction from at least patent owners' perspectives.
Thanks, Eldora. That was great. So Jonathan, maybe we heard the patent owner's perspective on discretionary denials. Maybe you can give us the petitioner's perspective on discretionary denials.
Sure. So I've been saying since before General Plastics that the director had absolute discretion at institution under 314. There's a great opinion by Judge Oberman that was precedential back in 2014 or 15, I can't remember, that said that explicitly. And they've always been able to consider whatever they want under the director's discretion in institutions. So I think it's interesting that parties are starting to get creative. Edor did mention this, that the behavior of the patent owner is just as important for the director's discretion as the behavior of the petitioner is. So the nature of the patent owner, if the patent owner is a non-practicing entity, that would be fair game, right? If the patent owner is bringing abusive litigation serially so that its parties are forced to bring multiple petitions because the windows are closing, certain people are being strategic about the way they're presenting them, and also the amount of damages they're asking for, what's happening in the district court, all now, because the world is open at institution, play into whether something should or shouldn't be instituted. And the other thing I'll add that I think is important to point out about the revised trial, and there are parties arguing that, Microsoft has a couple of really interesting petitions where they have pointed out that certain serial litigants that have a lot of petitions filed against them, it's almost required because they stagger their filings in district court and they make it so that they're basically trying to evade PTAB review by any group of parties so that it can't really be done efficiently. And so the behavior of the patent owner is what's leading to the multiple petitions. And I think all of that is on the table, and all of that is relevant after the updates to the trial practice guide. I will also add that the agency was clear that the merits are part of that discretion. So if there are strong merits, they would outweigh weak policy factors in the discretion to institute. And if the merits are poor, they might, even if they're 51% likely to institute, but there's some things that tend to suggest that they should deny it, they might deny it for that purpose too. So I consider this all part and parcel of their entire discretion at institution to do what's right for the patent system and do what's right for the economy. And that's not just focused on the attention of the petitioner or the patent owner. It's focused on both parties and basically the entire universe.
So if you're a petitioner, right, let's say this happens all the time, like you said now, where you have a patent owner, let's say company ABC sues company right D and then company E, but they are staggered by 6 months, let's say, right? And both company, both of the companies that are sued, they of course want to see it at the patent office, right? From a IPR perspective, let's say. What advice would you give to those companies under the current regime to try to get institution at the PTO in light of what's happening under Section 314?
Well, so to Judge Gilstrap's point earlier, I think the earlier in the life of the district court that parties can file their petitions is better for everyone. It's better for the judges that are trying to consider stay motions, which, by the way, John, are overwhelmingly granted. It's like 60 or 70%. It's not unlikely, like you said earlier. But also, and we've been doing this since before, everyone who is a petitioner should know that this is a question or an issue. If they're not the first filer, even if they are the first filer, they should be putting in arguments up front, because they shouldn't ever be in a position where they have to ask the board for permission to talk about things they didn't talk about in their petition. So we, for a long time, have been saying, we're almost always the first filer, but if we're not the first filer, this is why the factors aren't met, and this is why factors outside of the factors don't matter, and this is why, under your discretion, you should institute. And moving forward, I think it's not only fair game, but it should be encouraged that petitioners discuss the nature of the patent owner itself, if it's relevant, or the nature of the patent owner's behavior in litigation, if it's relevant. Because if the agency can consider the policy implications of the petitioner, there's no reason why they can't consider the policy implications of the patent owners as well.
So I guess let me ask you the question maybe differently. I mean, that was helpful. It almost seems like now we could be in a regime that it's sort of raised to the patent office, right? If you're the defendant or defendants in litigation, it's a race to the patent office at times. And is that really what kind of the system that we want from a policy perspective?
Not necessarily, and I understand that there are parties that want to take their time and do everything right, but in the interest of efficiency and expediency, I do think that getting to an answer sooner, even though it goes against the instinct of every single lawyer in this room, is probably better for the whole system, whether that answer is positive or negative, right? Whether it's a denial of institution or an institution and the claims survive, or it's a stay of the district court litigation or not. I think that earlier is almost always better for the U.S. economy, because litigation itself is one of the sort of least efficient means of resolving disputes. The more the parties can resolve those disputes earlier, the better.
Another way, I was just going to mention, another way that the timing can come into play is we've also seen instances where the PTAB has denied institution because the parallel district court litigation would reach trial before the PTAB would reach a decision. And I think that's been the exceptional case where they've denied trial on that basis, but it's definitely something petitioners have to be aware of.
I was actually going to ask Steve about that. Steve, what are your thoughts from a district court practitioner perspective? Let's say you're representing a defendant in a litigation and you're faced with this, and you're in one of the districts where time to trial is maybe as fast as how the PTAB will handle the case, or how fast the PTAB is going to handle the case. What advice advice would you give to your client in that situation?
It's okay to say, come to the ITC.
Yeah, go to the ITC. So this is a fascinating issue, and I think it raises a related issue, and I don't want to jump around on our agenda, but maybe this is a good point to bring up, is really the change that Adora talked about earlier from the broadest reasonable construction back to the Phillips standard for claim construction at the Patent Office, and it directly impacts strategic considerations of when to bring petitions. And so what do I mean? So just last year, November 13th, there's a new rule went in effect at the PTAB that claims now are going to be construed under the Phillips standard. The Phillips standard, of course, being the person of ordinary skill in the art, looking at the claims through the intrinsic evidence, and what's the ordinary meaning of that term. On the other hand, the PTAB had for years been construing claims with the broadest reasonable interpretation of the intrinsic evidence. And so now you're going to have more unification between the two. On the one hand, how the PTAB construed claims in the district court, theoretically. And so before, what would happen, and this is a very good detour to take, before what would happen is if you're the petitioner, you run in as fast as you can, as early as you can. As Judge Gilstrap said, he'd rather see the petitions filed early, but you would run in early, hopefully you'd get your institution decision, and then run the district court and get it stayed. During that proceeding, you wouldn't have to worry about how broadly you construed the claims. You'd have almost impunity, get out of jail card, if you will. Why? Because I have a different standard. I'm applying the broadest reasonable interpretation so that if I lose as the petitioner in the PTAB, I can go back in front of the district court and now come up with completely new constructions that are much more narrow. And of course, the patent owner would be frustrated, understandably so, and say, well, this isn't really fair. But the rejoinder that usually wins the day is, hey, they're different standards. One's broader, one's under a different scheme, and one's more narrow, so you can't give this any sort of even persuasive effect. And that generally works in the district court. Now, given that they have the exact same standard, it puts a huge premium on knowing your district court case. And this goes to your question, Naveen, directly. So I'm the defendant, and it impacts the patent owner as well, but I'm the defendant, and I have to know my non-infringement positions in more detail earlier. Why? Because if I run to the patent office and I have sort of half-baked constructions that later on may hurt me on my non-infringement positions, I'm going to be in big trouble. No longer can I come back to the district court and say, hey, we're under two different regimes, two different claim construction standards. So it puts a big premium for me to see what the plaintiff is doing in the district court in terms of claim construction, how I'm going to attack my non-infringement positions. And it has an impact on like I said, on the patent owner as well. So it has big strategic implications. And what you see is more filings, I think, later in cases, and that could impact the stays, because you want to make sure you know your positions both from a claim construction position and non-infringement before you run off to the PTAB now. Because the worst possible position you could be in is you lose the PTAB decision, and then you're back in district court and you're stuck with a very broad construction. You're stopped, and now you don't have your non-infringement positions. So we haven't seen this play out. It's only been about a year or so, and I think what we're seeing is there's much more strategic consideration of when to file IPRs, and in terms of the calendar of a district court case. So I think it's a big, it remains to be seen. Most people looked at the issue, the BRI and the Phillips issue as, oh, now we're going to have substantively different decisions be given the standards. I think in some cases that is true. I think those are limited cases, meaning because if I apply the Phillips standard, more patents would survive, right? That's the theory. That has, I think, when you look at some of these cases, I haven't seen a great study on it. Very few times does it really matter. Again, the impact is more on when to file, how to file, and really being in a tough bind on the district court side if you lose the PTAB decision. Before the IPRs were almost separate, isolated, collateral, although parallel proceedings. Now they're much more symmetrical with the district court, and you have to have much more integration between the teams than you did, say, a year and a half ago. So, Eldora, do you generally agree with that, or?
Everything you said is absolutely 100% correct, as always.
And
Wow, I got to record you for my wife.
Sure, I'll give her a call.
sorry, go ahead, Judge.
I just want to be on Eldora's team now.
What I was going to add is that it's interesting from a PTAB perspective. Again, the director spoke yesterday, and he said statistically, the number of petitions that have been filed over the last year actually have gone down, leaving aside sort of the spike they had right around the rule change. So I think this change to Phillips, and he said, I think some of this is because of the change to Phillips, that they actually have seen for the first time a decrease in the number of petitions being filed at the Patent Office. I guess, Judge Cheney, maybe a follow-up question for you. Steve talked a lot about the district court and kind of the interaction between the PTO or the PTAB and the district court. What are your thoughts on claim construction by the PTAB and how you look at those when they're presented to you, let's say in one of your cases at the ITC, and so it'd be great to get your thoughts on that issue.
I don't have a lot to say on that. The ITC has always applied the Phillips standard and the law that led to the Phillips standard. Occasionally in the past, someone would argue in favor of a stay at the ITC pending patent office proceedings, and a counter argument to that would be, well, the patent office is applying a different claim construction standard, so we shouldn't stay the ITC proceeding. So it does take that argument off the table, but for any ITC practitioners in the room, you know that you're still not likely to get a stay at the ITC. And the difference in claim construction rarely comes up because the ITC is usually the first to trial anyway. So it doesn't come up that often.
So I guess you would say that you probably see more of an impact going the other way, right? So that you have a claim construction order that you've issued, and a party should put that in front of the PTAB.
I have heard requests for our record by the PTAB. So sometimes parties do want a claim construction order or a final determination from the ITC to be part of the PTAB record. I'm not involved in those, but I've heard that it happens.
Jonathan or Eldora, thoughts on that in terms of what have you seen, whether it's from a district court or the ITC? Let's say you have a claim construction order. How do you handle that in front of the PTAB, assuming, let's say, you haven't filed the petition or the petition has been filed?
Yeah, it's come up in a handful of our cases. I would say it's the rare case that another tribunal has spoken, and when they have, if you're not giving it a substantial amount of practical deference, then you're not going to win that argument probably. I mean, I always thought that the PTAB, even before the change in standards, sort of did a really good job considering even non-final claim construction orders from district court judges that hadn't gone all the way up on appeal as effectively binding. I mean, they didn't say that, but we had a case or two where the district court judge spoke and we kind of deferred to the district court judge, because what are you going to stand in front of the PTAB and say the district court judge was wrong? So to me, the practical upshot of this is that for law students, there's like a few cases where there's like a direct conflict that's going to happen, and those cases are going to get peeled up, and there's going to be a lot written about them and all that. But for the majority of the tribunals below, there might be one other order or one other finding, maybe the PTAB ruled at institution before the case settled, or there's a final written decision that hasn't gone all the way up that you need to consider. And so far, at least in our cases and in others, both the lawyers and the tribunals seem to kind of be deferring to whoever spoke first. That's just how I see it.
So to answer your question, Naveen, we've put the district court claim construction in front of the PTAB in various situations. And in one case that we have, the PTAB came to a broader construction than the district court did, even though it was on basically the same record. That case is on appeal, so I'm going to leave it at that.
Okay, so the Federal Circuit will decide.
So Naveen, I think the practice pointer is if you like your construction from the district court, then you want to get it front and center in front of the PTAB judges. And if you don't like it, I think you still have to address it. But instead of a full frontal assault, you may want to tweak a particular piece that you don't like. And we're generally keeping the construction, but we think it needs to be tinkered right here or right there, as opposed to trying to create this conflict or really position it that way.
One practice point I would say to your second point is just, if you don't mention it to the court or you don't
Right.
put it in a notice, that's the only time I've seen the board really get angry at a party. Like, there was a claim construction order and you didn't tell us about it, like.
Well, someone's going to raise it. One of the parties is going to raise it. So you need to address it regardless.
Sooner rather than.
And I guess, the other issue, Steve, you made this point earlier, which is that if you're a defendant in a litigation, right, where you're looking to file an IPR, and obviously if you want to get a stay, you want to get that IPR on file as quickly as possible. And before the PTAB, you really don't have a claim construction hearing, right, as you do before the ITC and in district courts. So how do you deal with that, sort of not having the ability to argue claim construction before a judge and sort of have separate briefing? Any thoughts on that?
I mean, I would say you have the ability to argue it. It's just not a whole separate event the way it is in
Fair
district court.
But so how do you deal with that? Obviously, you have to, I assume, right, you deal with it at the petition stage. Any practice pointers on that?
Do it all along the way. If you're patent owner, do it in your POPR, do it in your SIR reply if you get one, do it at hearing, keep making your argument.
And be consistent.
Right. And logical.
Yeah, I mean, I think petitioners are forced to be mind readers a little bit because they don't know what tribunals are going to comment. And so if there's plausible constructions, they should be offering alternative positions in their petitions. I mean, it's sort of the nature of the way that the board works that you kind of have to have something in the petition to point back to. And if you haven't raised a claim construction position or how the art reads on a claim construction position that might get adopted, then you'll be up a creek later on in the case.
So I want to raise a related issue in terms of overlap with district court, and that is, and the ITC estoppel. Can we talk a little bit about estoppel? Let's say you have a final written decision now from the PTAB. How have you seen estoppel playing out at the district court and at the ITC? Maybe Judge Cheney, we can start with you on that question.
Sure. The IPR statute imposes an estoppel on petitioners, and they are stopped from asserting arguments that they raised or could have raised at the IPR proceeding in other district court proceedings or at the ITC. And the ITC is particularly mentioned in that statute, so the estoppel applies to us. I was very interested in the BTG versus Anil Pharmaceuticals case at the Federal Circuit earlier this year, where the question of whether the estoppel prohibits a party from raising successful arguments at the PTO at the district court was before the Federal Circuit. The Federal Circuit actually deftly avoided reaching that question. But it was interesting to me that the government in that case contended that the estoppel should be read very strictly and is a personal estoppel and should apply to affirmative arguments that were persuasive to the PTO. So we don't see this very often. Mostly, again, because the ITC were going to trial within 9 months of filing your complaint. We're usually the first to cross the line anyway. And so we just don't see it that often. But it does seem that the government is construing the estoppel to be personal and quite strict.
Jonathan, Eldora, Steve, any thoughts on estoppel?
Well, I think the judge hit the practical point that given the speed of the ITC, that it's unlikely to be a big issue at the end of the day, but it would be fascinating to me, given that the joinder provisions of the AIA don't apply to the ITC, where you have a big joint defense group. Typically, you have it's usually handset manufacturers, you have chip makers, so you have 5 or 7 parties. One files an IPR, they may be stopped, but you're in the same investigation, and then the other 6 raise the yard anyway. So it'd be fascinating how that would play out, but I haven't seen a case that addressed that, and I think in large measure, we probably won't, given the speed of the ITC.
Okay, let's move on. I know we're sort of running short on time, and I want to try to leave some time for questions from the audience. I actually want to try and maybe cover at least one ITC-specific topic, and that's sort of if I can call it, the rise of trade secret litigation at the ITC. So maybe, Judge Cheney, we can start with you on that, and hopefully you can elaborate on that point for me.
Wow.
And maybe I oversold it, but you'll correct me.
Oh, it's more interesting.
Since 2013, there has been a 400% increase
So I was right.
in trade secret cases at the ITC. We are swimming in trade secret cases. Well, that 400% increase is that for most of the ITC's history, we had 1 trade secret case per year. And in this last fiscal year, we had 4. Now, that doesn't sound like a lot, but it's a good chunk of our total docket, and it's a very good chunk of total trade secret cases that go to trial in the United States. So the ITC is looking at trade secrets at least as much and maybe more than the average tribunal in the United States, and more than most. It's an area that has long been part of our jurisdiction, and we have I think, some good expertise in deciding these issues. The ITC has robust pleading requirements, so we get the issue on the table early. That's often a big barrier in district court litigation, even in districts that have patent-specific rules. Getting the plaintiff to identify exactly what the trade secret is difficult, and plaintiffs often have a strategy that we'll tell you when we see it in your discovery, right? But the ITC, we have some very detailed pleading requirements, and it consequently makes for organized and very timely resolution of trade secret disputes.
That's helpful. And is it really the timing factor, you think that's one of the reasons why companies are going to the ITC for trade secret disputes?
It's timeliness, and it's also, I think, the long hand of the ITC in evaluating unfair acts that impact U.S. imports. And one of the leading cases on this point was from the ITC to the Federal Circuit, the Tian Ray case, decided in 2011 or 13, 2011. And one of the arguments raised in that case is, well, the ITC shouldn't have jurisdiction over the stealing of a trade secret that occurred in China. And Judge Bryson, the learned Judge Bryson, who I clerked for, explained that this is not actually extraterritorial jurisdiction, because we're talking about imports into the United States. This is our territory, the territory of the United States. And we have often looked at what happens in other countries when it comes to trade in determining whether the trade practice is unfair. After all, anti-dumping or countervailing duties are all about what happens in the other countries and the prices charged and things like that. So there is an aggressive remedy available at the ITC that maybe other tribunals would be less enthusiastic about addressing.
So one of the takeaways is go to the ITC. So another sort of topic, I think it's sort of a gating factor for the ITC is the issue of domestic industry. I know I litigated a couple of cases at the ITC, and that's always in my mind has been a very, very interesting issue at the ITC. So can we kind of go through that? And I feel like over the last decade, the domestic industry law has developed. So maybe again, Judge Cheney, if you could give us your thoughts on that in terms of the development of the domestic industry case law over the last decade, that would be helpful.
So the Commission had a domestic industry common law or course of practice prior to 1988. And in 1988, the Congress enshrined that practice in some amendments to the Tariff Act of 1930. And what we call the domestic industry requirement uses very broad language like a significant investment or a substantial industry. And when Congress uses words like significant and substantial, those words beg for facts. And consequently, the ITC's domestic industry jurisprudence is very fact-specific. So there is not a lot that I can say other than that. And in almost every commission opinion that you read, the commission will emphasize that on the facts of this case, here is how we view the domestic industry. And that is as it should be for a statute that deals in trade policy, especially trade policy that is directed to the domestic industry. Other folks probably have other reads on the tea leaves, but that's what I'm comfortable saying.
That's fair. And then maybe I'll ask Steve or Jonathan or Eldora, from a practitioner's perspective, how do you feel things have changed in terms of proving domestic industry, if any, over the last, let's say, decade?
I'll take this one first. So I think it has been a stricter requirement over the last 15 years. It has been applied, I think, on a case-by-case basis when you look at them much more stringently than it did, say, 15, 20 years ago. I think from the practitioner's perspective, if you're a complainant or a prospective complainant, the biggest takeaway now is to make sure you have your entire domestic industry case ready to go when you file. If you don't, the judges will crucify you because their thinking is, rationally so, that this information is in your possession. You voluntarily filed in this forum, and so you should know your domestic industry case very well. And so when you file, you have to typically you have a declaration from someone in your company that testifies and declares about certain expenditures that are related to the patent and the product, the domestic industry product. Those have to be pretty airtight when you're ready to file, and you have to usually you have to apportion. That's been a big requirement over the last 8 to 10 years that we've seen. No longer can you say, I have a plant in Ohio that makes the domestic industry product is covered by my patent. Now you have to really go through and from almost like a cost accounting basis, how much square footage is allocated to this particular product or patent. So it puts a premium on being ready. It puts a premium on being detailed and really preempting a lot of the attacks that are going to be made on you pretty quickly. And you're going to be asked for that discovery. So you put a declaration in, and the ITC, as soon as the investigation's instituted within, I think it's 10 or 14 days, you're going to get served. Right then, you're going to get served with discovery, and you're going to have to respond pretty quickly. And the domestic industry discovery is going to be expected to be given over to the other side less than a month. I mean, you have very little time to maneuver there. So you have to be ready going forward.
I'll just say once again, I agree with Steve, and I'll add that words like substantial and significant, I think, not only call for facts, they call for litigation. Those are like prime targets.
So Jonathan, maybe last question for you, and then I want to open it up to the audience.
Can I just add one more thing?
Of course.
While those words do call for litigation, people might be surprised that in many, many cases, the domestic industry is stipulated. And it's often decided on summary determination. Often the facts are just very clear that there is a domestic industry. I would say maybe even half of my cases that occurs.
So last question, Jonathan, maybe you can address this quickly. There's some talk in the policy circles about refining the definition of domestic industry. Can you elaborate on that for us and give us your thoughts?
Sure. Well, I mean, I think that the ITC policy is always a little bit amorphous, right? But the ITC's goal is effectively protectionist, right? It's to protect American industries and American companies from unfair trade practices at the importation stage, right? And for a while, the ITC was used through very creative arguments based on licensing practices and on certain people licensing this, that, or the other to sort of establish domestic industry. I think that the case law has pulled back on that a little bit, but I think there's still a fear that parties could sort of manufacture domestic industry as the law currently stands. So my understanding is that there's, particularly under the current administration, there's always an interest in strengthening our protections for US-based trade with others. And if there are unfair acts happening and there's no other way to reach them, it should be a forum that's reserved to companies that truly have a domestic presence.
So I find this fascinating, Jonathan. So I teach a class at Mason, and I'm a GW grad, so I feel like I'm a little bit in enemy territory. But thank you for welcoming me.
American over here.
Yeah, exactly. So this is fascinating because when I talk to students about it, we go back and forth on the policy implications about letting foreign companies into the ITC and so forth and so on. And at the end of the day, what is the ITC designed to protect as a trade forum? Really, when you think about it, it's in its simplest forms, it's designed to protect American jobs from unfair competition, right? And that's, if you look at it through that prism, I think some of this legislation may be a little bit misguided because what's an American company? What's an international company? Toyota has 65,000 jobs in Tennessee. Do we want to say Toyota can't have a domestic industry now? So it raises fascinating issues as companies become more international, that they have many more, different headquarters and activities. And so I think it's still going to remain. I think it's going to be tough to get that legislation through, given that there's a lot of technically foreign companies, non-U.S. companies with huge presence in the United States, both in terms of manufacturing and particularly employees.
I will say that we looked at this just in terms of PTAB data, and it's very difficult to determine. It depends on your definition of what is a U.S. versus a foreign company, right?
Right.
Because they're so intertwined. But yeah, I take that point for sure.
Yeah. Be interesting.
Okay, with that, we will take any questions you have for the panel. Okay, looks like you.
There's one.
Well,
Come on up. And why Christopher, of course you may, but Mr. Dorman, I'm going first. So if I may, no, come on. So come on up to the. It's a former student, Federal Circuit clerk. Thanks for coming back, Christopher. What is the impact of Federal Circuit developments on PTAB hiring and retention? So I think all of us, or many of us, were favorably impressed by the caliber of individual who advanced to the PTAB. Many of these individuals have taken pay cuts of 50 to 75% to enter government service. Part of it is the mission, but I think part of it is stability of employment. That's been taken away from them. Do you anticipate any sort of staffing or retention issues, or do you think I'm overblowing that?
I can start with that because it kind of came up yesterday. The director was asked a similar question. And I think from his perspective, or I think from the PTO's perspective, and certainly from my perspective, I don't see it because the PTO does need all these judges. Because remember, there's the AIA side. We always talk about the IPRs, PGRs. We actually never talk about the ex parte side of the PTAB or the PTO. And they have so many appeals pending that they need all these judges for. So at least from my perspective, I don't see an impact. Perhaps maybe there will be, people will think twice now before they go to the PTO to the extent they need to, they have a job opening and want to apply. But from my perspective, I don't really see it.
And by the way, I want to make fun of the two gentlemen taking their coats off in the back. So Professor Sarnoff from DePaul and Professor Karstedt from GW have just showed up. That's the way they roll right before lunch, I tell you. So
That's academics. You give them free food.
There you go. I'm sorry.
Yeah.
No, any other thoughts? I mean, those are my thoughts.
It's all kind of evolving, and I'm sure that the judges themselves don't like the protections being removed. But my understanding is that it went from them being able to have a lawyer and have like a 30-day period where they're being reviewed when they are removed for a type of cause, to not having those procedural protections. I'm not sure that it's going to make that much difference unless maybe there's a director out there that wants to come in and fire 100 people like Josh Malone suggested that we should do the very next day. But I don't personally see it. I don't know. But I'm sure some of the judges probably feel differently.
There's a question from Christopher Dorman. Please step up to the mic.
Similar question. I was wondering what you were talking about with strategy changes with the claim construction standard changing at the PTAB. Do you perceive that if the administration were to change and the directors change, that could be something that changes every 4 or 8 years? And
I hope not. I mean, I was an advocate for BRI. I was a former examiner. I think it makes sense. But the director's discretion is the director's discretion. So if he has discretion to change it, he has discretion to change it back. I hope to God he doesn't. I was talking to companies last week, and all the companies, particularly the companies that are not really lobbying a lot. So a guy from Seagate said, look, all I care about is my bottom line and knowing what to do. So tell me, he was talking about 101, but he was sort of like saying, tell me what it is. I don't care. I just don't want it to change. And we here in Washington love to change it, and we love to freak out, and we love to talk about it. But that costs money. And personally, the bell's been rung. I hope it doesn't get unrung at this point, but it could.
Are there other questions? Friends, we've always had a lovely experience with this conference. I think we had 2 fabulous morning panels. So let me thank our colleagues here for coming up. Now hold on a moment. We've had a great experience, except for lunch, I have to say. We used to have this lovely lunch in the atrium of our library. Do you remember some of the repeat players here? Yeah. And a few students complained that they were studying and that we were too noisy. And to be honest, I never see any of my students studying in the library. That's all. So I think that was oversold. So now we started having lunches here. And last year, our caterer sort of underserved a little bit. So we have a new caterer. And apparently, the new caterer is now on main campus of Georgetown University, driving around asking where the law school building is. All right, so the lunch is on the way. I tell you that's going to happen.
We can keep talking.
Yeah. Why don't we just take a break and we'll allow you to mix and mingle, and there'll be more word from the lectern. All right, so thanks for your patience. The food's coming. All right, we'll see you in a bit.
Yeah, pleasure.
Okay, so again, thank you for bearing with us over our little bit of lunchbox drama. We are glad that you were all fed, and that we're joined today by Commissioner Slaughter. As you can see from your program, we were originally going to be joined by Commissioner Phillips as well. But unfortunately for us, but happily for him, he's had a major life event, the birth of a nephew that he is up in Boston celebrating. And so he is not with us today. It was going to be a fun former Senate Judiciary Committee staffer reunion. Commissioner Slaughter and I served on the Judiciary Committee together with Commissioner Phillips as well, when he was working for Senator Cornyn, when Becca was working for Senator Schumer, and when I was with Senator Leahy. So we almost had the full reunion.
We still have
pretty good. And we have Caroline Holland, who was with Senator Klobuchar, is with us here too. So we're doing pretty well in terms of the numbers. Okay, well, I'm so thrilled that you're here to join us today and to have a conversation about the intersection of IP and competition. More than a few things happening at the FTC these days, and this is an important one of them. I thought I would start us out by talking about some of the pharma cases, and then we'll move into some of the other ones that are ripped from the headlines that I know people want to hear about as well. So in March, the Commission announced its final order against the generic pharmaceutical manufacturer Impax for entering into a reverse payment settlement that delayed the creation of a generic version of Endo Pharmaceuticals' opioid pain reliever. And I know that in February, the Commission announced its global settlement with Teva after protracted litigation. That was litigation that was pending in 3 separate federal court antitrust suits. I'd love if you could just start us off by talking about what the takeaway are from some of those cases, what trends you're seeing in the FTC's challenges and successes in the reverse payment settlement context.
Sure, and thanks so much for having me here. It is really nice. It's nice to be here with Alex and to see a lot of familiar faces of folks that I worked with on IP issues over the long time that I was in the Senate. Somebody asked me when I got here, does the FTC really have to do a lot with IP stuff? And it is the case that you wouldn't necessarily make that connection, but we have an enormous volume of cases that implicate intellectual property issues, particularly in the healthcare and pharmaceutical space, but certainly not exclusively in that area. So let me talk a little bit about some of the cases that you mentioned. So pay for delay or reverse payments cases has been a bipartisan priority of the agency for a very long time. These are generally cases, for those who are not intimately familiar with them, in which a generic drug launches to challenge a branded drug on the market, and then the brand sues the generic, and as part of the settlement of that litigation, the types of cases about which we are concerned are ones in which the generic agrees to delay entry onto the market in return for a payment from the brand. And the concern is that that is an agreement between the two companies to share the monopoly profits that the brand is enjoying at the expense of consumers. So the FTC has been challenging these cases for a long time, and there was a pretty active debate in the law about what the scope of the legal authority for the agency was in this type of matter. And the activist case, which was decided by the Supreme Court in 2015, settled the question of, were these types of agreements per se legal or per se illegal, by saying they are neither. They absolutely can be illegal, and they need to be analyzed under the rule of reason. So we need to determine whether the anti-competitive harms outweigh the pro-competitive benefits of any particular deal. Great, what does that mean? Is really the important question for us. So Impax was the first FTC case that really laid out the bounds of post-activist jurisprudence. And just a little bit of FTC procedure for those who are not in the weeds on that. Some of our cases we file in federal court and go through sort of standard litigation procedures. Some we file in our administrative tribunal, which we call Part 3, in which case there is usually a trial before an administrative law judge who renders an initial decision, and then the commission sits as sort of an appellate court and hears oral argument and renders a decision on an appeal of that initial decision by the administrative law judge. And so that was the stage at which this current set of commissioners entered activists. Also, for those not in the weeds on the FTC, we have 5 commissioners at the FTC right now, a full slate for the first time in a very long time, and all 5 of us were confirmed on the same day in the spring of 2018, and 4 of us started the next week, and the final one started in September. So we have a brand new full commission at the FTC for the first time in the history of the 100-year history of the agency. There haven't been 5 commissioners turning all over since the agency started. So one of the very first Part 3 cases we all heard was the Impax oral argument. And we issued a unanimous decision that was drafted by Noah, who is not here to talk about it, but I will tell you, I thought it was extremely well written and well argued. And in that particular case, what the commission found was that if we implemented the activist framework and found that here, Endo, the brand company, had made a large and unjustified payment to Impacts, the generic, in exchange for it agreeing to delay entry of any generic. And in that case, the nature of the payment was not, here's many dollars in cash. It was a promise that Impacts, or that Endo would not launch an authorized generic that could compete with Impacts' generic. And there was also an additional credit that Endo would pay Impacts in the event that the relevant market declined before Impacts could enter. So what the commission analysis found was, but for that agreement, Impacts could have entered, Impacts generic could have entered and created competition. And so the deal eliminated the risk of competition, and that created competitive harm, and it wasn't justified by any pro-competitive benefits of the decision. So the question is, how does this fit into the general pattern, and how is it significant? I think one really significant part of the decision, and let me first add that it's on appeal right now, so I'm going to cabin my comments to what the commission found in its opinion. This is an ongoing piece of litigation. Clarifying that no authorized generic agreements constituted a form of consideration, and payment is an important part of clarifying the law. It's pretty easy when somebody just delivers cash to say there's a payment, but there are lots of types of consideration that can flow from a brand to a generic that we need to look at and think about whether they similarly constitute a payment. And this is part of keeping our analysis fresh and in touch with evolving market trends. So I think that's a really important part of it. I think it's also important and significant that this continues to be an area of bipartisan focus and agreement. Antitrust isn't always as consensus-driven, particularly not right now. So I think it's notable and important that we stay that way in the reverse payments cases. And then the last point is that we have to keep paying attention to trends in the market. So we study every year how many of these settlements are entered into and what are the terms of the settlements. And what we're seeing is that there have been actually an increase in the number of patent settlements, which is interesting because we'd also heard lots of Sturm and Drang before activists that if reverse payment settlements were made illegal, then there would never be any settlements of patent litigation, and therefore generics would never launch at risk. And in fact, we're seeing an opposite trend. And I will just make a note that my very first week, maybe first month on the Senate Judiciary Committee in 2009, there was a bill that addressed pay for delay settlements that was being marked up, and I was on the receiving end of a degree of vitriol and passion from a generic drug company about how this bill and limitations on reverse payment settlements would ruin pharmaceuticals forever. That made quite an impression on me, at least in the nature of its passion. And so it's interesting that the market trends have not borne that out at all in the post-activist world. And it's also notable that only one of the agreements that we saw contained a side deal or a no AG commitment. So that also tells us that cases can settle without large and unjustified payments. And that's an important point to note. And then you asked about the Teva resolution. It was a global settlement because Teva, either through itself or through companies that it had acquired, so it was the legacy interest and was involved in many of these cases. And what the commission was able to achieve was exactly what it set out to achieve, which was a ban on or a commitment from Teva not to enter into these kinds of settlements, including explicitly banning no AG and no side deal statement. So that was a really important resolution to many, many, many years of litigation in lots of different cases.
Now, the AbbVie case, which was kind of in part of the Teva global settlement, has some remaining pieces of it, including an appeal of the FTC's allegations that one of the mechanisms of delay was filing sham patent litigation against the generic. Can you talk a little bit about that case and its current posture?
Yeah, so that case is on appeal right now. The FTC won. The court ruled excuse me. Alex was just talking about how she had a middle of the night train, and it was making me feel bad for complaining about my level of exhaustion and inability to form sentences because she is so articulate, notwithstanding having to spend the night on Amtrak. But I'm just going to apologize in advance because I have 2 children who are not sleeping at all. And that means I am not sleeping at all. And so full sentences are something with which I am struggling today. Anyway, the court ruled that AbbVie had used sham litigation to maintain its monopoly over the testosterone replacement drug Androgel, and it ordered a $448 million monetary remedy for consumers who were overcharged for Androgel because of the conduct. And that's the largest monetary award ever in a litigated FTC antitrust case. So that's a really, really big deal. The other thing I think that's important about that is, just as I said, we need to pay attention to market trends and evolution in pay for delay cases. If we make it clear that one thing is illegal, how is behavior changing to achieve the same goals through different means? We also need to pay attention to other ways companies are exercising market power to keep competition out of the markets. And sham litigation is a thing about which I think we are and need to be really concerned, using processes that are put in place to protect legal rights in a way that is illegally extending market power and limiting competition.
So in that bucket of thinking of current trends, I want to talk a little bit about the Reckitt-Benckiser case.
Yeah.
So in that instance, there were charges that they thwarted the creation of generic versions of Suboxone by product topping, which was developing a dissolvable oral film version of the drug. And then in part allegations that they were misrepresenting to doctors that the film was safer than the traditional historic version that was coming off patent.
Yeah, this concern is fundamentally that a brand company will protect itself from generic competition by moving patients from a drug that is facing generic entry to a different version of the same drug that doesn't have the risk of generic entry. And when you do that, certainly by misrepresenting the nature of the drug, that's especially concerning. In the area of Suboxone and opioid treatment, we have additional levels of concern about, manipulations of vulnerable populations. So this is another important trend that we're looking at. This is a focus for Congress right now, too. And it's another way in which I think everyone who has an interest in protecting patients and protecting against increased drug prices is paying attention to market trends and practices and patterns of behavior that might be illegally and anti-competitively extending monopoly power.
Now, one of the concerns that people talk about in light of these cases is it can be really tough to make that distinction between valid arguments about novelty or new discoveries as to safety and efficacy. I should say in the Reckitt case, there were criminal charges of fraud brought in West Virginia, so it's clearly on kind of a further extreme of the fact patterns that you're typically presented with. But how do you think about navigating that kind of tough factual balance to make sure that you're bringing these cases in the right instances?
Well, I think that's exactly right. And a lot of these are universes that don't operate with bright line rules. But that's true in antitrust generally, for the most part. We always have to look at specific facts, weigh the particular circumstances, consider exactly what the behavior, the market power, the implications, the harm looks like in any case, much to the chagrin of folks who are trying to put together cases to bring in court, because the burden is really high on the government. And that's what I think about all the time as the appropriate and important, but sometimes quite frustrating check. If we want to challenge a practice and we're operating in a rule of reason universe, which most of these cases are, we not only have to show that there are anti-competitive harms, we have to show that they outweigh any pro-competitive benefits that the parties might assert about the transaction, and a pro-competitive benefit in the pharmaceutical space certainly could be improved quality, improved innovation, moving patients to a better drug. So I think you really have to look at the particular facts in any case before you can make a conclusion about it.
Now, in the Reckitt case, Commissioner Chopra, so one of the other new commissioners, filed a concurring statement saying that he would have brought deception charges as well. What do you think about those arguments or that framing?
Yeah, I think he made a really good point, and an important one, that Congress recently passed a law that gave the FTC additional authority to go after deceptive statements around the marketing of opioid treatments. And that gave us particularly the leverage to get civil penalties in those cases. And that's a pretty limited universe for us, the civil penalty universe. And so his point is we should be looking at all the tools in our toolbox when we have these cases and making sure we're appropriately using all the levers that Congress had given us. So I think he's absolutely right. Those are the kinds of things that we should look at. I will say this case was a global settlement that involved criminal charges, state charges. And so sometimes in global settlements, you can't do all of the things that you want to do, and because you're not the only negotiating party. And of course, he supported the settlement too, but raising the point that we should always be looking, making sure we're considering the full panoply of our tools is really important. He and I also had a separate statement on Section 5 recently where we talked about how we should be thinking about using our Section 5 authority to address rapid price spikes in drugs. Congress had asked us to put out a report about it, and this is not something the agency has done before, but we think it is important to think about how our unfairness authority could apply to situations where a company that is with an off-patent drug that's not facing any competition has the ability to raise prices very suddenly because it knows there won't be any entry because of regulatory barriers from the FDA and others for a long time, and consumers don't have an alternate choice. So competition isn't working to protect consumers, and they're at the mercy of these extremely dramatic high price spikes of drugs. It would be a novel approach. You'd want to have the right facts to bring a case like that, but I think we both think it is something that is worth considering and investigating and pursuing.
Great. I'm going to pivot us to a different field. It's no surprise that for those of us who follow the intersection of IP and competition, want to hear you talk about the Qualcomm case.
Yes.
And I sense that I'm going to have a hard time getting you to talk about the Qualcomm case, but we can at least talk about related issues. It's obviously hotly contested, and one that finds itself in a pretty unusual posture, being brought very in the eve of all five of you joining the commission, with the DOJ weighing in a pretty unorthodox way with its statements of interest, with Commissioner Wilson writing an op-ed about her own views in the Wall Street Journal, sharply contesting the ruling as it came out. So in that op-ed, Commissioner Wilson framed the decision as dangerous antitrust overreach that will create new legal obligations, undermine intellectual property rights, and expand the application of our antitrust laws beyond U.S. borders. So even without pushing you to talk too much about the facts of the case, I do think it would be great to hear you talk about your view of the intersection of antitrust and its applicability, specifically with respect to standard-setting organizations.
Yeah, and I will say, I have a lot of thoughts and feelings about the Qualcomm case. The ones that I will share most directly are, I think the work that the FTC staff did in litigating that case deserves enormous, enormous accolades. They brought a really hard case against an extremely well-financed and legally full of firepower opposition. They litigated it while the government was shut down and they were not getting paid, which is really extraordinary. And they put on a really, really compelling case, and they won very handily. So my first thought about that case is always respect and appreciation for the work that the staff did there, because it was hard and they worked really hard and did an extremely impressive job. I didn't agree with what Commissioner Wilson wrote in her op-ed. You know, we have a lot of, one of the great things about the FTC right now is that we have 5, what I describe as engaged commissioners, people who are all very interested and very involved in what we're doing, why we're doing it, what direction we should be going in. And we don't always point in the same direction. And that is part of the institutional design of the agency, but also creates some very lively debates and discussions. Going back to your actual question about the intersection of intellectual property rights, what was the actual words that you used so I can answer it?
So it's thinking about the use of antitrust specifically in this case, so to grapple with the obligations within standard-setting organizations.
Yeah, so here's my view. Standard-setting organizations are basically groups of competitors and other market players getting together to agree on standardization protocols that will help make technology not only implementable, but also promote innovation and improvement and complementary uses across industries. That is a pod that has absolute pro-competitive benefits, but we can't ignore the fact that it involves a bunch of competitors getting together, making decisions about how the market is going to operate. And just because we are in a space where patents exist, we are not in a space where antitrust clears the field. So we still have to think about whether market power is being exercised in a anti-competitive or illegal way. And it is there have been views expressed that behavior in this space needs to be per se legal. I certainly don't agree with that. I'm also not saying that anything is per se illegal. I think, like other areas of antitrust law, you have to look at the specific facts and the specific allegations and figure out whether there has been a violation of the antitrust laws.
So in their statement of interest filed before the Ninth Circuit, the Department of Justice cautioned that deploying antitrust law to remedy a breach of a contractual FRAND commitment can chill participation in standard-setting activity. And there are others that have made these arguments in many other places, too. I think part of the thrust is that antitrust law brings with it the threat of treble damages. We know that Qualcomm is facing, stayed, but pending class action litigation. Is antitrust too heavy a sword in this setting?
I don't think so. I mean, I think in particular when you look at what the implications of unrestrained monopoly power look like, we also have to worry about the effect on participation in standard-setting organization and on innovation and on the ability, particularly of smaller companies, to compete and innovate and build on products and designs that are out there. I don't think antitrust clears the field when patents enter. I don't think it clears the field when contracts enter. Lots of areas of the law operate together. And we think about how they operate together. And we can think about that in a nuanced and sophisticated and thoughtful way without creating huge bright line rules that just because, pharmaceuticals is a great example. Just because the FDA is there, we don't leave. We have to deal with FDA regulation and rules and requirements that create all sorts of incentives and also barriers. And we think about the competitive implications. And that is something that we are capable of doing, and I think we should be doing.
I'm going to move us into a different area, which is we've talked about kind of patent-related enforcement, but you've had an interesting case last year, which is the 1-800-CONTACTS case, ruling on trademark settlements. Can you talk a little bit about how you view the distinction or lessons to carry over from patent settlements to trademark settlements? And maybe just give a little bit of background on the case, because it's a really interesting one.
Yeah, sure. So the summary is I'm going to make the same point here that I made literally a second ago, that just because trademark is there doesn't mean antitrust is not. The 1-800-CONTACTS case is a case in which 1-800-CONTACTS entered into settlements with a number of its competitors in online sales in which they agreed not to do their search advertising bidding using 1-800-CONTACTS trademarks. So in other words, if I'm a competitor, I can't do search advertising. I can't key my advertising to somebody's search for 1-800-CONTACTS and pop up an ad that says, shop for cheap contacts instead. And what the commission found, this was another Part 3 case, the commission found that limited customers' access to a competitive advertising market in which they could compare and contrast different kinds of contact lenses that were available, and it deprived them of the benefit of the cheaper contacts that they could access through that advertising.
And so how do you think about that as a dynamic and with relation to patent settlements, for example?
So trademark has an important distinction from patent, whereas patent is the absolute right to exclude. Trademark is not. Trademark is the right to prohibit confusion, the use of your trademark to confuse customers. And so one of the concerns that the commission had in this case is that the settlements didn't restrict confusing advertising. They didn't restrict advertising where somebody said, if you want 1-800-CONTACTS, click here, and took you to an alternate confusing site. They restricted any use of 1-800-CONTACTS, including a use that would say, if you searched 1-800-CONTACTS, popping up an ad that just said, that didn't even mention 1-800-CONTACTS in its ad language. I don't think there's a lot of risk of customer confusion there. So that strikes me as not necessarily within the scope of trademark, and therefore certainly not immune from or doesn't entitle 1-800-CONTACTS to the exclusionary rights that, say, a patent would.
So since Noah isn't here, he did have a dissent in this case, and he took a different view of that, right? Really putting more of an emphasis on the value of IP rights and trademark. I'm going to read his dissent just because I don't want to paraphrase him. But he disagreed with the FTC using the quick look standard. He said, the majority make a separate holding that the settlements are anti-competitive based on a showing of direct effects. But the evidence upon which they rely fails, both as a matter of law and a matter of fact, to meet the legal requirement that such effects must be actual, sustained, significant, or substantial. I fear the majority's approach will foster uncertainty and undermine trademark policy. How do you engage with that argument?
So again, Noah had a very well-written, very long and thorough dissent in that case, with which I disagreed. And he took exception actually with a couple different points of the argument. First, he disagreed with using a quick look analysis rather than a more extensive rule of reason analysis. And the majority thought, and I continue to agree, that the quick look analysis was justified by our jurisprudence and antitrust jurisprudence around advertising restrictions that suggest to us that advertising restrictions really do inhibit competition in a way that justifies a quick look analysis rather than a more detailed rule of reason analysis. The other thing he took exception to is that the commission found that there were direct effects of harm to consumers from the advertising restrictions at issue here. And that was the part that you read there. And it's a little bit hard to engage with in detail because that's a very fact-specific inquiry, and he just thought the evidence didn't show that as thoroughly. That's going to be an issue that's going to be litigated on appeal. But I will say for my part, I actually thought the evidence was very compelling to that effect. And then the last point to make about this case that I think that was interesting to me as I grappled with it, there were two harms that the commission pointed to in that case. The first was the harm to consumers, depriving them of the benefit of advertising of lower cost products. And the second was the harm to search engines in depriving them of in what was effectively a bid rigging scheme. If you agree not to bid on each other's search terms, then you lower the price of advertising, and that's bid rigging, which is generally very illegal. One of the things I think about all the time when I think about how we deploy our very limited resources to protect consumers and promote competition is who is going to benefit from us spending our resources in this case? Who is going to be on the receiving end of promoting the fairness in the market that we're talking about? And it was really important to me in this particular case that the harm that we focused on and the harm that we found included harm to consumers, and harm to consumers in the form of higher prices and lower access, and not just harm to search engines. Had the harm exclusively been to search engines, I don't think that would have made the behavior legal, but it would have made me ask questions about whether this is the greatest and best use of our resources in promoting competition, because you have to take as a baseline matter, there are way more cases that we could bring and investigations that we could do than we are able to do with the resources that we have. So I think it is incumbent on us to think very carefully about where we should be deploying those resources and make sure that the cases that we choose to expend resources on are the ones that are going to have the farthest and most important effect on consumers.
So that's a really interesting point. You didn't just think it, you actually wrote an entire statement saying that. What do we have to read into you choosing to affirmatively write on that issue? Were you signaling for a very particular reason, or just it felt like it was something that you needed to say?
Well, it was something that was important to me as I thought about the case at the time, and it's something that remains important to me as I think about all of the cases that we're considering. And this is where, I did not come to this job as an antitrust practitioner. I did not come with an enforcement background. And that has, I think, actually some costs. I have a lot of learning to do in that respect, but also some benefits because I have a different perspective and a fresh perspective. And I think fresh perspectives are helpful. And one of the things that I have learned about my perspective that is different from how people have traditionally thought about these things is antitrust tends to be an area of the law these days where people have a view that we look at the facts and we look at the law and we decide whether there's an antitrust issue or not an antitrust issue. And we don't engage in additional considerations about is this good or bad or what does it mean for society? And that's actually really important. The basis behind that view and the good faith basis behind that view is that we don't want to make antitrust political. We don't want to be picking friends and picking enemies and going after companies that we don't like, which I certainly agree with. But I also think in every other area of the law, we are very, very comfortable establishing priorities, prosecutorial discretion priorities. We talk about, which types of criminals we want to focus on, or how we want to think about vulnerable populations in civil enforcement. And that's something we do not only consciously, but openly. Administrations campaign on it, and that's fine. I think that's appropriate. I don't really understand why antitrust is insulated and different from that, because I think the decisions that we make do have broader implications for social values and how we function as a democracy. And so I'd rather we be making those decisions with open eyes. So this case was interesting because it was the first one that crossed my desk where I was like, how do I think about this if the harm were exclusively to companies that I think could pretty well protect their own interests? How would I feel if that was where we were spending taxpayer dollars to protect those interests? And it's something that I continue to be thinking about and still, as I go, trying to figure out how to talk about, because it is different from how I think a lot of people traditionally think about antitrust.
So that's a great segue to what's going to be my last question before I open it up to the audience. So please get thinking. As you talk about setting priorities and we think about this intersection of IP and competition, are there other areas that you think need more attention?
Well, I think the whole universe of drug prices is one that we need to be thinking about a lot and goes to that question of priorities and where we're spending our resources to protect consumers. So we talked a little bit about some of the ways in which we deal with conduct issues in drug prices, and I mentioned the statement that Commissioner Chopra and I had about price spikes and how we could use our Section 5 authority. I think it's worth thinking about how we address pharmaceutical mergers. We see a lot of pharmaceutical mergers, and we tend to have a pretty standard formula for how we address them, which is looking exclusively at product overlaps. Products or pipeline product overlaps. And I'm not sure that that captures the full effect that pharmaceutical mergers have on innovation, which is important for creating competition going down the road. So I think that that's something that is worth a close look and a reconsideration.
Great. Questions from the audience?
Thanks again for coming to Georgetown today.
Of course.
I'd like to talk to you about some of the Actavis cases, or just make some observations. I'm curious what you think.
Sure.
So one is the private plaintiffs bar has been pretty aggressive in bringing suits. I wonder how you choose to interact with them, either when you're joined with them in one case or just more generally. The Supreme Court in Actavis was hoping. Can't hear you. I'm sorry, I'm in the mic. Okay, I'll shout.
There you go.
That's really a problem for me. Private plaintiffs bar. It's very aggressive in this Actavis space. So the question is, how does the agency choose to cooperate or not? A lot of settlements and the reverse payment settlement cases. the private plaintiffs are coming in and then they settle out. There's surprisingly little precedent that's been developed. I wonder if you have any, you would agree with that and see if the FTC is trying to, you settle, which doesn't give the courts opportunities to say much about the cases. Also in that case, the Supreme Court was hopeful that high payments would substitute as signals that everybody thought the act was invalid and this isn't true. But of course, people got very creative very quickly. So you don't see high payments as a proxy for validity. So you've got patent experts, it's going to work if you can get it, going in and saying, I think there was an 80% chance of validity, and the District Court of Delaware would have had this done by the 30-month stay. And I don't think that's what the Supreme Court really had in mind. But that seems to be the kind of evidence that's the agency is producing and certainly the private payments folks producing. So I just wanted to throw a few things out, and I wondered if you had any observations on any of those. Thank you.
Yeah. Thank you. Thank you for the question. I'm going to continue to think about how to respond to the second one while I respond to the first. So a couple thoughts on private antitrust enforcement. The first is that our antitrust system sets up sort of a three-legged stool of enforcement: public civil, public criminal, and private civil enforcement. And those three pieces are all intended to work together hand in hand to deter and correct anti-competitive conduct. The federal agencies and state agencies, again, with limited resources, can't possibly reach all the cases that are problematic or investigate all the issues about which we have concerns. Private litigation can supplement that effectively. To the extent that your question was about coordination, I don't actually have an informed answer for that in the context of pharmaceutical cases. I can think of some consumer protection cases where we've thought about global resolutions or entered into global resolutions with class plaintiffs. But I think that we think very seriously about how we are bringing our case on behalf of the American people more than we think about what that's going to mean for the private plaintiffs' cases that are happening. And then the last point that I will make about your point about things settling and therefore not having a lot of guidance, that's actually one of the reasons I think impacts is an important case, because it helps outline that and create some post-activist jurisprudence that is really important for clarity. Settlements are not a bad thing when they remedy a problem. That's an efficient way to address a problem. And the scope of settlement and the terms of the relief in settlements, I actually think can provide really important guidance. To the extent that our settlements are almost exclusively, if not exclusively, conduct focused in the antitrust space, if you look at the body of settlements, that sets out a pretty good outline for what conduct is prohibited or not prohibited. So I'm not sure that they provide no guidance, but it is also true that sometimes if you can't get a settlement, and I feel this very strongly, that actually remedies the problem that you are addressing in a way that best effectuates deterrence, then you should litigate and let the courts decide. So, and then your second question was about guidance on our high payments, a indication of invalidity. I think one of the issues, again, that was important in activists was not in activists, in impacts, was the commission talked not about the certainty that generic entry would happen, but that the competitive problems that arose from a brand drug eliminating the risk of competition. And that is material, because you can't assume that a brand drug knows whether a generic will actually launch, whether a patent will actually be invalidated. We want competition. We don't want people paying to eliminate the potential for competition. And that's something that we need to focus on.
Great. Any more questions?
Yes, John Dubiansky, Dolby Laboratories. Commissioner Slaughter, I've got one question on the issue of the antitrust IP interface, particularly regarding standard setting. And that is, what's your view following the 2015 Section 5 statement on the scope of Section 5 of the FTC Act with regard compared to Section 2 of the Sherman Act?
help me understand how to put that question in the context of standard setting bodies.
Sure. Do you think that the scope of Section 5 of the FTC Act extends beyond conduct that would violate Section 2 after the 2015 statement?
Yeah, look, I think there is a reason Section 5 is a separate statute. And I think that that's something that the FTC has been a little hesitant to use, but we have used, and we do use it, and we should think about how to use it, not just in the context of standard setting and patent cases, but sort of across the board. We need to look at conduct that we think inhibits, is unfair, methods of competition that may not otherwise be captured by Section 2. And the 2015 statement outlined some boundaries of that. We primarily use the other antitrust laws as a guidepost, but they are not a full stop limitation.
All right, go ahead.
Hi, thanks for being here. I'm curious about the effect, if any, on your choices as far as enforcement and on your approach of the new California law, which makes it presumptively anti-competitive, any kind of reverse payment, anything for value, has some exceptions, a certain amount of dollars you can settle for, et cetera. But I'd be curious, does that affect how you allocate resources? And, if you wanted to speak to what you think about the merits of that, or, kind of pending legislation and federal legislation that would do the same sort of thing, that'd be really interesting too. But I don't know if you want to speak to that.
Well, I'm not going to speak to the merits of the California law because I'm just not informed enough about it to do that in any kind of a thoughtful way. I think I know a lot more about the various iterations of federal legislation, and I continue to think that even where current law allows us to go after problematic behavior, if new laws make it easier for us to do so, that sounds like a good thing to me, because our cases are hard, as I have mentioned several times, to bring and to litigate, and often require a lot of resources to do so. In terms of resource allocation and case generation, I'll make a couple points. The first is that I am a minority commissioner, and even if I were not a minority commissioner, I'm a commissioner. And the FTC is a very bottom-up place in terms of case generation. Almost all of our cases are generated by the staff who are doing the investigating and the litigating, and they get to us for decision-making points. So I can talk about what I think should be priorities, and the chairman does talk about what he thinks should be priorities, but most of those decisions are not ones that I am intimately involved in making. To the extent that we use our resources to fill in gaps and be protective of interests that are not otherwise being protected, I think that that's a good thing. So where states are doing a really good job filling a space, that makes it less important for us to jump in there. Where states are not, then I think it is more important for us to jump in, and that's something that we need to balance across the board, not just in this area.
Thanks for coming as well. I think most people think that having courts around the world trying to figure out FRAND royalty rates is not a good solution. Has there been any further discussion between the FTC and DOJ about relaxing ex-ante price collusion issues to actually have the standard setting body set the licensing terms up front collectively?
DOJ has not had any conversations with me about these issues, so I can't pretend to answer that side of the question. I think you're right that court adjudication of FRAND rates is hard, and in fact so hard that we basically never see it happen. That's one of the concerns about in this space, that who knows what a FRAND rate actually is, and how do you figure that out? That's extremely difficult, and part of why we get concerned about the exercise of market power to extract supra-FRAND rates. So I don't have a more well thought out answer to your question, other than that I share a sense that the current system doesn't do the best job of helping us determine what is actually FRAND.
Let me just suggest that international discussions among the competition authorities of various jurisdictions to authorize standard setting bodies to set those terms up front might be a good solution.
Wonderful. Well, everyone, please join me in thanking Commissioner Slaughter.
Thank you.
We have a short break, and the next panel will start in about 10 minutes. Okay, I'm going to start off by making an obvious point that I am not Peter Manel. Unfortunately, Peter was called away by a family emergency, so he had to change his flight to an earlier time. So I've been able to jot down a few thoughts, and I'm very happy to fill in moderating this panel. I'm just sorry that you get me 2 times in a row. Today's panel is a new addition for this conference, which has historically followed a pretty traditional format. And it's a topic, obviously, Section 101 reform that comes up in our case management discussions, in our year-end case law and review. But this year, with the activity at the PTO and also discussions on the Hill, we wanted to add a specific policy conversation. And I'm thrilled for that, that we have some real experts who are in the thick of the debate, including from the Senate Judiciary Committee, Phil Warwick, who is serving as a counsel detailee to Senator Coons on detail from the USPTO, where he is an associate solicitor. We're also joined by Hans Sauer, who is deputy GC for the Biotechnology Innovation Organization, or BIO, an organization known to many of us, a trade association representing over 1,000 biotechnology companies in many different sectors. We also have with us Kate Rain, who's senior legislative counsel at the ACLU, who are the plaintiffs in the Myriad case and have been deeply engaged on questions of gene patenting and other things at the intersection of 101. And then we're also joined by David Jones, who's executive director of the High Tech Inventors Alliance, a coalition of high technology companies that was created to advocate and support patent policy reforms at the PTO, the courts, and in Congress. So I'm going to start just by passing the mic to Phil, who's agreed to do a little bit of an overview for us of where we are in the conversations today, how we got here, and then specifically from your perspective, working in the Senate and leading the hearings of this summer, the thoughts that you can share from that.
Well, great. I'm excited to talk about this. I've been doing a lot of these types of panels because we thought there would be a bill out right now and I'd be answering all of your questions about it. It turns out we don't just yet. But this 101 has been such a crazy ride for me. I first got involved in patent law right on the heels of the State Street decision. I was an undergrad student working at a law firm. When I was clerking at the Federal Circuit, Bilski was being considered. I litigated Alice in the private sector at a firm. More recently at the agency, worked with Director Yanku on guidance. And everything kind of came to a crazy head this summer on one day in June where in the morning I found myself going to the Federal Circuit to argue a 101 appeal on behalf of the agency and then rushed over to the Senate to staff Senator Coons at one of the 101 hearings. But it's been, the topic is fascinating. I think most people know the general background, so I don't want to spend too much time. We've obviously had some significant Supreme Court decisions, Myriad, saying that naturally occurring human DNA, even when isolated, is not eligible. We have the Mayo, the Bilski, and the Alice decisions that really cemented the current two-step test where we first look to see whether there is one of the implicit exceptions, the judicially created exceptions like laws of nature or abstract idea, look to see whether the claim is directed to one of those. And if so, moving to step 2 and saying, what else is in the claim? Is there something more? And specifically, is there what the court called an inventive concept? And I know, at least from Senator Coons' perspective and mine, that's somewhat of a messy analytical framework. The court itself cautioned that any claimed invention can be described as an abstract idea at some level. And inventive concept is also a little mushy, and there's a lot of overlap with some concepts in 102 and 103. So the Federal Circuit, I think it's fair to say, has struggled over the years to figure out exactly how to apply that framework. On the computer implemented art side, there have been some very interesting developments, I think. Some cases, more recently especially, I think, have started to take a look at how does that step one analysis really work? What does it mean to be directed to an abstract idea? I think some cases arguably look for something that's either just recited in the claims or it's implicit in the claims. There are some cases that really, I think, take a deeper look and say, is this actually an improvement in technology? Which there's some dicta in Alice about that. So cases like the data engine case or the EnFish case, where they said even at step one, this is eligible because it's not really directed to the idea, it's directed to an application of the idea. The other thing, another thing that is interesting in some of the cases is that at least to me, there's a lot of overlap with Section 112 concerns, with functional claiming, with breadth of claiming. So if you look at opinions like the Interval versus AOL decision, you have the court saying, you haven't claimed a solution, you've claimed a result. And your claim covers all ways of achieving that result. And that's too broad, and therefore it's abstract. Although one could also argue it perhaps is not compliant with Section 112. And then, of course, in the midst of all this, we have the issue about when and how these issues are being resolved under 101. I know pretty early on, as the Supreme Court was looking at these issues, there was an opinion by former Chief Judge Rader in Ultramershal where he said, caution, that's going to be a rare case where you should decide 101 early on. There could be some factual questions. But as we all know, that case actually went up and back from the Supreme Court 2 times. By the time the third opinion came out, Judge Rader was gone. The eligibility outcome flipped, and the language about early motions was gone. But that was resurrected some years later by Judge Moore in the Berkheimer decision and in the Atrix decision, where the court said, there are, in fact, subsidiary factual questions, and in particular focused on step 2 of the framework, when we're looking to whether the rest of the claim is well understood or routine or conventional. And if those factual questions are in dispute, it may not be appropriate to resolve 101 on a Rule 12 motion or an early summary judgment motion. So that's been in play as well. Currently, I know everyone's watching the Supreme Court. There are 2 cert petitions in particular where the court issued a CVSG asking the government to weigh in. One was Berkheimer talking about factual questions. That the question presented by the petitioner was actually framed in terms of juries deciding 101, which I thought was crazy. I didn't think that was really the question, but then I went to the EDTEX bench and bar earlier this year, and that's all anyone was talking about. And there are, in fact, juries deciding 101 questions more and more frequently, especially there in Texas. So that actually, the court asked for the government's views back in January, and I believe is still waiting for those views. This is a good point, actually, for me to clarify. I'm here on behalf of Senator Kuhn's office. I'm not speaking on behalf of the USPTO. But so that's out there. But so that's kind of on, mostly, computer side. Another area of just enormous impact with 101 is in the diagnostic space. And as far as I can tell, following Mayo, which held that basically if you have a new correlation between some sort of biomarker and some type of condition or disease, you combine it with some conventional steps to diagnose that condition, that is not eligible for patent protection. And the Federal Circuit seems to have really doubled down on that. We had cases like the Ariosa case, where even we had the judge I clerked for, Judge Lynn, had a very passionate opinion where he said, this is a very valuable invention. This is exactly the kind of thing we want to incentivize with the patent system. And everyone agrees it was new, it was groundbreaking, it was commercially valuable, it was important in terms of public health considerations, but not eligible, hands tied by the Supreme Court. And that one went up, along with many other cases, to the Supreme Court on cert petitions that were denied. But there is a case that's pending, the Vanda case, that instead of being a diagnostic method, was a method of treatment. And the Federal Circuit said, this is different. They distinguished the diagnostic cases. They said this is eligible. Patent Office has issued some guidance based on that. But that one is also pending. The court asked for the government's views, I think in March. So presumably a brief will be coming at some point on that as well. And in the meantime, pretty consistently, diagnostic claims have been invalidated or held not eligible under 101 almost across the board, which is very concerning, I know, to my current boss, Senator Coons. But what's interesting is there's not that much agreement as to why we're reaching that result. And this was illustrated in the recent Athena case. In the Athena case, it was another diagnostic method. The Federal Circuit panel held that was not eligible following the Mayo decision. And then the court, there was a petition for rehearing en banc. The judges, 12 active judges, split 7-5, that they were not going to reconsider the case, but remarkably wrote 8 separate opinions opining about either what the law is or should be, or who should be changing it or not. And several of them, some of the judges explicitly asked either the Supreme Court or Congress to step in. So there's a thumbnail sketch of where we are on the case law. Meanwhile, the USPTO has been grappling with this issue, and this was a high priority for Director Iancu when he took over at the agency. And so he issued some guidance, as I'm sure everyone knows, back in January, trying to make some sense of the case law for the examiners. I know from talking to folks at the PTO that this is tremendously difficult for the examiners because the way the case law has evolved is you say, what is the claim directed to? And it's like, well, no one really knew what that means, but then is it abstract? And the way the courts have generally done it is, well, does it look like one of the other cases we've already resolved? And this is typical legal analysis. Is it more like these cases or is it more like those cases? But the examiners are, many of them, not attorneys. This is a legal type of analysis that's hard even for the seasoned attorneys. So the guidance attempted to simplify the process, and especially focusing on the step 1 analysis. And 2 big things it did. One was to say, instead of asking examiners to figure out just whether something's abstract and then look at all these cases, tried to go through and synthesize what are the abstract ideas and categorize them and list them and have some easier guideposts for the examiners. And there's also a mechanism where perhaps there's an abstract idea that's not itemized, that could be sorted out as well. The other thing that's really significant in the guidance, I think, is a new step compared to the prior guidance that really builds on those Federal Circuit cases dealing with the directed to part of the analysis at step 1. What does it mean to be directed to an implicit exception? And so the guidance says, well, what you have to look at, first, like, is there some sort of law of nature, abstract idea in the claim? And if so, is it integrated into a practical application? And if so, then you're done. You're done at that step. You don't have to move to step 2. And that's very much, I think, like the cases I mentioned before, like the EnFish case with the self-referential table, the data engine case with the tab spreadsheets, where they said this is actually an improvement in technology. So that's going on. Meanwhile, there was this case, Cleveland Clinic, where the Federal Circuit looked at a claim that really was drafted to mimic earlier PTO guidance from 2016. And the Federal Circuit said, well, granted, you did draft this very much like the PTO told you to, but respectfully, we don't care. Maybe that's too strong. We shouldn't say that. But they made it clear, like, we don't defer to the PTO. So I think there are a lot of folks who have voiced concerns about, well, what does that mean for the 2019 guidance, which was actually just recently supplemented and updated and clarified. So against all of that backdrop, we'll move to the legislative branch. Senator Coons, working with Senator Tillis, We're very excited to have the IP subcommittee reconstituted this year. It had been absent for a long time. They had built a partnership with some folks over on the House side and really tried to tackle this issue. For Senator Coons, I know the issues were at a high level, twofold. One, he's very concerned that diagnostics are being shut out of the patent system. He's hearing from folks like Cleveland Clinic who have said that this is really affecting investment decisions. It's affecting R&D, which affects solutions that are available for patients. And he's also worried just about the clarity of the law. Like, how is it that we're doing this system where we're trying to figure out if something is an abstract idea? If we keep comparing it, we have this ever-increasing bubble, because you look a little bit like the last case, and then the next case looks a little bit like that. And based on that system, we've had a lot of folks raise concerns with where we've ended up, with some recent cases like the Chamberlain Group case with the garage door opener, or the ChargePoint case with a charging station for electric vehicle, or more recently, this American Axle case with a method of dampening vibrations in a drive shaft. So we held a series of roundtables starting about this time last year, before I got there, worked with everyone, made it clear that we were really trying to figure out, like, how do we balance the interests? We recognize there are competing interests. The system's actually working great for some folks. If you're being hit with a lot of patent litigation and you feel that the claims are abstract or overly broad, this is turned into a way to efficiently get rid of those lawsuits. So to the extent there's abuse, that's something to be addressed. To the extent that some of the issues being resolved under 101 are actually 102, 103, or 112 questions. I know Senator Coons is really passionate about saying, well, let's keep those things in their lanes. And Director Iancu has said some similar things. So we tried to do that. We tried to do it in a balanced way. The result of the roundtables was a draft that was published back in May. The draft at a high level said the case law involving the implicit exceptions, so law of nature, abstract idea, natural phenomenon, abrogated, be a new framework in its place. There's the existing language, but also on top of that, there's a definition of utility that basically said you have to have a practical application in a field of technology through human intervention. So some new limitations placed there that were an attempt at clarity. And there was some language that said when you are doing this analysis, you shouldn't overlap with 102, 103, 112. Don't think about whether any of the limitations are well-known or obvious, routine, conventional, et cetera. Leave that to the other steps. And then coupled with that, there was a proposal to amend Section 112F, dealing with functional limitations that would have removed this whole dance we do about whether there's the word means for or some other equivalent term that either brings you in the statute or not, and basically would have built on the Williamson v. Citrix decision to say if you have a functional limitation and you don't have the structure in the claim, well then construe the claim according to the structure in the spec and statutory equivalence. So based on that, we had hearings in June. We had 45 witnesses, which I'm told is almost unheard of in the modern era. I guess maybe.
We went through comprehensive immigration reform, so there were a few more for that, but this is close for IP for sure.
Maybe for intellectual property. Kept me busy, that's for sure. We heard from folks all across the spectrum. We've got
three
right here. So we have 1/15 of that experience reconstituted here today. And a lot of issues were fleshed out. I think what was interesting is we did hear from some folks who are generally happy with the status quo, who nonetheless admitted that the law is kind of a mess. And like so Professor Lemley notably actually said that at the hearing, which was a little bit surprising to me, but he did caveat that with, well, it's producing some good results and you should think about that. And some folks who are in industries who are not negatively affected in their view right now, nonetheless acknowledge that there were some really bad outcomes in other industries, particularly the life sciences. So that was interesting. We heard from folks who had raised concerns about some other related issues, either litigation abuse, things about drug prices. And we also heard from folks who wanted reform, who wanted it to be done differently. A lot of people were not happy with the idea of amending Section 112 and wanted to keep it focused just on Section 101 itself. But in any event, we took all that to heart. We read, I know I personally read all of the written testimony. We were there for all the hearings. A lot of other staff read all the follow-up questions, and we've been meeting with people really regularly. And we candidly hope we would have had a bill by now, and we don't. We're still working really hard. We're trying to resolve, I think, the big issues being the ACLU and some others raised some concerns about gene patenting and some related issues. So we're trying to deal with, like, well, how can we explicitly carve out? I know Senator Coons said, Senator Tillis also said, the goal was not to reverse the key holding of Myriad. A lot of people had concerns about, what does this mean that abstract ideas are eligible now? And the answer is no. I think we all can agree that whatever an abstract idea is, that's not what we're trying to patent. What we're trying to do is provide a new framework that's clearer, that's more predictable, ways to clarify that, maybe ways to sharpen up the technology language. A lot of people brought that up. And to the extent that the 112 language was designed to address overly broad functional claims and perhaps some litigation, allegations of litigation abuse surrounding those, like, are there other ways to address those concerns? And on top of that, I think we've had really quite a few suggestions about ways we could fix 101 that were completely different from what we proposed. So we're balancing all of those ideas as well. We're working hard, and to the extent anyone has ideas about how to fix it, you're definitely welcome to come and talk to us.
Great. Well, thank you for that overview and whirlwind tour of everything that's happening in the world of 101. I've next asked each of the other speakers just to speak for a few minutes about the point of view that they bring to this debate, and then we'll have a conversation after that. So Hans, do you want to go next?
Very well.
Great.
Okay, so within bio, let me quick word on who our constituents are, right? So we have a lot of for the most part, small companies that are organized within bio. They're all biotech companies. Most work in the therapeutic space, that is, they develop new biologic drugs or treatments. Some of them work in the diagnostic space, but not very many. Many of them work in agriculture and industrial biotechnology, right? So it's a widespread, and they're unified in the use of biotech, but in other respects, they work in very disparate aspects of commerce. Nonetheless, I think I would say across the board, Section 101 is for sure the most highly debated topic of substantive patent law within our membership, even today. Well, this has been going on for years. So it is a big deal when it comes up in conversation. Our members continue to want to talk about this, even though they bring different perspectives to the table on what this might mean for their business or their sector of commerce. It's been my experience, having watched this for a couple of years, that to the extent people agree that we should seek for a solution to the state of the law, I've seen this funny phenomenon where you might get 15 or 20 well-informed people into a room, and before they can start talking about what kind of solution to craft, they first need to agree on what kind of problem we're trying to solve. Right? And there are so many different readings of what this jurisprudence is trying to achieve that I think it spawns a lot of disagreement that stands in the way of crafting a solution, even among very well-intentioned and informed people. Right? Is it about undue claim breadth? Right? Some people say yes, but we're seeing claims go down under Section 1 that are not very broad at all. You know, some of them are very particular. So it's not always about breadth. Right? That's not the touchstone. Is it about preemption? Well, no, not really, because we're seeing claims got down that preempt nobody from doing anything. Is it keeping natural phenomena and building blocks of nature in the public domain? Well, most of the patents that go down really don't have anything to do with natural phenomena or things that occur in nature. Right? That's not what's being claimed. Is it notions of inherent patent worthiness that spook through this conversation? Who knows? But everybody brings different perspectives to the table, and I think that stood in the way of reaching an agreement on crafting a solution. Right? We haven't agreed on what we're trying to accomplish. And frankly, I believe reading the Supreme Court's cases, the Supreme Court itself isn't quite clear on what it's trying to accomplish either. Right? And that creates difficulties in responding to that in a policy space. Okay, so from our perspective, what kinds of products, this may be illustrative to you, what kinds of products and activities are affected? Not everything biotech does is affected by Section 101. But I can point to some areas. We've already talked about diagnostics, not the focus primarily of most of our members, but it's pretty clear at this point that diagnostic companies who hope to get patents don't really have a clear path forward. Right? I think that we should accept that as truth. Right? You might be a diagnostic company that isn't actually a diagnostic company. You're a company that develops tools for use in laboratory work. Right? Okay, that's a different field of endeavor. I would say the real diagnostic companies don't have a good way forward. And the Athena case that's pending right now, I think might be an opportunity for the Supreme Court to answer, is there such a thing as a patent-eligible diagnostic claim? Because if there isn't, that would be a good thing for the court at least to say, right? Otherwise, maybe we should create some bookends and explain what's a patent-eligible diagnostic claim versus one that isn't. If there is a patent-eligible diagnostic claim in the world, we haven't seen one. They've all gone down, so nobody knows what to do to draft an eligible diagnostic claim. That's if you work in diagnostics. But there are other areas of biotech products that are likewise affected. For example, claims to preparation of substances, medicinal substances, industrial enzymes, fermentation products, so that's compounds that are in some way are extracted from, or that copy compounds that otherwise exist in nature. Right? Claims like that are being rejected. For example, under the logic of you can't claim a purified preparation of this antibiotic molecule that you extracted from a bacterial culture, because if you can't patent the DNA you get from the bacterium, there's no reason why you can patent the purified antibiotic you get from the same bacterium. It's just not going to fly. It doesn't fly in the patent office. And it creates a disparity in substantive patent law on important biotech inventions where things aren't patentable in the US that continue to be patentable everywhere else in the countries with which we compete and trade, including actually Australia, which has had its own gene patent case and which resolved it differently, right, in effect. Okay. So there we are. This is why we care. I hear many reports from colleagues inside our member companies who continue to say that they have difficulty advising their business on investment decisions. I think that is true in the diagnostic space itself. I recently read one estimate that the cost of fully commercializing a new diagnostic test to the point where you get payers to reimburse for the tests, right, where it's covered by insurance and all that commercial work you have to build around the product can easily cost in the range of $50 to $100 million, right? So that too, it's not as expensive as developing a drug or a genetically modified crop, but even in the diagnostic space, it's not cheap to build a diagnostic franchise and to develop a product. I find, like, to finish this, I hear a lot of arguments saying, well, why it would be better if these things weren't patentable. Take the Ariosa diagnostic test. You may recall, right? That was the case where amniocentesis or chorion villus biopsy was replaced by a blood test that can be performed on the mother. Well, that seems like a pretty darn good invention. And we heard lots of arguments at the time saying, well, it would be better if that weren't patented for all sorts of reasons, price, supposedly access, and so on. And we hear this often. I think it's very easy to say after a discovery was made, after a test was developed, after it's been commercialized, and after insurance companies have been persuaded to pay for it, it's very easy to say then that the public would be better off if it weren't patentable, right? But that is not an argument that's in any way particular to natural phenomena or anything else. That's a utilitarian argument that doesn't have to do with Section 101. That's just an argument against patents. And if we're here to solve a specific problem in substantive patent law, I think that's what we should be focused on, and not get distracted by more generalized arguments of how would we be better off having fewer patents in any given space.
Great. Kate?
Thank you so much. Can everybody hear me? Mm-hmm. Short. Thank you so much. It's really an honor to be here. Thank you for organizing this, and thank you to Professors Thomas and Manel and to Georgetown and Berkeley for inviting me to be here on behalf of the ACLU. It's an honor. I am not as good at articulating my thoughts off the cuff as Han is, so I'm going to read a little bit. I'm very eager to get into the discussion, as everybody else is. So I just want to make 3 main points here at the beginning to give folks a bit of a view into what the ACLU's perspective is here. Like, why am I here? and why we're very concerned about the possibility of legislative changes to 101 eligibility exceptions, and why we view the patent eligibility exceptions as necessary to safeguarding civil liberties in our modern society. The first is one that I think everyone here probably knows, which is that the Constitution limits the reach of the intellectual property laws in ways that are important to preserving the freedom of speech, thought, research, and innovation. Article 1, Section 8, Clause 8 creates the authority to grant patents, but it limits that authority to claims that promote the progress of science and the useful arts. Furthermore, like all other Article 1 powers, the First Amendment also constrains the government's ability to grant patents. And to me, that means patents are good, but only to a point. There is some subject matter that shouldn't be eligible to the patent monopoly because granting that claim would not promote the progress of science and the useful arts. And taken from a slightly different angle, patents claiming certain subject matter could harm the marketplace of ideas, our ability to share and iterate upon each other's ingenuity. These limitations are liberty affirming, and they should be pre-baked into any patent system this country creates. The eligibility exceptions do just that. And what the Supreme Court has acknowledged is that laws of nature, products of nature, natural phenomena, and abstract ideas are part of the storehouse of knowledge of all men, free to all men, and reserved exclusively to none. Eligibility doctrine has evolved to give meaning to that concept. It provides standards that help us draw the line between patents that claim one of the fundamental building blocks of human ingenuity and those that apply those building blocks in a new and useful way. Which leads me to my second point. One of the main arguments that I've heard throughout the day, and that I think that Phil alluded to a little bit earlier, is that eliminating the eligibility exception is that essentially that the jurisprudence has basically mistakenly evolved to require 101 to do work that is better left to the other patentability doctrines like novelty, non-obviousness, and the specification requirements. But I don't agree that the doctrines of novelty, obviousness, and written description can do the work that Section 101 does do to prevent claims that claim laws of nature, products of nature, or abstract ideas. So just to put a little meat on that, prior to Mayo, Myriad, and Alice, the patentability doctrines did not ensure products of nature, laws of nature, or abstract concepts could not be patented. Myriad and many other companies had patents on human genes granted by the PTO. Patents on broad concepts like hedging risk or the concept of telemedicine were granted. And I think human genes are a really good example of why the patentability doctrines can't save us if we eliminate or abrogate the eligibility exceptions. So I'm going to talk about that a little bit more. The case of Myriad holding patents on the BRCA1 and BRCA2 genes is helpful to elucidate. Prior to the Myriad decision, people, especially women, could not access information about whether they had harmful mutations in their BRCA1 and BRCA2 genes. The specific reasons for that lack of access varied, but they all trace back to one source. Myriad Genetics held patents on the BRCA1 and 2 genes, which meant the tests were expensive, incomplete, and no one else could offer the test. The patents claimed the genes and methods relating to genetic sequencing, to comparing genetic sequences. There was no way around that. Any geneticist isolating the genes would have infringed the patent. Under the patentability doctrines, the discovery of the BRCA genes was new, and its linkage to cancer was not obvious. The patentability doctrines didn't prevent those patents, and they would not prevent patents on any new variants discovered after the eligibility exceptions are erased. The fact that the genome has now been published and sequenced would not mitigate the potential harmful effects of expanding patent eligibility to allow for the patenting of isolated genes and DNA once again, or necessarily prevent the issuing of patents on isolated genes and DNA. We know that variants are continuously being identified, as well as connections between portions of DNA with various conditions. Those are also novel and non-obvious. Without the eligibility doctrines, patents could issue on these new variants just as they were before. So why not just carve out human genes? As Phil suggested earlier, yes, we can carve out human genes and make sure they remain ineligible. We can even make sure any association between a gene and a disease is ineligible. But other products of nature, laws of nature, and abstract ideas would be eligible. And we do not know which will create the same issues as gene patents did. A good example is the microbiome, which I think Han alluded to. We're only just beginning to learn about gut bacteria. If they are associated with disease and they can be patented, we can find ourselves in a similar situation that we were in with Myriad. So that's why I think it's important that products of nature, laws of nature, and abstract ideas remain patent ineligible. The patentability doctrines aren't going to do the work that we need them to do. And finally, one of the main arguments I hear over and over is that legislation is needed to clarify patent eligibility. The Supreme Court cases have left patent applicants and lawyers completely confused as to what is eligible, and lack of clarity is harming investment. I'm not completely convinced that the current standards articulated by the Supreme Court cases are totally unclear. And to the extent that clarity is needed, it seems like they are being provided as we go through iterations of deciding cases. I also fail to see how wiping away 150 years of precedent could bring clarity to any doctrine. Each and every new word of a statute will have to be litigated without the benefit of precedent as a guide. For the draft bill released earlier this year by Senator Coons and Senator Tillis, the subcommittee held 3 hearings with 45 witnesses and received 45 different interpretations of what the bill meant. Some diametrically opposed to each other. Hans and mine, for example, it represented completely different interpretations of the bill. So to the extent clarity is needed, I think things are progressing as they should when a change in doctrine has happened. The courts are taking it and thinking about it. The PTO is taking it and thinking about it. Patent litigators are taking it and thinking about it, and we are getting clearer as we go along. So that's what I've got.
Right. Well, I'm going to try to keep my comments fairly short, but let me pick up where Kate left off. So tech, I think, is almost entirely of a view that 101 serves a distinct purpose that is not served by 102, 103, and 112. And as Kate said, I think we completely agree there is certain subject matter that is inappropriate to patenting no matter what. Right, and this is hinted at in the Constitution. I mean, I think Phil mentioned the useful arts language. If you look back and try to figure out what are the useful arts, you'll find that historians agree that there's kind of 2 classes of things, and there are the useful arts, which are the things that would be taught in vocational schools or an apprenticeship, right? These are things like engineering and agriculture, so the hands-on practical application. And then there were the fine arts and the pure sciences. Those are things that you learned typically at a university. So, if you ever want to know what useful arts is, and Jay may have a gloss on this, but the way I think about it is, would you learn about it at a vocational school, right? Or would you learn about it in a university? If you're learning about it at a university, the founders apparently thought it shouldn't be patent eligible. And there are a lot of good reasons for that. Typically, the ideas that come out of an academic institution are going to be very high level, very broad, very abstract. They're going to be principles. So the useful arts are characterized by things that are subject to patenting because they're specific enough and narrow enough to be patented. So we would totally agree that there's a distinct and very important role for 101 to play. Moving on to kind of the overall high-tech perspective, I think it's important to emphasize that virtually the entire industry, companies large and small, except for literally a handful of outliers, is of the same view that 101 has certainly not been a disaster for the tech industry, and in fact has produced some significant benefits. Phil mentioned some of the cases like Enfish, I can't remember the other one you mentioned, but McCrow is another example, where in the computer arts and the software, the Federal Circuit has used the Alice test as kind of a proxy for, is there an advance in technology? Well, given that the patent system is supposed to advance technology, that feels like about the right test to most tech companies, and we're pretty happy with it. Although we don't want to minimize the problems that are affecting other fields. And Hans is my friend, so I feel very bad for him. But we're just fine. He really is my friend, by the way. We've known each other for a long time. So we.
No, you are. You are.
Hans, that's mean.
Friends, but only to a point.
Yeah, frenemies. Let's go there. So we don't think that there's, and more to the point, we don't think there's significant evidence of damage. Right? Certainly not in the tech industry. R&D investment keeps going up. Revenues have gone up. You cannot look at what's happening with tech companies and see anything like the Armageddon that people described at the 3 hearings on 101 in the Senate. It just doesn't exist. In fact, people have done economic studies that indicated that for companies who are seeking business method patents, when Alice came along and they could no longer get reliable business method patents, they invested more in research and development. Right? So this is an instance where there is empirical evidence that the narrowing of the scope of eligibility increased exactly what we want the patent system to do: investment in research and technology. And that, I would argue is, raise your hands if you want more business method patents and less research and development, right? How is that good for society? We think this is a good decision, and that, we're happy with the status quo, although we've been also happy to engage with our friends on this issue in the Senate.
So I want to pick up where Kate and David left off, which is this idea that 101 has a unique job to do with respect to 102, 103, 112. Hans, Phil, how do you envision that? How do you think about that as the distinct role that we need 101 to remain strong because of the function that it serves in the system?
Yeah. So for one, I have yet to see actually a really good case that will convince me that 101, does things that cannot be done by other provisions of patent law. Right? The cases that we've seen, I think were all, for the most part, carefully crafted so that we wouldn't get the answer, especially the big precedent-setting cases in the Supreme Court. Right? The Mayo case, didn't go up with accompanying theories of where the court would have had an opportunity to strike the claim down under Section 112, for example, or for obviousness, right? They were brought up on, this is all about 101, that's the only thing we'll let the court decide, and the court decided. Maybe the best, frankly, the example of that is the Myriad case, where I will wager that case would have been decided differently if it had been a normal infringement case, right? If Myriad had sued Harry Oster for doing diagnostic testing, the court would have been required to compare the asserted claims against what's actually being done in the lab, right? There would have been a question of, are these claims even infringed? Right? Which claim are we talking about? If there's an invalidity defense, we would have to talk about what's wrong with that case. And who knows how that would have come out. But all those opportunities to discuss whether other doctrines of patentability could have taken care of the claims in that, or actually all the Supreme Court cases ever since the Mayo case, that answer wasn't possible, right? Because they were carefully crafted to avoid actually a discussion of these issues. So no, I don't agree that Section 101 routinely does things that cannot be achieved by other provisions of patent law. I acknowledge that it's doing something important. I think most arguments that I do hear for Section 101 are either normative, right, in the sense of we just shouldn't have patents on certain things like naturally occurring substances or genes, right? We just shouldn't. But for the most part, the other arguments that are here are just utilitarian. It's like, this is good for us because it prevents the issuance of patents in our space, and that makes us happy given what activities we undertake. Whether And so this has nothing to do with Section 101. It's just an obstacle to patent enforcement or patent issuance that's good for certain sectors of the stakeholder community. What? Imagine the PTO burnt down tomorrow night. What? With no loss of life and no harm.
We have an awful lot of PTO people in the audience, so.
Imagine the whole place went up in a conflagration. Well, that's certainly going to impede the issuance of patents, right? And some people might say, that's good for the economy because if we don't have patents in our space, people will have whatever, access to cheap automotive parts or whatever it might be, right? So I think there's a disconnect here between what the people who engage in this debate are trying to do. Phil and his people are trying to solve a problem in law, right, that cuts across all sectors. And then you have important stakeholders who go, but we don't want patents in our space, and we think whatever you're doing is going to facilitate patents in our space, and that's going to be bad for society, right? And so the argument will be made, like always, on that basis. And I don't know how to square the two, but I think both must be heard.
So I want to give Kate a chance to respond to that in a minute, but Phil, I'd love to hear your response first on that question of what is the work that you see 101 doing?
Right. So, I think coming from the perspective of the group on the Hill that has been working on this, we do think there is a unique role for 101 that's distinct from 102, 103, 112. But I think a couple things. One, we want that to be clear where that line is. And there does seem to be a lack of clarity, and it turns out it's very hard to draw the line. But I guess one example would be when we talk about business methods. I don't think there's a huge appetite on the Hill to make pure business methods, like methods of hedging, for example, as we had in Bilski, eligible. But what about a claim that just says a computer configured to perform the following steps? And then you have your otherwise ineligible hedging process. It was our attempt when we had the May draft by incorporating a requirement that inventions have practical application in a field of technology, that there would be a limit. And sure, there's going to be some uncertainty, but it would be a discussion in the courts about what is technology, not what is an abstract idea. And I think I even heard Dave say that technology, improvements in technology is not a bad touchstone. I know the word improvements, a lot of people start to think improvement, that means new, non-obvious. I think there's a way to actually disentangle those concepts. You could have, for example, a communication channel that is encrypted, and maybe someone else already did that, but that's a technological improvement that's been claimed, hypothetically, when we think that should be able to get past the 101 test. So the other thing I just want to reemphasize is that from at least Senator Coons, Senator Tillis's perspectives, as they've articulated, the goal is not to wipe out all the case law and say that everything that was held ineligible is now eligible. The goal is to have a clear framework for that. And as we do that, one thing that's really important to Senator Coons is on the idea of, like, for example, the genetic testing. The goal is not to undo Myriad and say that isolated DNA can be eligible or that information encoded in DNA should be eligible. But to the extent someone has a diagnostic method that utilizes a newly discovered correlation, which, as Kate mentioned, the BRCA1 correlation was new, it wasn't obvious, it took time and money to develop that diagnostic. It's very valuable, being able to determine if someone has breast cancer. We want to make sure that R&D is being incentivized. And as Bob Armitage testified at one of our hearings in June, the drug or the diagnostic that is never brought to market is not available at any price. And that's a key consideration for Senator Coons.
So how do you achieve that goal without overturning Myriad?
Well, so at the hearings, Senator Coons and Tillis both expressed willingness to add explicit language to any proposal that would specifically say that human, naturally occurring genes or even isolated human genes would not be eligible. It was never their intent to go that way. And we've actually had meetings with various groups, including the ACLU, to talk about ways we could possibly...
We greatly appreciated the meeting.
About ways we could possibly do that. But we also think that on a higher level, we had requirements in the draft dealing with things like human intervention. So you find something in nature, if it's a human gene or an apple on a tree, that shouldn't be eligible either way. There should have to be some additional step. And the other thing I'll just point out is like that draft in May wasn't even actually a bill. It was kind of a discussion draft, I think we called it. And I would say it was a huge success because we've had an enormous amount of discussion.
Spoken like a true Hill staffer, they've co-opted you over.
Will you allow me to add one proposition to what you said, right? Because I think it's actually, quite rational to see the draft and to see the statement about we want to abrogate, this part of the case law. Well, that clearly must mean that natural phenomena or laws of nature so would then become patent eligible, because why else? What else would the effect be of abrogating the case law? But there's an alternative view to that. Right? If you abrogate the exceptions, I think courts will simply be required to construe the words of the statute. Right? Courts, actually, the Supreme Court has spent very little time construing what it means to be an article of manufacture, a process, a machine, or a composition of matter. Right? The courts never actually had to do this because they always had the handy-dandy exceptions that they could construe instead. It's not that these exceptions haven't been construed and developed. Right. The big difference is that one was passed by Congress and the other appeared out of thin air with very unclear doctrinal origins. So I do agree that in either case, if we pass legislation and abrogate the case law, it's going to create the need for more judicial construction, but this time it's the words of Congress. There's not going to be clarity immediately, but it's not that we have clarity under the existing case law either.
Although
so that would be my pitch. Why not the statute? Construe that instead of the exceptions.
So I think, let me just jump in on a couple of things. One, there are extra legislative provisions in the draft that say you have to construe 101 in favor of eligibility every time, inevitably. The abrogation does kill 160, 170 years of those precedents. Now, Hans is right. The courts could then go back to reinterpreting, the statutory language and somehow interpret it in a way that excluded the same type of subject matter that we're concerned about. But that is very uncertain, especially with these extra legislative provisions that really limit what a court can do in construing 101. I think kind of relying on that would be a bit of a fool's errand, and it's being proposed by the very same people who are very unhappy with what the Supreme Court has done thus far. So, asking us to trust them, even though the people proposing that we trust them don't, I think is problematic.
It also misses the Constitution. And
it does.
The extent to which the progress of science and useful arts is served by extreme expansion in eligibility. And I think that would be one of the primary questions that would be asked of the court almost immediately.
Mm-hmm. Yeah, I think there's a decent chance that if the draft actually were enacted, the Supreme Court would choose to constitutionalize the very same exceptions that they've recognized thus far. I mean, thus far, they've termed them exceptions to the 101 statute. They fit quite well as being constitutionally based on the useful arts language. And I could very much see the Supreme Court saying, well, we can't interpret the statute anymore, but you can't prevent us from interpreting the Constitution.
Right. So how would that be worse than what we have today? I say, let's call their bluff. Right? The Supreme Court said, if you don't like it, go to Congress. Let's go to Congress, right? If the Supreme Court gives it constitutional dimensions, okay, well, then we're no worse off than we are today.
Yeah, but that's the best case scenario for my industry, right? So we can only be as good off as we are now or worse.
And I don't understand how that serves the argument of clarity, how that brings additional clarity to the doctrine or to the case law or to anybody, to people seeking patents, to anyone.
But I think just abrogating case law and kind of leaving it to the courts to go back to the statute, that's not at least where Senator Coons would like to go with this. He would very much like to provide a substitute framework, one, again, that is clear and more predictable. I think that's important. There's going to, of course, be some litigation for any new language, because otherwise, why do any legislation at all in any area. But in terms of the clarity, because I've heard this argument a lot, the law is actually pretty clear. It's not that unpredictable, and there's really not a need for Congress to get involved. Countering that is the fact that we have heard from several former directors of the USPTO. We've heard from the current director of the USPTO saying this is actually a big problem. We have a real lack of clarity. We had, again, 8 separate opinions of the 12 active federal circuit judges, many of whom expressly called on Congress to look at this. We've had some of the senior judges who are also on record saying that Congress or the Supreme Court needs to get involved. And these decisions really are, some of them, like policy decisions. What will or will not be able to get in the front door? And I mean, if we go all the way back to the 70s with the Gottschalk v. Benson case, what do we have? We have the Supreme Court saying, hey, Congress, you might want to look at these software patents. There's probably some decisions to be made. And it hasn't happened yet.
I want to pick up on a challenge that Hans set out earlier for you, Kate. So going back to these policy decisions that are embedded, right? And a clear point of what he was saying is, why are we using patent eligibility as the tool to deal with gene patents? One could say that there are other interventions, right? That it's a question about the distribution of health resources, that it's a stronger exercise of march-in rights. So there are other tools that could be used to help address the types of problems that surfaced in the Myriad case. Can you talk about why you think eligibility is a key piece of that puzzle?
Right. So I completely agree with Hans that there may have been other ways to challenge the patents that were at issue in Myriad. I think that 101 was the right way to go because as I argue now and we have argued all along, human genes are subject matter to which no one should have exclusive rights. And the way to obtain that result was actually pretty straightforward based upon the case law and based upon the Constitution from our perspective. It would have been one thing if we could have invalidated Myriad's patents on the breast cancer genes, but we didn't think that's not enough. That is not enough. Human genes should not be patent eligible. No one should claim them exclusively, and that was why we approached it. That is why we approach it from a 101 perspective and not necessarily any patentability doctrine perspective. Does that answer the question? Is there more that I should say?
No, that's fair. I mean, I think it's so it's not just about 112, like, are there other patent arguments that you can make, but whether the patent system is the place to be
whether the subject matter at
concerns.
issue should be patent eligible to begin with. It is a product of nature. It's a natural phenomenon. It's an abstract idea. Those are things that belong to us all to be able to research and examine without fear of infringement, without fear of a patent demand letter. There are stories from pre-Myriad of genetic counselors having drawers full of patent demand letters telling them that they were infringing and they needed to stop testing because they were infringing on patents. Those are things that impact research, they impact patient access to care, they impact far more than whether someone is able to have a patent. And the other aspect of that, I think that David pointed to empirical evidence of the need of a patent and what it means for incentivizing innovation. And I don't know that we have empirical evidence of what the need of a patent is when it comes to medical diagnostics writ large. But to the extent that we know anything about whether patents were good for human genetic testing or for the development of research surrounding human genes, the empirical evidence we have suggests that they weren't necessary, that they actually impeded research, they impeded patient access to care. And to the extent that there was investment that was directed to genetic research, private investment directed to genetic research, the report, which was issued by the government, it's called the SAGES report, posited essentially that really what investors want is to be able to research therapies and to be able to claim the therapies. And they may not be motivated entirely by the need to patent the gene itself. So I question the empirical evidence that drives the need that says that we're that we're hurting for investment, and we need the patent incentive to get there.
Go for it.
Yeah, well, okay, here you go.
So I just want to say, I mean, this is something that came up at the hearings in June, and we actually had someone from the company Invitae who testified that, in fact, there's been just this enormous surge in genetic testing, research, and development. But the thing that stuck out to my boss, to Senator Coons, and frankly to me, was that a lot of that is being done pursuant to trade secret protection. There's nothing wrong with trade secrets. Senator Coons was really instrumental in the Defend Trade Secrets Act, but there is a problem. Like when we talk about patents, you got to remember patent is, to use a loaded DC term, a quid pro quo.
Too soon.
Yeah. I mean, so we focus a lot on this exclusive right that's been granted and how that's used, and royalties and possibly injunctive relief can flow from that. But the flip side of that is that the invention is disclosed to the public, and the next person that comes along can build upon that idea and improve that idea, maybe design around that idea. And if everyone is resorting back to trade secret protection, we really lose that benefit of the patent system, and that's something that we're very aware of as we're working on this issue.
Kate, you look very eager to jump in.
I am a little bit, because I've heard this trade secret argument a lot, and I'm not sure that it's true when it comes to, at least to genetic testing, where a lot of the companies that engage in the genetic testing are actually disclosing what they find to databases like ClinVar, where they are then open to researchers to use and discover what the meaning of new mutations are. So you discover a new mutation, you don't know, and please, I am not a geneticist. Call your friendly neighborhood geneticist and ask them to correct me if anything that I say sounds strange. But from what I understand, when they identify new mutations, they go to ClinVar to determine whether this is a positive mutation, a harmful mutation, or something that we don't actually really need to worry about. And it's going into a store of knowledge for people to look at. There are certain companies, is also my understanding, that are maintaining the new mutations that they find as trade secrets. One of them, I'm pretty sure, being Myriad. Now, that's their choice, but not everyone is doing that. And the norms of scientific research and discovery are to share information and to disclose what you find in order to increase the store of knowledge so that we can all treat patients better and so that we can all understand ourselves better. So I'm not really sure that trade secrets are the place where everything is landing. I'm not sure that that's the case.
And if I could just jump in, one additional point there. I mean, at least in tech, for the kind of lack of disclosure argument to really have a lot of impact, we would have to have much stronger enforcement of the current disclosure rules, right? People in tech don't read patents, not because they're not interested in patents, because typically the patent doesn't tell you how to, as a practical matter, actually do what is claimed in the claims, right? So a technologist reading the patent often gets nothing out of it other than what the desired result is of whoever filed the patent. And knowing people's desired results is typically not, from a technological perspective, all that useful.
So I want to pull back to a bigger question, which is, David, in your remarks, you drew a very clear distinction between where the debate is in the life sciences and where it is in the software or computing world. And observing from when I was on the Hill and even now, it is true. It seems to me that there really is a different caliber in the level of dissension, but also the urgency of need of those advocating for reform. That butts up against a very long-standing precedent of treating a unitary patent system and thinking about holistic reforms. So Phil, I wanted to start with you about how you're thinking about that tension and if there's any world in which a piece of this gets separated out for reform versus thinking in the comprehensive way we've historically thought about 101.
Right. So I think the short answer is no. Senator Coons at least feels very strongly that he would like a comprehensive fix for 101, and he would like for it to be technology neutral. And I know there are some TRIPS treaty obligations at play there as well. But with that said, I'll say that it's one thing to be facially technology neutral, but there could be a way to craft some provisions such that they affect some industries differently than others relative to the status quo. And that's is something we're considering. But in terms of just splitting off, for example, the diagnostic world and crafting a new form of protection or something like that, not really in consideration. The other reason for that is, frankly, we've talked to a lot of companies in that space and have asked them, it looks like we're running into some resistance with comprehensive 101 reform. Would you like us to explore this narrower targeted fix? And I really haven't had anyone say yes. And the primary reason that is given for saying no is that it's not so easy to carve up what is a diagnostic, and particularly with things like artificial intelligence, we have a lot of convergence between different areas of technology, fields like bioinformatics. So a long way of saying probably not.
I would add a political observation to that. So being in a field that's always felt there's one patent law for us, at least for pharmaceuticals, right, and one patent law for everybody else, it won't surprise you that the question has come up, like within our field, saying, shall we pursue our own solution? Because there are a million solutions that are just for us and a million problems that were created just for us already in patent law. I think it's true. I think people are very committed. The people, the usual suspects, the crowd who helps work policy in this space, I think has a longstanding commitment to a unitary patent system and its widely accepted dogma, even though it might not even conform to present reality. The other thing I would observe is that I think there's a belief that, being together, all of us who are affected by this in pursuit of a solution will create more momentum for congressional action. Right? If we
Not more opposition to?
Yeah, well, and maybe more opposition to it as well, right? If people start peeling off and leaving everybody else in the dust, somebody will be left in the dust with their problems unaddressed, right? Biotech comes out smelling like roses, and whatever business software, gets left in the dust. Right? They won't be happy about that. And
we're happy to be left in the dust on this issue.
Well, we're not going to make friends, or maybe. So I think there's all sorts of reasons why, for the time being, I think people don't want to entertain the pursuit of sectoral solutions. So we'll see. Right? I think it will help for people to articulate what is it that you can't patent right now that you would like to have to be patentable.
Mm-hmm.
I was reminded when we were talking about genes, we don't care about human genes, right? They're a phenomenon of the 1990s to the extent they were patented, but we would like to be able to patent novel antibiotic substances and industrial enzymes, which are falling under the Myriad case, right? That was one thing that we were worried about. We were saying, you're going after genes and you're going to make the medicinal substances unpatentable. If that was one of your objectives, please tell us now, because back then you were saying, no, this is only about Myriad. And
I did not
genes.
litigate Myriad, and I was not at the ACLU at the time, but I can confidently say that we agree that those should not be patent eligible.
And what distinguishes an antibiotic that you discover in a fungus from an antibiotic that you discover in a reaction tube in the laboratory? Because there's no difference in its utility.
And there's no difference from whether they're a product of nature, right? Like if you have changed the bacteria through human intervention, then you have a new product that is patent eligible. But if you have not, if you have merely discovered it, either, isolated it from someplace in nature, or you've isolated it in the laboratory, it's still a product of nature that is not patent eligible.
Yeah, so you're making a normative argument saying the one thing that was just discovered of nature, we just don't want that to be patentable. Rapamycin, it's a good example, right? Immunosuppressive substance was developed into a drug at great expense. The only difference to some other immunosuppressant is this one was discovered after looking for it in a fungus from Easter Island, right? In other respects, it's a drug like any other drug, just as expensive to develop and seek approval for, and it works just as well, right? So there's really no difference other than saying it's because of the origin of this medicinal substance. We don't want that to be patentable, and the other one we allow. Right? You see what I'm saying? Well, there's no practical difference between the two other than the circumstances under which they became known to man. Yeah.
I don't think so. I don't think, maybe I'm not understanding the distinction that you're making, because I don't feel that I'm making a normative argument. I think I'm making a legal one based upon what the Supreme Court has said is a product of nature and what is a something that used to be a product of nature, but has gone through an inventive transformation and is now a patent eligible product.
Well, yeah, so.
Hans, I'm going to give you one more minute to respond, and then this gets continued over drinks this afternoon. We're going to do a couple of audience
We'll do that.
questions.
Right, so if you agree that we can patent the antibiotic in a form of a tablet, formulated in pure form for the first time as a medicine.
If it's different than it was when you discovered it.
Tablets don't grow on trees, so maybe that would be okay.
Yeah.
But then frankly.
I mean, you guys are working on it.
All right, I'm moving this to a reception conversation.
In the spirit of just a brief observation that, Kate, I think I heard you say human intervention would be a good touchstone for eligibility. And earlier, Dave, I heard you say technology, and those are the two touchstones.
Let me give you again. I mean, so getting back to Alex's point.
Changed the actual product. So if you made the gene into something that wasn't a gene, okay, fine. If you made a new bacterium that does not exist in nature, then yes, the Supreme Court has said you get to patent that. There's direct precedence finding that. So. Yes, I hear why that was a good get.
Just giving you a hard time.
Yep.
and it was deserved. I appreciate it.
All right, I'm going to open it up to audience questions. Can you come to the mic just because we're recording, so it'd be helpful for the audience online? Thank you.
I think I can help put a little face to this whole problem. This is a lot of abstract discussion, but I've lived this world, okay? My team and I, we had a big hand in developing the technology that Ariosa built off to develop the test that replaced amniocentesis with blood tests. The Nobel laureate, Hamilton Smith, who helped develop the Genome Project and make that knowledge available to the world, was the person who interviewed me for med school when I went to Hopkins, okay? He helped me graduate from the MD PhD program, and when I was in residency at Harvard, he encouraged me because he had left Hopkins to start the Genome Project with Celera, with Craig Venter. I'm sorry if I'm a little upset, because my blood boils when I hear some of this stuff, particularly from the ACLU, which I do. I'm a fan of the ACLU, but I believe you all need some science knowledge, and I'm happy to provide it if you need it, okay? But look, Hamilton Smith left Hopkins Med School after the Nobel Prize to start the Genome Project, and I can tell you right now, his blood would boil too, because he'd probably be pretty damn pissed off to hear how little has been done with the Genome Project since he published it with Craig Venter. Because it costs a hell of a lot of money to do anything with those genes. I was in residency at Harvard in a very comfortable position, in a very comfortable field. I talked to Ham Smith in the mid-1990s, should I leave my residency, because I had an idea for how to replace amniocentesis with a blood test. I left my residency, I built a team, John has been with me for almost 15 years. My investors, I left my residency, started a company. My investors literally spent the type of capital that Hans is talking about to build diagnostic technology, tens and tens of millions of dollars. We published the technology because we got patents, because I agree with Phil. The whole point of patents is to publish it, is to encourage us to publish it. We published in JAMA, Lancet, New England Journal, so that companies like Ariosa could build off the work that we did to bring the technology to patients. 2012, I learned of this AIA thing. So we haven't published anything since then, okay? Not only that, but it pains me to not develop things that I know my team and I could develop to save thousands of lives. And I'm glad scientifically that my team and I invested the effort, which has now been 18 years of effort, to develop the technology so that many women all over the world can not have a miscarriage due to amniocentesis, okay? My wife had, a miscarriage that encouraged me to get into this field to begin with. That's how I got the idea to go after this field. But I cannot encourage the next generation of Hopkins students or Harvard students or University of Maryland students to leave their residencies to go start a diagnostic company if this is the mess that they face, okay? Thousands of lives will die, or people will die. I've seen those phone calls from patients calling me to develop something for them, and I can't do it now because of this 101 BS, okay? And so, Phil, my main question to you is, Kate, I'm going to have to talk to you in private to give you a science lesson. But Phil, just because, I respect you, but you don't understand science, okay? Phil, my main question to you is there any hope for diagnostics? Because worse than me having to, we would have to walk away from diagnostics if this situation is not solved. I've committed most of my career on building diagnostic technology because there's one simple thing I learned in med school. If you can't diagnose it, you can't treat it. So Kate talking about therapeutics is where all investors want to go. That's a bunch of BS. Because investors want to help with diagnostics.
I don't mean to cut you off, but I thank you for sharing your thoughts. I want to have a chance to respond.
Is there hope for diagnostics? That's my question. Otherwise, we're going to have to just walk away from this damn field.
Well, I sure hope so. And Senator Coons really hopes so as well. He has quoted Judge Lynn's opinion in the Ariosa case many times as being an example of his specific concern about diagnostics. We are still working very hard on the Hill. I will tell you that even if we reach consensus, right now very few bills are making it through Congress, especially in the Senate, without unanimous consent. And based on this conversation, I think we're a ways from that. But I'll also mention there is the cert petition pending in Vanda, and also the Athena case that we've been discussing. And even if we don't get anything done in Congress, I was encouraged to see a lot of the hearing transcripts cited to the Supreme Court. So I'm hoping that they will notice that, yes, this is a big problem. This is something maybe we can also try to address.
So could I just jump in on a more general point here? I mean, diagnostics has always been an uncomfortable fit with the patent system. And the patent system was really designed for technology, right? Most, at least as I understand it, of the diagnostics, these days at least, is matching up I think you kind of mentioned this, matching up a specific gene mutation or gene sequence to a disease state.
David, I hate to tell you, you understand science less than Kate, okay?
Okay, explain to me how that's technology. Explain to me how pure information is technology.
You know how much work is required, human intervention, as Phil describes it accurately, to take the genetic information and actually make it into something that a patient can benefit from. And I'm not talking about just the Myriad case. I mean, my God, we have done so little with the Genome Project compared to what it could be done if it weren't for this type of changes.
David, if you respond quickly, and then there's another person.
I don't need to respond. That's fine.
Okay, thank you. Thank you.
So Ariosa versus Sequinome is a perfect case to respond to you, Hans, about where 101 does work that 102 and 103 can't, precisely because if you treat the discovery of the cell-free fetal DNA, which is hugely important, thank you, as if it were prior art against the applicant, then there is no other inventive concept in what is being claimed, which is the method of using it, because what else would you do with the damn thing except prevent amniocentesis and measure for the defects? That's why what we need to get to, if we're going to go down the line of technological, is distinguishing what is categorically excluded as such, and then how to treat that stuff in regard to the invention behind the claim, the inventive novelty of the claim. Europe does it by saying that excluded matter as such doesn't contribute to the technical effect. Section 14 of the AIA says tax liability methods don't contribute to distinguishing novelty. 101 says treat the discovery for the reasons that Kate has said of keeping everything free as if it's already prior art. Find a different inventive application to then patent, not just mere application. Or we can just say everything is free game so long as it fits in the 4 categories. We're going to use other measures. But you've got to decide that when you write the legislation, or we're just going to constitutionalize the question.
Okay, we have one more question.
I have 2 really quick questions. First to Kate, I feel like your arguments against genetic testing patents actually like high price for patients and I guess preventing other companies from entering the field apply equally to pharmaceuticals, right? So I guess in your view, do you think those pharmaceutical patents should be also patent ineligible? So the second question to the panel, do you think if we replace the current 101 with, say, a shortened monopoly, is a viable solution from, like, say, 20 years to 15 years? Would that be a, good way of solving the problem? Thank you.
Sure. So to your first question, I describe lack of patient access as one of the problems that resulted from the fact that an ineligible substance was granted patents. As far as there being similar arguments made about drug patenting, I don't actually, the ACLU doesn't have a position on drug patents or the changes that are being discussed right now in drug pricing.
Anyone else want to comment? Okay, well, thank you all. Please join me in thanking this panel. We have a 10-minute break, and then we'll come back for our last panel of the day before our reception.
Friends, this is my group of diehards, I can tell. You've made it to the final panel. This is going to be the best panel, because I tell you, I had a dream. I wanted to get the three Georges together. All right, I wanted to get George Mason, George Washington, and Georgetown together on one panel, and we finally did it. I am grateful. Hey, friends, you know, Alex Givens, we're getting going here. Who else do we have? David Jones, Suzanne. We're trying to get it going here. All right. So, students in my class now, ask Joe Top. Acoustic. Come on, you guys are setting a bad example for the rest. Come on, Joe. All right. Anyway, I wanted to get the three Georges together. I am grateful that our food went to Georgetown's main campus rather than George Mason's campus at Fairfax. That would have been trouble. We get deliveries from you all the time, and vice versa. So it's a great pleasure to introduce the last panel. I'll do it very quickly. I'm grateful to have Dimitri and TJ here from GW and George Mason, our rival law schools. But actually, it's really great to be in DC because we have this basic cadre of patent professors. And it's quite a pleasure to interact with you. David Olson is another newcomer to this panel. Boston College and Georgetown really have an historic relationship because of Father Drinan. Remember Father Robert Drinan? He was on the BC faculty, and then he came here, and it's a connection that binds our faculties, and he's certainly well remembered here. Ken Correa is the only one who's not the newcomer to the panel. In fact, he's been a longstanding friend of this conference, so it's really great to have you up here. Ken, I think, has had one of the most diverse legal careers I've ever heard of. He was a federal prosecutor, then he became a law firm partner litigating patent cases, and now he's head of the Silicon Valley U.S. IP Center for Samsung Electronics. So that's quite a bit of functions in the courtroom and in the boardroom, and we're keen to hear your remarks, Ken. So thanks a lot. Thanks for stepping on up. And helping us out. This is the best panel, I think, because we're just going to shoot through some fun cases that have come out, interesting, significant cases. I've asked my colleagues on the panel to present a few. We're not going back to 101. Not going to happen. All right, we're done. We don't want to get heckled here or something like that. And we won't talk about IPRs either that much, though we could talk about sovereign immunity if you wanted. But I'm going to ask Dimitri to begin. He's chosen a few cases he liked and to tell us about it, then we'll sort of go at it. Thanks, Dimitri.
Thanks so much, Jay, for the introduction, and thanks to Georgetown, Alex, to Jay for the invitation and putting together this fantastic conference. Being a local, I've lurked at this conference before and seen excellent programming, so it's a pleasure for me to be now on the other side and to be on the panel and to speak to you. Thanks for sticking around. I will keep my remarks brief so that we can have some time for discussion and debate as well as a reception, which may be the most important part of it, right? My interest is in two cases that I think affect the pharmaceutical space in patent litigation, but also maybe beyond. And these cases that I've chosen to discuss today are the Accorda versus Roxanne case and the Eli Lilly versus Hospira case. The Accorda case is an obviousness case, a Hatch-Waxman obviousness case that, among other things, raises the issue of so-called blocking patents for secondary considerations or objective indicia, which I think is very interesting. The other case, Lilly versus Hospira, raises the issue of tangential relation exception to prosecution history estoppel and DOE assertion. Again, two discrete issues that I think are certainly not under the radar. People have paid attention to these cases, but I think might have some significant impact in years to come in pharma and beyond. So the first case, as I mentioned, is Accorda. It's a fairly standard obviousness pharmaceutical case in some way. The drug at issue in that case is called Ampera. The chemical is 4-aminopyridine, and in particular, particular, the claims in the patent, in suit, the patent that became an issue in this case were directed to a particular dosage form of a sustained release form for aminopyridine for multiple sclerosis. Particularly, the idea there is to improve the flow of potassium, right, to relieve some of the potassium channel blocking and therefore deal with MS and particularly walking problems that MS can cause through demyelination. So very significant from a healthcare perspective patent, I think. The district court, I think it was Judge Stark in Delaware, invalidated the claims under obviousness grounds. The Federal Circuit affirmed in a divided 2-to-1 decision with Judge Taranto writing, Judge Dyke and the majority, Judge Newman dissenting. The beginning of the case is actually rather standard sort of non-obvious analysis. There are factual issues relating to motivation, teaching away whether the prior art, which involved a lot of studies involving MS and related molecules, whether the prior art sort of taught away from the specific stable dosage regimen that was claimed, and in particular, whether sort of the idea of titration, which was important for treating this sort of illness, was something that would lead an ordinary artisan in a different direction. There were a lot of fact findings there by the district court. District court basically concluded there was motivation, reasonable expectation of success with coming up with this particular claim limitation of dosage forms of aminopyridine, and I think that may have been maybe enough, but there, of course, as often happens in these pharma cases and other non-obviousness cases, the patent owner introduced evidence of objective indicia, in particular commercial success, long-felt need, and failure of others to come up with a successful multiple sclerosis drug. And I think a fairly short and underappreciated part of the opinion, although there was a cert petition on this that got denied earlier this year, the Federal Circuit said that there was a reason to discount this evidence. Why? Because Accorda, through licensing, acquired a dominant patent, so a patent that basically claimed this particular molecule, but also a larger genus of molecules, again, as often happens in pharma, covering basically the same ground, and the patent it was asserting was a narrower patent directed to specific dosage form, specific molecules, but because of the dominant patent that covered this space, others basically could not compete with Accorda in developing an MS drug with this sort of formulation. Again, the court went through the various objective indicia that were asserted, commercial success, failure of others, and long-felt need, and said they all could be discounted sort of in terms of favoring the patentee because of that dominant patent, so-called blocking patent. The court talked about blocked space, so the ability, because the patentee has owned a dominant patent, the patentee has excluded others from making sort of similar molecules and their equivalents, and said that the commercial success, while it could be attributed to sort of the intrinsic technical value of the drug, could also be attributed to the fact that there's no competition from other companies that would have been discouraged for pursuing research in this area due to the dominant patent. So there's some precedent in the Federal Circuit law for this notion that blocking patent could lead to discounting of evidence of objective indicia in favor of patentability. What was interesting about this case, and again, the analysis is quite abbreviated, I would think, is applying the same reasoning to ex ante, so not exposed evidence of non-obviousness like commercial success, but to ex ante evidence like long-felt need and failure of others, right? So the ex ante evidence there was, there was a need for a drug, people weren't coming up with it for a while, and the district court said something, probably Sanofi tried to develop an MS drug, but they probably weren't looking in the aminopyridine space because there was a patent on it already. But there wasn't sort of fact-finding as to whether they were actually considering this area of research and were deterred, and so on. The court just sort of assumed that because there was a blocked space where people wouldn't have gone there, and the Federal Circuit affirmed that finding. And with respect to basically failure. This is a failure of others. Part of it, the other drug that Sanofi tried to look for MS succeeded, and long-felt need as well. Sort of the patentee, the idea being the patentee controlled the need by having this dominant patent, and sort of by the time he came up with a solution. So I think that was fairly novel, right? One of the points that Judge Newman made in her dissent is that long felt need exists independent of patents, right? People need this drug and the need is out there. The fact that it was not met because of patents is a different story, but the need was sort of not patent related necessarily. And she, along with disputing the majority's conclusion on motivation and what the prior art taught, whether it taught a way toward, she thought that the majority gave short shrift to objective indicia because of the sort of blocking patent dynamic, right? So the need, regardless of the patents, right, the need was still there, and the patentee met this need. And there's sort of a familiar accusation, perhaps, of hindsight reconstruction, right? If the need is defined as a molecule, particular class or particular structure, right, then of course, what about, there are potentially other ways to treat MS, but that sort of gets taken out of consideration if the need is defined basically around the class of molecules that the patentee had been pursuing. So I think this case raises some interesting issues related to motivation, right? There are a lot of times people would be discouraged from pursuing a line of research because of the patents of others, or perhaps because of the costs of a project needed for FDA approval. Are all these other things perhaps, can they be used to discount the patentee's commercial success or the patentee's meeting a long felt need? It's hard to say, but for now, I think the blocking patents doctrine is here to stay. I think it's raising interesting issues as to who bears the burden of proof. For example, obviously the challenger has the ultimate burden to prove invalidity by clear and convincing evidence. However, the patentee has a burden of production on objective indicia, because that's the evidence that favors the patentee, right? But who has a burden of proving that the others were deterred by a patent in this space? Right, it's not entirely clear, and how much fact-finding around sort of deterrence, the actual blocking effect of patents is something that is interesting to see whether it's going to develop in the future, right? But I think the big expansion of the blocking patent doctrine, from my perspective, is application of it to ex ante objective indicia, such as specifically long felt need and failure of others, right? And whether others failed because of the patent in the space. And the second, so that's Accorda, the first case. I'll give you a rundown very quickly. The second case I'm going to talk about is the Lilly versus Aspira case. That's a DOE case, a famous sort of drug that's been litigated around the world involving a chemical called pemetrexed. It's a chemotherapeutic drug, and the discovery there was that a presence of vitamin B12 essentially relieves some of the harsh effects of chemo. And what happened in prosecution is that there was some prior art against these sort of anti-folate drugs, which were claimed broadly, and the patentee narrowed the claim to pemetrexed disodium, which is what they invented. Disodium, the sodium salt part of it was not as important as the pemetrexed part of it. And the defendant in this Hatch-Waxman case was proposing to use essentially an amine counterion in the litigation, but pemetrexed was still the active ingredient. It would dissolve in the body and basically act the same way, but the claim was limited to the disodium salt after the narrowing amendment. Now, the general rule coming from FESTA, right, is that if there's a narrowing amendment for reasons of patentability, which here it was to overcome the prior art, there's a presumption of prosecution history estoppel, but the presumption can be rebutted, right? So if the equivalence given up, so in terms of asserting equivalence against the defendant, presumption can be rebutted by arguing that the equivalence at issue are unforeseeable, only had a tangential relation to the equivalence at issue, or some other reason, as Justice Kennedy said at the FESTA, which I still struggle to tell my students what it is, but there are at least those two, right, that you see. And tangential relation exception has come up in cases before. In this particular case, in the Lilly case, it came up in a big way because, again, the defendant, seeing that the equivalents are given up and the claim was limited to disodium, decided to use a different counterion. But the court, in I think, unanimous opinion by Judge Lurie, concluded that the tangential relation exception to the prosecution history estoppel could still be invoked by the patentee because the idea was not to give up the entire space, right? The idea was to just narrow it to a particular drug, pemetrexed, to get over the prior art involving other anti-folates. And the patentee, even though it's probably a prosecution mistake, didn't mean, or there's not significant from the inventive perspective, essentially to limit the claim to the disodium salt. I think the case has been somewhat controversial, although the en banc petition was just denied. There's a case raising similar issue called the Genomoto versus ITC, where the in-bank petition, I think, is still live and could come up in the near future. But for now, I think which came to the same conclusion, right? Sort of more of an expanded view of when the patentee can invoke tangential relation exception to avoid estoppel. So we'll see the developments there and see what what future decisions will come up with, both in terms of asserting blocking patents to discount objective indicia and also relying more on tangential relation to avoid prosecution history estoppel. Thanks.
Dimitri, when we have commercial success, we rely on this chain of inferences, right? So the idea is, okay, the product made a lot of money. Other people would have realized the product was going to make a lot of money. They tried to make the invention and failed. But we don't actually look at that backstory. We just assume it. Now, there's long felt need and failure of others that looks at it, but commercial success just has the inference. So this is the same for blocking patents that, I did a prior art search and I found this patent and I got an opinion from counsel and I decided not to do it? Or is it just that the fact that there's a patent out there and people are presumed to have read it and been chilled?
So it's an interesting point. I think at least where the patentee is held, is held to a higher standard is the nexus requirement. So while you don't have to show that the commercial success was in the face of a particular need, at least you have to show the nexus to the technical merits of the invention, right? And not, the success could not be due to advertising or some other factors. So in a sense, I think these blocking patents arguments strike at the nexus issue, right? The success was due to other patents and not to do technical merit of this invention. But I think in terms of, so I think there's kind of a reverse nexus issue perhaps, or its own nexus issue for blocking patents, right? Was there connection? Was the research of others deterred? And I think that's a much tougher question because they're dealing with a whole industry, potentially third parties that are not before the court, right? That may have failed for various reasons. It even could be kind of secret, confidential business information. So on the one hand, I think it's good to have some kind of proof that people were deterred or blocked by these patents or thought it was uneconomical to license them, right? Because again, the idea of the majority is that people would not expect to make profits because they'd be immediately sued for infringement, right? And maybe enjoined for making this product. On the other hand, the fact that actually happened is a good question, but how we find out, I think, as a practical matter, is kind of tough. But I do think that there's a lot of presuming in this area of law without evidence on both sides of objective indicia.
Other observations from the panel? Good. Dimitri, do you think the doctrine of equivalence is back?
I certainly see a lot of cases, I've seen a lot of cases in the past couple of years involving a doctrine of equivalence, and an interesting development in this area was a case not dealing with prosecution history estoppel, but just a sort of assertion of DOE. This is the Amgen v. Sandoz case that is the one all the way to the Supreme Court, a different issue, right? And there the Federal Circuit said that the DOE is an exceptional doctrine. It's not to be applied in every case, and there was an en banc petition that basically succeeded in having that language stricken from the opinion, right? So it's no longer viewed as an exceptional doctrine. It's asserted case by case, of course, but I think the arguments that DOE is not available as a matter of law, I think, are maybe being limited. The so-called vitiation doctrine, I think, has been somewhat limited by the Federal Circuit recently. And the prosecution history estoppel, which of course is decided as a matter of law, is also limited, right? There are at least factual questions, and plaintiffs can continue to assert DOE and hope to succeed in front of a jury. So I think it's back somewhat.
Great. I've asked Ken to go next. So please.
Yes, Jay assigned me two cases. One is Peter versus Nanquist, and the other is Power Integration versus Fairchild. I'm going to discuss those two cases, and I'm going to briefly mention Sprint versus Time Warner. Nanquist is a Supreme Court case. I think the oral argument took place last month. Facts are as follows. Unsuccessful patent applicant can appeal directly to Federal Circuit under 35 U.S.C. Section 141, or file civil suit in the district court under Section 145. If you choose the latter option, Section 145 provides that all expenses of the proceeding shall be paid by the applicant. So when the Nanquist appealed PTO's decision in the district court, and when proceeding was over, PTO wanted to get paid. or attorney's fees, or rather the money that PTO paid to its attorney and paralegal staff. Fed's district court denied it, and thus PTO appealed this Federal Circuit. No, I'm sorry, it's the other way. I think the district court allowed it, the Federal Circuit reversed it, and it was appealed to the Supreme Court. So PTO raised three arguments. One is that expenses are not a term of art like cost is. So thus, under plain and ordinary meaning of expenses, the money that PTO paid to its attorney and paralegal staff should be allowed. Second, they said we're under congressional mandate to be self-sustaining. So sure, we could raise everyone's application fee to cover extra expenses associated with the district court litigation, but that would be unfair. So we should be charging this to the applicant. Look at it more like part of the application process. That was one of their arguments. And I guess third argument is that applicant has an option to appeal directly to Federal Circuit under Section 141, in which case the applicant does not have to pay anything. You know you're in trouble when the justices start asking you a question. So was it 150 years or 170 years that you have taken this position under Section 145? And I forgot his first name, but Mr. Stewart from Solicitor's Office acknowledged was indeed first time in 170 years that PTO has asked for attorney's fees under Section 145. And also, Mr. Stewart had to acknowledge, I think the question from Justice was that, isn't this a radical departure from your own practices? How many federal statutes, and there were 3,300 statutes that provides for expenses, has government asked for attorney's fees? And Mr. Stewart said, frankly, none. So things were not going too well. So even though there is no decision, I don't believe that, I don't think the government is going to prevail. Nenquest made several points, but yeah, one point they made was that, look, when government says this is a part of application process, nothing can be further from the truth. This is a civil suit filed in the district court, adversarial process, and under American rule, everyone bears his or her own attorney's fees. So my bold prediction is that government is not going to prevail. Next case is power integration versus Fairchild. So it's really apportionment case. The seminal case in the apportionment is the Garrison versus Clark Supreme Court case, where Supreme Court said if you want to collect damages, the patentee has to provide evidence that separates or apportion defendant's profits and patentee's damages between patented features and non-patented features. And the Federal Circuit reaffirmed that in laser dynamics, and that is known as apportionment requirement to damages. There is an exception to this rule, EMVR, or entire market value rule exception. That is that in the context of multi-component product, if you can prove that consumer demand was driven by the patented feature, you can actually collect royalties using entire revenues from that multi-component product. So this particular case, Power Integration and Fairchild have been suing each other for the last 15 years. So there are many different Power Integration versus Fairchild cases. This particular case has to do with the two patents that Power Integration used to successfully sue Fairchild against their power control chips. I think the patent, one particular patent goes to the fixed switching cycle. And Power Integration's expert, who was not allowed to testify on apportionment on Daubert, but was allowed to testify as to entire market value rule. So he said there is such thing as a 1 watt power efficiency standard by US government, and the only way you can meet that standard is through this fixed switching cycle. And that is what drove the demand for power control chips. Thus, we are entitled to use the whole revenue as a base for our revenues. That really did not succeed. I think the reason was that government market is not the entire market. It's one of the sub-market for this particular chips. And the second thing was that, unfortunately for power integration, its own CEO took the stand and testified that this particular infringing chip had other useful features, such as jitters and soft start. I don't have to tell you what those are because I don't understand what they are. But the thing is that the third reason was that there are many litigation between the two, and in fact, it turned out to be Power Integration sue Fairchild on those exact same chips using patents covering the jitter feature. So I think that based on those, Federal Circuit decided that this entire market value rule requirement was not met. And Supreme Court, that was last year, Supreme Court denied the cert, so that's the end of the case. And then parties settled last month. So I guess we're probably not going to see too many Power Integration versus Fairchild. But I kind of want to contrast that with another apportionment case, which is Sprint versus Time Warner. Sprint had 5 patents covering voice of IP, and they sued Time Warner and was able to collect royalties on the basis of entire revenues from the Time Warner's network, even though it has other useful features. And the way they were able to do that was that they used comparable licenses. And I think it is, I guess, in that respect, it's not that unusual because there's a Sauter versus Cisco line of cases where a Federal Circuit that says you can do that. And the rationale there is that these comparable licenses are already apportioned. But is that really right? Because oftentimes, so-called comparable licenses are not apportioned. In fact, they use entire market value rule as the basis for calculating royalties. I think Federal Circuit has to come back to that, is that, look, that is a reality, industry reality, that's the practice, so we're gonna let it slide. Well, 25% rule of thumb was reality until Federal Circuit says that's not permissible. In fact, in the Sprint versus Time Warner, Sprint's own expert used verdict of a previous case, Vonage case, where the expert for Sprint did exactly that, the rule of thumb, 25% rule of thumb. Yet Federal Circuit allowed the verdict to stand. So that's a problem. I mean, how do you get around the apportionment requirement using comparable licenses when comparable licenses themselves has not met the entire market value rule? So I think the Sauter versus Cisco line of cases where you can actually utilize the entire market value rule without meeting the requirements for that exception is simply inconsistent with both the Gerritsen versus Clark and as well as laser dynamics, and I think is a live issue. And unfortunately, Supreme Court decided not to grant cert in Sprint versus Time Warner, and probably because it was non-presidential case. But I think I'm hoping to see that this issue being re-litigated sometime in the future.
Ken, that was very helpful. Thank you. There's a bit of economic literature on nudges and things of that sort. And, should we charge unsuccessful patent applicants fees and the successful ones not, right? Because that way you'd be pretty highly incented to get a good application together, right? Talking like at law school admissions offices. Should we make it free, but if you get rejected, you have to pay, right? So that would discourage applications that don't have a lot of merit, right? So here we have a fairly seemingly vindictive USPTO charging a lot of money, right, for sort of an unsuccessful applicant. I'd hate to be the chief financial officer of the USPTO. I don't know how that person sleeps at night. Try to forecast how many applications are going to come in through the door, economic cycles, the impact of judicial opinions and congressional enactments. Maintenance fee payment. How many maintenance fees are going to be paid? Some say that maintenance fees, encourage the agency to put out quality products. Others say that there's so many back-ended fees with the allowance fee and maintenance fees that the agency has to grant a lot of patents, otherwise it would go broke. It would have to furlough people, right? So this sort of strikes me as sort of part of this theme of sort of, cost-based pricing that the agencies got into. There's sort of only a high single-digit number of these suits to the Eastern District of Virginia every year. So I don't know how much money we're really talking about it. Ken, I did listen to the argument, and maybe you're right about the precedent and the agency, but I know one thing: the Supreme Court likes precedent, its own precedent. Okay, that doesn't care about anybody else's precedent. So we'll see through the federal circuits. So let's see what comes. But
justices were asking questions such as, well, does that mean that you're going to charge a portion of electricity to the applicant? And how about your time, Mr. Stewart? Your time here, you're going to charge that to the applicant too? So they're pretty cynical.
Okay. Comments from other panelists about either of the cases?
So on the entire market value rule, right? So I've always understood the entire market value rule when we were talking about an apportionment, when we were talking about Garrison versus Clark, because Garrison versus Clark was in an era where you could recover not only actual damages, but infringer profits. And if you're recovering infringer profits, then you either have to apportion or you have to evoke the entire market value rule, and then you get all of the profits. And that was perfectly comprehensible in that there was no way to divide up the infringer profits in comparable licenses, because you really weren't trying to measure comparable licenses at all. When we're getting to the point of trying to apply the entire market value rule to reasonable royalties, at least as a mathematical matter, I've never quite got the kind of policy logic of why you would actually kind of care in that the royalty rate and the royalty base kind of automatically trade off from each other. Now, there's a pretty well-known psychological effect, which trial lawyers are perfectly aware of, which is that you want a big base from the entire market value rule as a plaintiff, because then kind of juries will psychologically also inflate the rate, or they won't properly discount the rate in proportion to the base. But in terms of the split in federal circuit law, where you have some cases that say, look at the comparable licenses and just figure out the base from whatever those comparable licenses use, and then you have the different line that says, figure out the base using the entire market value rule, where if the rule applies, then you use the entire product, versus if the rule doesn't apply, then you use the smallest saleable unit. I'm not sure why kind of we ever ended up with this dueling lines of case law, in that I would have imagined that the proper way to do it is to figure out the rate and base at the same time and kind of trade them off each other to reach the correct number based on comparable licenses, whatever other evidence you use. Now, in the cases that reflect the split, how do you think that they reconcile with each other?
Well, many things in this area, sometimes they are not reconcilable. But from from the industry perspective, and here's an issue. When you overcompensate innovator, it creates inefficiency. Whatever extra dollar you pay to the inventor, that's beyond his or her own contribution. That's a dollar we have to pass on to the consumers. And supposedly there are 250,000 patents covering smartphones. Whenever that happens, then consumers at the end of the day suffer, and there's less money for R&D, and that surely doesn't help with the innovation aspects of it, and thus defeating the whole purpose of having patent system, which is to improve the state of useful art and the progress of technology.
I think there's an interesting issue out in the market, out in the real world, and maybe somebody can speak to this in the Q&A, but absolutely, it's right, of course, that, the base and the royalty rate, they trade off against each other. So mathematically, it doesn't matter, but psychologically it does. And we are with the case law we have, which is, entire market value or smallest saleable unit. But it's all hard to do. It's hard to figure out what should be the percentage, what should be the royalty. So of course I don't see the courts moving away from turning to, wait, here's some real world examples that look pretty similar. Let's take that as our royalty rate. So then what I'm interested in is, if you think you're going to be on the plaintiff most of the time, and you also actually have a licensing practice, are you out there trying to write licenses using the entire market value as your base? And given a nice low royalty, and vice versa, if you're out there and you're doing some licensing, but you're worried, maybe others might sue you, are you tempted to then not use the entire market value rule, but use a much smaller base with a higher royalty rate? How much do you try to prime what will be the exemplars look to in damages cases that you may be involved in?
Current system is sometimes not workable because I think both Fairchild and Time Warner case, I think the royalties per device or per user that the plaintiff got was in excess of the selling price of the chip. I think chip was selling for like 90 cents, and I guess if you convert that $100-some million damages was actually more than the price of chip. So that's the reality that a lot of companies have to live with, is how do you stay in business when you have to pay royalties that's in excess of your selling price?
So I'll just add a small comment to this already very helpful exchange, and I think Ken's comments in this discussion points up a fundamental tension, right? Georgia-Pacific is supposed to be about what parties rarely do in negotiations, and the process is supposed to approximate that, which could mean a real license. Sometimes ex ante you might overpay for a patent and end up later on having a price that's too high or too low or whatever. But it's the idea is that Georgia-Pacific is supposed to be ex ante, right? And to me, Power Integrations is very much in tension with Lucent, which is a foundational case in this area, 2009 case from the Federal Circuit that says the main thing we'll look at is what parties actually do in negotiations. We use it as a starting point. I mean, yes, later that was refined to smaller saleable unit and so on, but the idea is you try to approximate what actually happens rather than create these artificial seeming apportionment rules.
Briefly on that, I've always understood the entire market value rule to kind of result in inflated numbers only if you manage to pull a trick, which is you determine the base by the entire market value rule, but then you determine the rate by Georgia-Pacific without looking at the base of those comparable licenses or whatever factors. Now, I think that trick works a lot of the time as a practical matter, but as Demetrius pointed out, I think Lucent you're not supposed to do that under Lucent, so it happens.
That's right. I mean, there's nothing in the Federal Circuit rule that mandates or require you to use Georgia-Pacific factors, but most district courts just feel comfortable using that analysis. But if you really look at what industry does is that when you put together bill of materials for particular products, IP is one line item. then, and that's how the business people can rationalize what it costs to produce products or services and provide them to consumers, and you realize certain profits. But when Georgia Pacific factors really do not take into realities of industry. Let me give one example. Like in Silicon Valley, people recognize the role that capital plays. Somebody need to risk his or her money to hire people, lease buildings, rent equipment to commercialize certain technology. Unless somebody is willing to do that, that technology will never see the light of the day. And that doesn't really change when you move to big tech companies. The tech companies need to put up the capitals necessary to make all this technology possible. And yet, especially in convergence devices or multi-component products, you have just too many patents, and sometimes you really don't understand what their contributions are. You never were aware of their patents. You never talk to them. I don't know whether they made any prototypes other than they have this paper called patent right to sue. So it's really difficult for business people to figure out what's going on here. Why is it my IP line item is about 100 times or 1,000 times more than anybody anticipated?
TJ.
Okay, so I've got a few Supreme Court cases. My fellow members managed to give me all of them except Newquest. But it's been a fairly quiet Supreme Court term, all things said, in patent law. So we have one major substantive patent law case, which is Helsing, and then we have a couple of cases on sovereign immunity, one of which is has already been granted and just got argued earlier this month, which was Cooper versus Allen, which is technically a copyright case, but it implicates the same clause and the same logic as sovereign immunity with respect to patent infringement. So I'm counting that as a patent case. There's also sovereign immunity as applied to IPRs, which the Federal Circuit decided in University of Minnesota versus LSI. That's pending on cert right now. Don't know whether they're going to grant it. If I was kind of forced to place money, I would say it's less likely than 50% in that there was a cert petition in St. Regis which dealt with tribal immunity, and the court denied that one. So whether they will grant state sovereign immunity is, at least I'm a little bit pessimistic. But starting with Helsing, which is on the kind of long-running question of whether secret sales count as prior art under Section 102. So the background here is that under metallizing engineering and kind of a group of related cases, the Federal Circuit developed a body of law that said secret sales and secret uses by the patent applicant count as prior art against the patent applicant. Secret uses and secret sales by third parties unrelated to the patent applicant do not count as prior art. That was the pre-AIA position, and kind of the statutory language both before and after the AIA said, right, prior art includes prior public use and placing the invention on sale more than 1 year prior to the effective filing date of the patent. So there's like slight modifications in the language between the pre and post AIA versions, but they are functionally identical. What the AIA also did is add a residual clause that says, all right, here are the categories of prior art. The invention is patented, described in a printed publication, on sale, in public use, or otherwise available to the public. And the argument, at least that was most strenuously pressed by Teva, which was the challenger to the patent, was that as a kind of matter of linguistic inference, when you say A, B, or otherwise C, it imports the characteristics of C into the category, or A and B fall within the broad genus of C. So if I say kind of tables, chairs, and other types of furniture, then it clarifies the ambiguity in the word table, which otherwise might exist, which is table could apply to a physical piece of furniture, or it could apply to a spreadsheet in digital form. But if it's a sentence that says tables, chairs, or other pieces of furniture, then obviously I'm only referring to the physical table. And so the argument is that to the extent that the word on sale is unclear about whether it encompasses secret sales, then on sale, in public use, or otherwise available to the public would implicitly define sales to encompass only public sales. Now, as a kind of pure linguistic argument, I think that has a lot of logic behind it, and that was the kind of, I think the PDO actually subscribed to that position going in, though they were overruled by the Solicitor General. But it went to the Supreme Court. Federal Circuit kind of abided by its prior precedent that says secret sales by the patentee counted. The facts of the case were Helsing held a patent on, I believe it is Eloxy, which is a drug to treat nausea arising from chemotherapy. So they have the patent on Eloxy. They entered into a contract to distribute distribute and market the drug with a distributor. I think it was MGI, if I remember correctly. And that was more than 1 year before they filed the eventual patent application. The agreement itself was public in the sense that Helsing disclosed in their securities filings the existence that they have a contract with MGI. They did not say what the contract encompassed or what the specific product that would be sold was or how it worked. So the only public information is the existence of the contract, and obviously that does not actually disclose the details of, for example, the chemical composition of the drug. And the question is, does that count as on sale when the sale and the disclosure surrounding the sale does not actually allow other people to know about the details of the invention or be able to replicate the invention or in fact do anything except just be aware of the existence of this contract. Federal Circuit said that sale still counted based on its prior precedent. Supreme Court affirms basically on the rationale that once there is a judicial construction of a term that is repeated in a later statute, the assumption is that Congress intends to incorporate the pre-existing judicial definition. And that is a very strong assumption unless there's kind of overwhelming evidence to the contrary. And even though there is some sporadic legislative history that tends to suggest that Congress in fact intended a public disclosure standard, it wasn't kind of overwhelming evidence to rebut the presumption of kind of carried forward meaning. The remaining question, I think, in Helsing is that as applied to the situation of a secret sale by the patentee or by the patent applicant who then becomes patentee and holding that those secret sales count as prior art, I can see why the court would be fairly comfortable kind of going, well, the statutory phrase itself, which is on sale, does not clearly say private or public. And so private secret sales count, and the word otherwise is not kind of so overwhelming. I'm less sure that the court will fully stick with this logic when the next case comes on the other side of the metallizing engineering kind of coin, which is a secret sale by a third party, which under the metallizing line of cases does not count as prior art. So the kind of language in Helsing is actually pretty, when the court is actually stating its kind of holding, it says that secret sales count. It actually did not say secret sales by the patent applicant count as prior art. The court actually just says secret sales count as prior art. But that's not actually a full description of the pre-AIA Federal Circuit standard, which was secret sales by the patent applicant count, but secret sales by third parties don't. And kind of correlatedly, secret uses by the patent applicant also count, even though the word public, in public use is actually explicitly in statute requiring public, while secret uses by third parties do not count. So if you use the logic of the Helsing Supreme Court opinion, which says that Congress is assumed to incorporate the prior case law, then you would probably say it would incorporate the metallizing distinction between first party and third party secret activity. We'll see how that goes in that there's the logic and then there's the formal statement of holding, which are not exactly 100% congruent with each other. But that's Helsing, and I think there is a residual question there, even though the issue of secret first-party sales, I think, is now settled.
Let me just break in there while you can warm up for the next case. If you were here last year, we had a pretty distinguished panel, save for me, discussing the Helsing case, including some Supreme Court advocates. And the only one who said that the case was going to confirm metallizing was actually Mark Lembley. And I gotta give it to Mark. He got this one right. You know, as usual, it's considered really more of a, I wasn't sure, I thought it'd be a statutory construction case, because that tends to be how the court focuses on a lot of patent cases. Just sort of, it's like a puzzle. It's just a linguistic trick, really. And there's not a lot of discussion of innovation policy. But here the court just went with precedent. And why were so many of us baffled? Did you think it was going this way? I thought it would be really bad for innovation policy, any result otherwise, but that's not where the court, how the court ran with it.
I'm not altogether surprised on the particular issue of a secret first-party sale that they stuck with metallizing. I mean, so the linguistic argument, it was fairly straightforward and purely as a matter of linguistic inference, fairly strong. But that was true also as in TC Heartland. if you just really parse the language of 1391C, it explicitly defined residence for purposes of the chapter. I mean, as a straightforward plain language argument, it was kind of impeccable.
Unbeatable, yeah,
It was
right.
just that it was overturning prior Supreme Court precedent with a kind of small linguistic detail, and the court goes, we're going to stick with the precedent. You need kind of much more blatant language to overturn a pre-existing judicial gloss. And I think that's the same thing as what happens in Helsing. But I would be much more hesitant in a secret use case, because the statute in 102B says in public use. And so there, kind of sticking with metallizing will require a lot more kind of going, we really don't care what Congress says as a linguistic matter, we stick with our precedent.
Are you going to do another case? We've got about 5 minutes here.
So moving to a completely different tack of sovereign immunity, we have kind of two slightly different sovereign immunity cases that one of which just got argued earlier this month. Cooper versus Allen is kind of factually fascinating. It's a copyright case where so North Carolina sponsors people to dig up Blackbeard the Pirate's flagship. And Allen is a filmmaker who films and takes photos of the work. He is not an employee of North Carolina. He is an independent agent, and so he obtains the copyright over the film and registers the copyright with the Copyright Office. North Carolina would like to use those images and films for kind of educational purposes in its museums and also on its online on its website. North Carolina initially just like posts the stuff, and Allen sues them for copyright infringement, and they settle out of court kind of with the agreement that North Carolina would stop. They stop and then they start again. And so Allen now sues North Carolina again. And North Carolina actually kind of to really stake out its position, passes a specific law that deems these particular copyrighted materials to be public records in North Carolina. And so there's a long history here, starting with a case called Seminole Tribes versus Florida, where the Supreme Court held that states have sovereign immunity against private suits in federal court. And that, at least in Seminole Tribes, Congress cannot abrogate the sovereign immunity through its ordinary Article 1 powers. So the particular power in Seminole Tribes was that Congress provided Indian tribes with a right of action against the states to force the states to negotiate on Indian gambling revenues. And the court in Seminole Tribes said that you can't force states to appear in federal court under the Indian Commerce Clause. The next case was a patent case where Congress passed Section 271H of Title 35, which explicitly said that for purposes of Section 271 infringement, whoever and persons who infringe include states and instrumentalities of states. The Supreme Court in a case called Florida Prepaid versus College Savings Bank said that 271H is unconstitutional. kind of based on authority of Seminole tribe saying that Congress does not have the authority to abrogate state sovereign immunity and force states to appear in federal court on for patent infringement. Sometime later, so at the time of Florida prepaid, the understanding was that Congress did not have any power to abrogate state sovereign immunity for states to appear in federal court. But then in a subsequent case where the bankruptcy statute actually allows the debtor's estate in bankruptcy to recover basically fraudulent transfers and preferential transfers. So one particular debtor tried to recover a preferential transfer that was actually made to a state government. And in that case called Katz, the Supreme Court actually kind of said, actually, now we're going to do a clause-by-clause analysis of Article 1, where some clauses of Article 1 of the Constitution authorize Congress to abrogate state sovereign immunity, and the bankruptcy power is one of them. So Congress can abrogate state sovereign immunity with respect to laws regarding bankruptcy. Then we have Cooper versus Allen, which Congress also passed kind of in tandem with the patent Section 271H, the Copyright Remedies Clarification Act, which said that states are subject to infringement liability in copyright. And it's kind of the same clause, virtually identical language, the same rationale. And so the Fourth Circuit said, based on Florida prepaid, the Copyright Remedies Clarification Act is unconstitutional. The argument basically is that after Katz, we now do a clause-by-clause analysis, and the court should kind of go back and find that the IP clause is one of those clauses that authorizes Congress to abrogate state sovereign immunity. Before the argument, I had thought I was pretty pessimistic about the petitioner's chances because I thought Florida Free Paid was directly on point, and kind of it doesn't get clearer than that. The oral argument actually went pretty badly for the state because the justices' questions focus mainly on the fact that if you really stick by Florida prepaid, then it seems that states could just kind of, so it would be a useful source of revenue for a state to start coming up with state-sponsored grokster, basically. Right, so we will undercut copyright holders by kind of selling discount versions of copyrighted movies and music on the state website as a revenue-raising measure. And the state's attorney did not have a fully convincing response to that, I don't think. So after the oral argument, I am now actually kind of going, Florida prepaid's days might be a bit numbered. So Regents versus LSI, or Regents and University of Minnesota versus LSI is a case that's pending on cert, but the Federal Circuit rendered the decision. It's a challenge to sovereign immunity with respect to IPRs on the logic that IPRs are kind of judicial proceedings that happen to be in an administrative agency, and state sovereign immunity applies to judicial proceedings and things that are like judicial proceedings. Federal Circuit basically said they look adversarial and judicative, but they are really a kind of action by the PTO that's controlled by the PTO. I'm not sure I'm fully convinced of that, but I also don't expect the court to actually take it up on cert. So,
TJ, thank you very much. Professor Olson.
Okay, thank you, Jay and Alex, and to Peter for putting this together and sponsoring and inviting me. I'm very happy to be here. So I know two things. I'm the only thing standing between you and Q&A, and more importantly, you and cocktails. So I'm going to keep that in mind and try to go through my cases very quickly. So I'm going to talk about Section 112 cases, specifically written description enablement, some recent very recent Federal Circuit cases. The headline is no big changes, but I think they show the continuing challenge that the court has in, especially doing written description. My perspective is that written description has an easier time doing a policing function when it comes to continuation claims that are, written 15 years later, trying to cover a competitor to the surprise of a competitor, than when it's used to challenge a genus claim that's otherwise enabled. I think that's the really hard part, and it's hard to know what the line drawing is. So I'm going to go through an enablement case, a written description case, and a case that combines the two. The first case I'll talk about is Enzo Life Sciences versus Roche. John Damaris represented the plaintiff in that case. John Damaris was my boss when I first started being a patent litigator, and he was here earlier, and so I spent some time earlier rereading the entire case and checking my characterizations because his side lost that case. And I was afraid he was going to relitigate it here, and I wanted to be ready because litigating against John Damaris is not an easy task. But now he's gone, so I can just say whatever I want. Ex parte. So what's going on in Enzo? Enzo shows that continuing challenge of enabling broad genus claims. More specifically, it shows the inherent danger of arguing non-obviousness based on the lack of understanding in the field of what species will work, how to get to the solution, and then turning around and making a fairly broad genus claim without teaching enough species. This is just a problem that we see repeatedly, and it results in invalidity for lack of enablement. The technology at issue is non-radioactive labeling. So Dr. David Ward in 1981 developed a non-radioactive probe by attaching a label to a polynucleotide via a chemical linker at a base position of nucleotide. You invented something cool when thereafter the positions at which he made these attachments were called the Ward positions, so named after him. Enzo picks up a license to this invention, files patents in 1982, and then files two more in 1995 that claim priority from the 82 application. This is not really this case nevertheless is not so much about policing continuation practice as really going back to that genus claims. So the panel just starts by saying the issue on appeal is not simply whether the specification enables labeling. The question is whether it enables creation of a labeled probe that is both hybridizable and detectable upon hybridization. So that's what the patent taught, that's what the patent claims. At issue claimed is they've got to hybridize without being degraded and be detectable. And the problem for the plaintiff, for the patentee, is that the patentee argued, Enzo himself, the CEO, said at the time it was thought aggressive chemical modification of nucleic acid would lead to the destruction of the content. Enzo's expert testified at the time of the invention, it was commonly thought the addition of a non-radioactive label to a nucleic acid sequence at positions other than the few known, the Ward positions, would interfere with hybridization. So they argued, hey, this was non-obvious, no one knew how to do this, and then they brought a genus claim that claims claims these markers at any position. at any position. Of course, it turns out there's only a much more limited species within that genus that will actually work at any position and that won't interfere with hybridization, and the court just says this wasn't adequately taught. So didn't teach enough examples. That's all I'm going to say about that because time's running. Second case I want to talk about is Nuvo Pharmaceuticals. So, and I should have said that first case was just decided in June of 2019 of this year. The next case was decided in May of 2019, so very close in time frame. Federal Circuit case, Nuvo Pharmaceuticals versus Dr. Reddy's Laboratories. The issue here is adequate written description. Case arises out of an ANDA litigation against Dr. Reddy's Labs and Mylan and various others. And the invention at issue is trying to solve that problem of how the non-steroidal anti-inflammatory drugs cause gastrointestinal problems. And so one way to deal with that is proton pump inhibitors can deal with that stomach acid. The problem, the prior art had tried to give both at the same time. The problem was that stomach acid would degrade the proton pump inhibitors before they could reach the small intestine where they would do their work. The prior art tried to fix this by coating the PPIs to resist stomach acid. This had some limited success because then the anti-inflammatory was degraded if it was released before the PPI could reduce stomach acid. So the solution here is a single pill that has a proton pump inhibitor that is partially coated but partially uncoated. So, and then there's a coating around the anti-inflammatory so that it doesn't, it's not released until the stomach acid reaches the correct level. So by partially coating the PPI, part of it's released in the stomach, other survives until it gets down to that small intestine, so it's more effective, and it also lowers that pH before the anti-inflammatory starts to work. So this is great. What's the problem? The issue is it doesn't disclose the therapeutic level of the uncoated PPI or the coated NSAID to achieve the claim. The issue is that a person with ordinary skill in the art, right, could probably figure out what those effective doses are once it's shown how to do this. The court doesn't go with enablement. Instead, the court decides this with written description, stops there, and says, you know, because there was a lack of understanding of how to do this, again, basically it was non-obvious. That in this case means there's a lack of written description because you didn't show full possession of the full scope, right? Whatever the therapeutic dosage levels would have been and with coatings would have been. So the district court, I'm sorry, the Federal Circuit scours the record because written description, unlike enablement, is a factual issue. And so it is reviewing the record to see if, to look for that deferential level of review, and nevertheless says that it's undisputed, there's no experimental data, and there's also no kind of teaching, and it was non-obvious, so this fails written description. It's interesting because if the court doesn't deal with this, but if enablement was met here, then the written description range here is probably not that large, right? People with skill in the art can probably pretty quickly figure out what's a therapeutic range. So written description is really stepping out here to do a job that is far more than enablement and far more than just kind of policing claim amendment. Last case I'll talk about, Idenix versus Gilead Sciences, decided last month, October 30th, 2019. Interesting case because here we do both both enablement and written description. Case arises out of litigation of Idenix's patent for a drug to treat hepatitis C. Gilead is the defendant, also has a drug to treat hepatitis C. The claim, which I won't read you the whole claim, but the claim is for a molecule, the patented molecule differs from the naturally occurring embodiments by the substitution of a methyl group at the 2 position on a certain sugar, or what the Federal Circuit calls the up position. So there's a substitution at 1 position. Gilead argues lack of enablement in written description because the specification did not provide guidance regarding the billions of possible molecules that could fall in the scope of the claim, because you can make substitutions at numerous points. And the way the claim is written is it makes a substitution at a certain point, but there can be lots of other molecules at other points. And in fact, Gilead's uses a fluorine, whereas the patentee uses OH in a relevant position. So the court looks at this, goes to jury trial, jury verdict for the plaintiff. The district court then granted a judgment as a matter of law that the patent was invalid for lack of enablement, but denied judgment of matter of law on written description, which is a factual issue. Federal Circuit takes it and says there's a lack of enablement but has to do a substantial evidence review because of the subsidiary factual issues, because this went to a jury. So the court goes through, looks at the WAN factors, looks at whether this enables someone to know which substitutions will work and which won't. Gilead has made a substitution that is not given as an example in the specification. Goes through and says, look, there's potentially billions, you haven't given us enough guidance. There seems to be good evidence in the record that this billions may have could shrink down to thousands or maybe even hundreds with someone with skill in the art. But nevertheless, the court says, whereas here practicing the full scope of the claims would have required excessive experimentation, even if routine patent's invalid for lack of enablement. Standard approach. Written description, the court then says, wait, there was also lack of written description. So overturns the jury's finding on that, notwithstanding the deferential review, goes through the record and says there's an absence of explicit disclosures of this species, an absence of a sufficient number of species to define the genus, and an absence of a structure or function to know the relationships that would disclose adequately how to get the relevant species. So just listing examples, but not explaining what makes them effective or why is not enough. Again, you've got to give enough guidance. And so says there's also a lack of written description. Interesting dissent here where Judge Newman says she basically wants to say that the claim construction was wrong even though it wasn't appealed. So Gilead's original claims construction was narrow and would have provided for non-infringement. District court ruled against Gilead, doesn't appeal that issue. Judge Newman nevertheless says we should have that narrower construction, and then in this case there'd be adequate written description and adequate enablement because we would narrow down the scope. And it just kind of shows this ongoing division on these kinds of issues between Judge Newman, often a dissent, and the rest of the Federal Circuit. And in fact, they're getting a little feisty about it. Footnote 3 of the majority says, the dissent makes an argument not advanced by Identix at trial or before us, reaches the opposite conclusion only by disregarding the district court's binding claim construction, ignoring the resulting stipulation of infringement, and analyzing a case that is not the one presented to us. So pretty hot treatment there in footnote 3. And so this kind of is ongoing there. But I think the takeaway is, you want to continue to be very careful with the genus claims. You want to make sure, and if you're a defendant, you want to, because in the interest of time, what I skipped over is defendant did a good job in one or both or two of these cases of raising these issues of, obviousness or lack of enablement. Always a good move to put the patentee in that bind. And if you have a genus claim and you're ready, you had to argue obviousness of people wouldn't have known the path, then if you make that broad genus claim, we're just seeing the court continues to say you're going to be out of luck on enablement and or written description.
David, thank you so much. Your talk, though, was extremely distressful to me because it means I'm going to have to keep teaching Ariad v. Lilly. And I was hoping it would just go away on its own force, but I'm not lucking out there. Well, patents don't last forever, and neither will this panel, so please join me and a round of applause for our panel. I'm going to indulge in a maudlin moment of farewell in just a second, but Alex has some comments first.
I have a very brief announcement. I'm going to, in your maudlin comments, I will let you do the thank yous. But I do want to do a special thank you to the Georgetown team that helped make today possible, including navigating some of our drama in delivery. Nia, Melanie Moisey, Waukesha Riddick, and Taylor Pegram were enormously helpful with all the logistics today. So thank you, team.
Alex, could I say one thing? I've been sitting up here and watching them set up the cocktails, which is part of why I was fast for you. But it's like a stealth ninja operation back there. When we have things set up at BC, if they're 30 feet away from the main crowd, it's like they think their sound doesn't travel or something. So this is amazing.
It's a great team. And my next thing is a PSA. You think you love our programming on patents, you will also love our programming on trademarks. On Tuesday, those of you who are familiar with the case Mittal v. Tam,
There's Joe.
round of applause for Mr. Mittal. We'll enjoy hearing, we have Simon Tam, the musician in that case, whose case went all the way to the Supreme Court in his effort to trademark the band name of his band, The Slants. We'll be here speaking about the case, his experience as an advocate, and some of the ramifications of that case for other groups as well. It's a lunch event on Tuesday, and it's open to the public. The information is at georgetowntech.org/TAM. It's also on our Twitter account, so you'll be able to see it there. But anyway, I hope you'll attend, Joe in particular. Thank you all.
And let me just say, thanks to each of you for attending. We can't do it without our 4 sponsors this year, Samsung, Verizon, Google, and Intel. So thanks to each of you for each of your enterprises for supporting us. It adds a lot to our patent community and our life of the school for the year, and it's really a high point for us. I hope it's something we can keep doing, and I hope that we'll see many of you next year for our 12th annual conference. We got a CERT grant, as many of you have probably learned, in Google v. Oracle, so we're going to learn all about software copyright, or maybe learn less, and then we'll be able to talk about its implications for patents. Now, as has already been alluded, maybe the food was late, but the drinks are timely. See, we're a Jesuit school. We have our priorities down correctly, I'm going to tell you. So I look forward to interacting with you in the back. Thank you again for coming. Cheers. Good job. Good job. Nice work, everybody.